to let me know. I think we're back in business. The only evidence we've heard so far, just to recap, is that the witness has confirmed that he's the Honourable Carvin Malone. Thank you very much.
Thank you. Hopefully we won't have any more technical glitches, Mr. Malone, but my first question is the one that I've put to all honourable and indeed former honourable members of the House of Assembly, and that is to ask them to begin by just giving an outline of your professional background before you entered politics.
Okay, great. I'll be grateful to do that. Carvin Malone, as I said before, schooled at the Willard Whitley Primary School, the BVI High School, and at Pace University in New York City. Management experiences includes that of Caribbean Basin Enterprises as the president and CEO of CB Engineering Associates of Virgin Islands Block Company and the family-owned business Malone Group Property Investment Limited and Island Block Corporation Limited. Quasi-government experience includes past member, well, I was a member of the 2007 Constitution Review Commission, a former board member of the finance chairman of the H. Stout Community College, a board member of the BVI Ports Authority, board member of the BVI Development Bank, board member of the Fiscal Advisory Committee back in 88 to 90, and a board member of the Land Development Control Authority. Also, in terms of social and community experiences, a past president of the Virgin Islands Party, four-time president of the, well, which is a record, of the Tortola Lions Club, past chairman of the BVI Hotel and Commerce Association in 83 to 86, past president of the BVI Amateur Basketball Association, the Lawn Tennis Association, and the vice president of the BVI Olympic Committee.
Thank you very much.
Thank you. You said that you were the past president of the Virgin Islands Party.
That's correct.
But is it right that you were selected as an at-large candidate for that party in the 2019 election?
That's correct.
And was that the first time that you stood for election?
That's correct.
Now, as an at-large territorial candidate, the way it works, as we understand from the evidence of other honourable members, is that each voter can vote for a representative in their district, and then they also have 4 votes to choose 4 people to sit as territorial representatives.
That's correct.
And essentially, it's at least for the at-large election, the top 4 win through. That's how it works, is it?
That's how it works, yes.
Yes. Now, according to the official results published on the BVI government's website, you in that election received 3,936 votes, which was 10.29% of the votes cast for territorial candidates. Does that accord with your recollection of your success at that election?
That's correct. Placed 4th in that.
And once elected and sworn into the House of Assembly, which was on the 12th of March 2019, were you immediately appointed to your ministerial post?
No, it goes through a particular process. So you have to first get elected, and then once the premier is actually sworn in, then it would be able to go through. But in the conduct of this particular session, I would just like to say, Commissioner, I wish to thank you for the opportunity to read into the record of this sitting my unqualified willingness to assist you in the discharge of your duty as outlined in your instrument of appointment dated 19th of January 2021. I wish, however, Commissioner, to advise that while it is your ultimate goal to fulfill the terms of reference as outlined in your appointment letter, it is, by contrast, my ultimate goal to fulfill my duty as a democratically elected representative of the Virgin Islands, part of which is to educate, to protect and defend the political, economic, and social advances gained by present and past leaders of the Virgin Islands or fathers and our forefathers, and to fulfill the needs and aspirations of the people of the Virgin Islands, generations past, present, and future. It is predicted that, though not originally envisaged, the final Commission of Inquiry report will serve as a blueprint for the UK's discharge of its obligation to prepare the Virgin Islands for future political advancement. As with all other administrative powers, it is what the United Nations or United Kingdom committed to and is obligated to provide under Resolution 66, subsection 1 of Chapter 11 of the Charter of the United Nations. This, I contend, would have been better served in a review of governance in the Virgin Islands, as opposed to this instrument of the Commission of Inquiry being conducted without disclosure, I might add, of the specifics represented to the United Kingdom officials by Governor Jasper, upon which it relies. These allegations were, however, issued in a statement in the House of Commons by the Secretary of State, Dominic Raab, on January 18th, 2021, and carried widely in the British press. I thank you very much for allowing me.
Is there any other statement that you want to make today?
No.
Good. Firstly, my remit is absolutely clear. I have terms of reference, and I propose to fulfill those terms of reference. No more, no less.
Thank you.
And secondly, today we're focusing upon register of interests. Mr. Rowett will ask you questions about members' interests, and it would be helpful to simply to respond to those questions. But thank you very much for your statement.
Thank you.
Mr. Rowett.
Mr. Malone, can I take you back to the question that I asked? Could you just confirm, if you can, and just try and answer that question? It's just, when were you actually appointed as Minister for Health and Social Development?
It was between the February 25th and when we were sworn in on March 12th. I'm not sure of the exact date.
So as of March 12th, that's when you began your role as a minister?
Yes.
You've remained in that role since?
That's correct.
As the Commissioner indicated to you a few moments ago, the focus of the current hearings is on interests, and that includes interests held by current as well as former members of the House of Assembly. Now, appreciate that you will have other demands on your time, so you may not be following the every minute of the COI's hearings. But if I hope you'll take this from me, the one of the pieces of evidence that the Commission has received, and it's undisputed, is that the current register of interest is not open to inspection by the public. A member of the public can't walk in off the street and say, I'd like to see it.
Well, the Act give circumstances under which it could be examined, but
yes,
but not an open walk in the registry.
But that is not one of the circumstances. You would have to get a court order in order to see it. Now, and there would have to be ongoing legal proceedings. But what is the purpose of my question is that we have been told, and the Commissioner has seen, a register of interest bill dated 2021, which intends to make the register of interest open to the public. Is that a measure that you would be supporting?
Well, in parts, because I think that if it's publicly accessible, then that is a measure, as I think the Premier had actually indicated, that will be a measure in which I could actually support in terms of having it publicly accessible.
With no disrespect to the Premier, what's important on this question is that we get your view. And I accept that this may be a matter of detail to be worked out. The question is directed to whether you, in principle, agree with the proposal that the register should be open to the public.
Well, it's open to the public in terms of having it accessible, yes.
Yes. And do you accept that that step improves government accountability and transparency?
That's correct.
Now, as we've established, you assumed office as an elected member to the House of Assembly on the 12th of March. 2006. I can take you to 2019. I've extended your time in the House of Assembly by several years, but I can take you to the Act if you need it. But I hope you'll take this from me, that what it places on you as a member of the House of Assembly is firstly a requirement, and this is under section 3,
Yes.
to provide a declaration of your interest on the date that you are sworn in. Do you accept that that's an obligation on you?
Yes.
And then that obligation arises again under section 3 on every subsequent anniversary of that date.
That's correct.
So in effect, for you as a new member to the House of Assembly as of 2019, there are 4 dates in your time before you have to stand for a re-election when you will have to submit a declaration on.
That's correct.
The other aspect of the Act to draw your attention to is section 7.
Mm-hmm.
Section 7 provides that if within 3 months of the due date, so the 23rd of March each year, you have not filed a declaration, then the Act says you are in breach and the registrar has to send a report to you about you to a standing committee.
After the 3 months period.
After the 3 months, yeah.
Yes,
If after 3 months, if by 3 months you have not filed your declaration, a report must follow.
That's correct.
And were these obligations that you were aware of on the day that you were sworn?
We were informed. I'm still trying to come to grip exactly in what manner we were informed, but yes. I know that we had from the date sworn and a 3-month window within which to file these.
Well, just to be clear, and again, I'll take you don't have a 3-month window to file it in. Your obligation is to file it on the 12th of March, 2019. Were you aware of that obligation on the day that you?
No, I was aware of a 3-month window to file it in.
And the Mr. Rowett's going to take to the statutory provision, I think, but I mean, perhaps, Mr. Rowett, you could take Mr. Malone first to section 112.
Yes.
This is where it derives from.
If you look at the bundles on the table in front of you, Honourable Malone, there should be a bundle which is headed Constitution and Legislation bundle. Do you have that?
It's one of the dark bundles in front of you, Mr. Malone, I think. Disclosure bundle, Malone, Constitution and Legislation bundle.
Yeah,
that's it. Thank you very much.
Now, if you go to the pages, numbers are in bold in the bottom right-hand corner of the page, and you'll see that number 1 on the index is the Virgin Islands Constitution Order 2007, yes. Which, as you indicated to the Commissioner a while ago, you were actually involved in the review process.
That's good.
That resulted in this constitution.
That's good.
Right. If you go to section 112 in the Constitution, which you will find at your page 53.
53. '86 and 53 will be right. 53 is here. Yes.
You should have, if we're on the same page, you'll see that there's a section headed registration of interests.
Section 112.
Section 112. Okay, good.
Excuse me. What section 1121 provides is there shall be for the Virgin Islands a register of interests, which shall be maintained by a registrar who shall be appointed and may be removed from office by the governor acting in his or her discretion. And then 2 provides it shall be the duty of any person to whom this section applies to declare to the registrar for entry in the register of interest, such interests, assets, incomes and liabilities of that person or of any person connected with him or her as may be prescribed by law. 3 provides a person shall make a declaration under subsection 2 upon assuming the functions of his or her office and at such intervals thereafter, being no longer than 12 months, as may be prescribed by law. And 4, this section applies to all members of the House of Assembly, including ministers, and the holders of such offices, except that of governor, as may be prescribed by law. And so if you look at subsection 1123 of the Constitution of 2007, what it makes clear there is that there is a constitutional obligation upon assuming the functions of your office to make a declaration. Do you follow that?
Yes.
And so if I take you, and what you then have to do is make declarations as prescribed by law thereafter.
Yes.
If I take you to page 59 in the bundle.
59.
Yes, being no longer than 12 months.
Yes. And so 59 is the Register of Interest Act 2006.
That's correct.
It has been amended on 2 occasions, one very recent one that we're all aware of, but the provision that I'm going to take you to has not been amended, and that's section 3 on page 61. Do you have that, Honourable Malone?
Yes.
3.1, a member shall make a declaration in the form set out in Schedule 1 within 30 days after this Act comes into force, and thereafter on the date on which he assumes the function of his office and on each subsequent anniversary of that date. So what section 3 does is it relates back to section 1123 that I showed you of the Constitution. And what it requires as a member an honourable member of the House of Assembly coming into office on the 12th of March 2019 is under A, on that date, reflecting what's in the Constitution, to declare interests on the very day that you're sworn into office. And then subsequently, what it's done at B is taken the interval to be the maximum allowed under the Constitution, which is 12 months. And so every 23rd of March until this 4th House of Assembly finishes its...
So every what, 23rd or 12th?
12th of March,
Yes.
forgive me.
The dates are getting...
Yes, no, I
Might be important.
it is important, but also I think I had in mind the date for the 2015 to 2019 House. But for you, so that I'm not confusing you, on the 12th of March 2019, you had an obligation under the Constitution and under the Act to make a declaration. And then subsequently, it's every year. So those are the first 2 immediate obligations on you. Do you accept that?
Well, yes, as I say, just as in everything that we do in law, there is a particular period. There's a 3-month period, and it shows that...
I'm sorry to interrupt, Mr. Malone, and I will let you complete what you want to say, if you still wish to say it. We haven't come to section 7 yet. We're just looking at section 112. Just look at section 112.
I know, but what actually constitutes a breach is important, isn't it?
Well, yes, looking at 112, the obligation is to make a declaration on the day you're sworn in. That's what 112 says. If you don't make a declaration, you are in breach of that obligation.
I'm not in breach of the Act. The Act shows me...
I'm sorry, we'll come to the Act. Let's look at the Constitution, because the Constitution's really quite important. Section 112 requires a member to make a declaration on the day he's sworn in, and thereafter at intervals of no more than 1 year. If the member fails to do that, do you accept that the member is in breach of the Constitution?
No, I do not accept they're in breach of the Constitution.
Right.
Okay.
Because it's actually prescribed in the Act, which is the Register Act, exactly the particular period. The Act does not say that if you don't do it on that specific date, that you're in breach of the Act.
So do you say that the Act overrides the Constitution?
I would not say that at all, because the Constitution allows the Act to actually state the particular period in which it can be done.
We're going to have legal submissions on this afternoon, Mr. Malone.
I have no doubt, yes. Okay, so then it'll be picking up there then. Yes.
That will be picked up
Okay,
there.
fine, good.
But your position is that if you are late If you're in breach of the obligation in section 112 and section 3, you're not in breach of the Constitution or the Act.
That's correct.
Thank you.
I'll take you to section 7.
Yes.
Which is your page 64 in that bundle. Do you have it?
64, right.
And it's 7A that we need to draw your attention to,
Yes.
which says, where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, the member shall be in breach of the provisions of this Act.
That's
and
correct.
the registrar shall, within 14 days of the knowledge of such breach, submit a report of such breach to the committee. And that's a standing select committee charged with consideration of the register of interest.
That's correct.
So at least in relation to section 7, do you accept that if you fail to make a declaration within a period of 3 months from the date in which it's due, you are in breach of the Act?
That's correct.
And do you accept that in those circumstances, when a registrar has knowledge of such breach, then that registrar is mandated to report to the Standing Select Committee?
That's correct.
Could we look at the dates on which you filed your declarations, please?
Okay.
That you can put the legislation bundle to one side and return to the bundle that relates to you. And it may be that you've already had a look at these papers. So if we go to 101 in that bundle, excuse me, if I explain what I'd like to do first of all, before we get into the detail
Yes.
of what you declared, I'd just like to look at the dates on which things were filed. Now, page 101, I'm going to suggest is your 2019 declaration. We can see that that's got your name and your constituency is recorded as territorial at large. Is that in your handwriting?
That is correct.
You can see that it's stamped by the registrar and she's written within the stamp the date 7th of May 2019.
That's correct.
If you go, please, Honourable Malone, to page 1, I think it's 113. It should be the last page of this form. You have attached, you've got an appendix to it, but
sure.
I don't need to go to that at the moment. But can you confirm that that carries your signature?
That is correct.
And it's dated, isn't it, the 30th of April 2019?
That's correct.
And so is that date written in your handwriting?
Yes.
Mm-hmm. Now, was the form sent to you by the registrar?
Yes.
And did she, in advance of the due date, which was 12th of March 2019, send you a letter notifying you of your obligation to file by that date?
That is what I'm trying to find, where those correspondence were. But it was given to me, and it was filled in at this time.
And you say you're trying to find those correspondence.
That very first one.
Right. Do you have some correspondence with the registrar?
Yes.
Amongst your papers?
See, as you have determined by all the witnesses, she was quite diligent in her work.
I think the one thing that all former and current members of the House of Assembly appear to be united on is that not only was she quite diligent, I think, to borrow the Honourable Fraser's word, she was assiduous
yes.
in notifying members of their obligation and also sending them reminder letters. Did you get correspondence from her of that sort?
That's correct.
And have you retained that correspondence?
My office has it, yes.
Right. So if the Commissioner considers it necessary, would you be willing to provide copies of that correspondence to the Commissioner?
Yeah, once it's necessary, because they were sent, and I was not exempt from those.
I'm sorry, you were not
exempt from having these notices sent to me.
Right. Thank you.
I mean, just to make it, I would find it useful because most witnesses well, the witnesses paint a general picture of, in your word, diligence on the registrar's part, both before the due date and thereafter in the case of what she termed delinquency, that is non-filing. But it would be useful if you could please
to have whatever correspondence she had sent as it relates to reminders.
Well, yes, or indeed a notice by her that the due date is coming up, because that's the evidence of other witnesses.
If I could ask Ms. Peaty to make a note of that, I think she's already doing it. So it's all correspondence between yourself and the registrar.
Sure.
Would be helpful.
No, thank you very much.
Now, 30th of April 2019, the date on which this declaration was due was the 12th of March 2019.
Mm-hmm.
So do you accept that you did not file by the date that's mandated under Section 3 of the Register
Well, I
of
didn't
Interest
file
Act
on the 12th
2006?
of March, but I filed on the 30th of April.
Yes, we can all see that, but do you accept that you did not file by the date that's mandated by Section 3 of the Act, which is the 12th of March 2019?
I'm not sure how many ways I can say this. I filed it on April 30th,
Yes.
2019.
So you accept you did not file by the date mandated under Section 3?
We have a 3-month period within to file, and we agreed that that will be taken up in legal arguments later.
Do you accept that you did not file by the date mandated under Section 112 of the Virgin Islands Constitution Order of 2007?
The Constitution allows for the Act to say the period in which you can do. So I accept that it was not filed on March 12th. It was filed on April 30th.
I'm sorry. I understand that. I've got the point.
Yes.
Mr. Mayor, thank you very much.
Okay.
Could you just help me on this? And I don't want you to make a legal submission because,
Right, because
those will be made by lawyers later on.
and they'll do it at 4:30 today.
And they'll do it whenever they do it. So I'm not asking for a legal submission, but you said that Section 112 allowed the Act to set a date by which the declaration was due. Can you? This is page 53 of the Constitution of the.
I would allow my lawyers to actually defend that particular situation.
Right. So you don't refer to any particular part of
No,
Section 112.
I read number 3 that you read from the Constitution just not too long ago, but any further submittals on this will be taken up by law.
Fine. No,
And if I'm wrong,
that's
well,
fine.
Yes.
Yeah. Thank you very much.
Thank you. If we go now to page 71 in the bundle that we were just looking at.
Sorry, which bundle now? This is Carvin Malone's bundle?
Yes.
Okay,
Yes.
good.
Thank you.
Yes.
Now, again, just to confirm that that's your name in your handwriting and your
That's correct.
constituency. We can both see that it's stamped Registrar of Interest. She has written 19th of April 2021 within the stamp, hasn't she? Do you
That's
see
correct.
that?
Yes.
But on top as well is in manuscript 2020 and then initialed. Is that in your handwriting?
That's correct.
And that's your initials?
That's correct.
So what you're saying is, if we're right, is that's your 2020 declaration?
That's correct.
Now, if you go, please, to page 91. Last page of that declaration. Does it carry your signature?
That is correct.
And is the date underneath that signature written in your hand?
That's correct.
And what date have you written?
March 8th, 2021.
Right. So if that's your 2020 declaration, it was due on the 12th of March 2020. So it was signed and returned to the registrar a year after, almost a year after it was due.
That's correct.
So you did not file by the 12th of March, did you?
No, I did not.
And on your interpretation of Section 7, which allows you suggested to the Commissioner a grace period of 3 months,
Yes.
you were way beyond the grace period, weren't you?
Yes, with reasons.
Well, it may assist you that the Attorney General, who not only acts in her own or has participant status in her own regard, but also acts on your behalf, when she gave evidence this time last week, confirmed that the Act doesn't offer a defence of reasonable excuses. So can I just, before we get into, I'll give you an opportunity to explain the circumstances, Mr. Malone. It's only fair to do that.
Yes, please. Thank you.
But the point is that leaving aside your interpretation of sections 3 and section 7,
yes,
you were in breach of the Act, weren't you?
Yes.
And you were in
by
breach,
virtue of this, yes.
You were in breach of the Constitution.
Well, the Constitution gives the Act, and if you're outside of this, then it could be deemed that.
Or do you consider yourself to have breached the Constitution?
Well, the Act itself and so forth. So in breach of the Constitution, I didn't go in that particular death. What I saw here in the Act, that by virtue of 7.3, I think it was, that I'll be in breach of the Act itself.
But we took you, and the Commissioner has taken you back to section 112.
I know. Again, that is a point I would rather my lawyers at this afternoon, that particular thing. We based on section 7 of the Act, I'm in breach of the Act. So
but you're not willing at this, you're not able at this moment
well, my lawyers
to say yes
will have to
or
then
no.
say
Well,
yes.
I appreciate the point that you're saying that your lawyers will make legal submissions. So
That's
pending
good.
those legal submissions,
Part, yes.
you are not able to say whether or not you are in breach of the Constitution.
Yeah, because I did not do any research and I did not have it as to whether or not the Constitution gives a particular determination as a reach to the breach of the Constitution. Breach of the Constitution is always a serious act. So the whole thing is that when it comes to breach of the Act, this particular declaration, chapter 7, there's no getting away from chapter 7.3, I think it was, as it relates to ways in which you can breach the.
But and I don't want to put words in your mouth. And the other thing I don't want to do is to rob you of the any legal submissions which are coming later.
That's correct, yes.
But from what I understand, you accept that a breach of the Constitution, when a right or an obligation is embedded in the Constitution, you accept that a breach of that obligation is more serious than the breach of some other act. And if you don't agree, do say so.
But no, because I wouldn't. Law has its fine words and so forth. Is, was, could, would, all has consequences. And so forth. But you accept, as it relates to the Act, the Registrar of Interest, it clearly states that if you don't file within a 3-month period, then you're in breach of the Act.
So your approach to filing your declarations was that you always, and this is your contemporaneous approach, that you always had a 3-month period in which to get it sorted out.
That's correct.
I see. And in this case,
if you can give me the chance for 2020,
yes,
I'll be prepared.
No, yes. I will. I'm just about to give you the chance.
Yes.
But the point is that in relation to 2020, as you accepted, you were very close to being almost a year late with it. Now, the reasons, you said you had reasons for why it was so late. Would you like to give those to the Commissioner?
Oh, please. Yeah, I'd like to thank you. The entire world was placed on, I think it was March 11th of 2020 in faced with a global pandemic. In the Virgin Islands, we started to look at the committees that would be charged with leading this particular pandemic, and the Ministry of Health, based on the Public Health Act of 1977, and 2 other acts of 2012, I think, and 2013. We had to basically go in and shepherd the country through this pandemic. And one of the first challenges was who was going to lead this. Was it going to be the governor's office under the Disaster Management Act, or was it going to be the Public Health Act? And once we got through that, and it was determined that the Public Health Act of 1977 would be the guiding force as it relates to this, we set on our ways. We had potential disruption of lives, livelihoods, and all attention focused on this. In fact, in 2020, there were 94 sittings of the particular cabinet. There were extraordinary sittings of the House that were actually conducted, and this was after the Health Emergency Operating Center itself had numerous sittings in order to come before cabinet in order to get this done. So not that there was any deliberate attempt to not to file this, but the fact is that these circumstances played a major part and cannot be overlooked in terms of what it is.
In terms of the pandemic, Ms. Malone, certainly we all understand the enormous effects that the pandemic had on the government here and everywhere else, but particularly here. The evidence so far is that the pandemic did not put the registrar off her stroke. She still reminded members of the House of their obligations under Section 3 and Section 7, and she still sent out a notice before the due date and reminders after the date. Is that your recollection too?
Well, two or three things. The notices, and it will be borne out as to whether or not any was sent between March and when they were due within that 90-day period, April, May, June. I'm not sure if any were received in that 90-day period. After we were able in June to begin to accept the first set of residents and belongers and nationals back into the country, then it began to open up a bit more, but it was not until August or September that we opened up more to work permit holders and to other persons, and not until December were we able to open it up to international travelers, and so forth. So there was a gradual approach in doing this, and all said, we had the task of making sure that all of the infrastructure for handling this pandemic was put in place. The swabbing centers, the laboratory efficiencies, the persons to handle the airport, to handle the different function.
I understand that. I understand the enormous strain that the pandemic put on the government and indeed the people here of the BVI, and also you as the Minister of Health. I understand all of that. But the narrow question is, did the registrar continue to send out reminders? And I think your answer is you don't know, which is...
No. My answer is she did continue, but I'm saying I do not know if they were sent between that March and that June period, and so forth. No. She did send it and so forth. I will bet you that she did not send it between the March and the June section, because the entire country was closed down in the first instance for it was a 3 to 4 week period, and then we lifted and we had to go back into it. And so
that's clear. Thank you.
I think also, to be fair to the registrar, there is actually no obligation on her in law to send you a single letter.
Well,
she's not. No, well, I mean, it's important.
Well, I'll say this.
She's not a witness here.
I'll say this.
And I think for the record, it's important to be clear that when she sent members notices, which on the evidence that has been shown, it does follow that she sent notices before the due dates to everyone. And she did that every year to everyone.
Yes.
And that once they had missed that date, she would send them reminders. She did not send them reminders talking of a grace period, but she would just repeatedly send people reminders asking them to make good their default. And would you accept, therefore, that it's likely that during the course of your time as a member of the House of Assembly, you have received notices from the registrar and you have received reminders from the registrar.
My understanding of Mr. Malone's answer is that he does accept that as a general proposition, but not necessarily for the period from March 2020 for 3 months.
Yes.
Is that correct?
Yes.
Thank you.
And given the extraordinary circumstances of a global pandemic, of which the world have not seen, save for 1921 maybe.
Yeah, no, we were just checking on the reminders that the registrar had sent.
Yes.
If you could go, please. Do you have a bundle in front of you, which I think might be headed something like Governor's Disclosure?
Disclosure from Governor.
Yeah. Now, I'm going to take you to some letters which are not addressed to you, but are addressed to other honourable members. And I'd be grateful if you wouldn't read out the name of the honourable member. But if you go in that, first of all, to page 48, you should have a letter headed at the top, 10th of March 2020.
That's correct.
And if you keep your thumb at that page, please,
Yes.
Honourable Malone, and just flag up page 75 in the bundle. You have that?
Yes.
75, and that's a day also dated the 10th of March 2020, addressed to a different member of the House of Assembly.
Sure.
And now neither of them is you, but they are both in exactly the same words.
Yes.
And they say, on the 12th of March, you took an oath and assumed the functions of your office as a member of the House of Assembly. The 12th of March 2020 marks the first anniversary as a member of the 4th House of Assembly of the Virgin Islands. According to Section 3 of the Register of Interests Act 2006, hereunder set out for your ready reference, a member is required to file a declaration of interest on each subsequent anniversary of taking office. And the registrar then sets out Section 3. The letter continues, enclosed herewith is a declaration form for your completion and return to this office at your earliest, bearing in mind that the declaration is due on 12th of March 2020.
Yes.
And she then continues to give the each honourable member a date at which it should arrive at her office because of administrative purposes. So I would suggest that on those two identical letters, it's likely that the registrar sent the same letter on the 10th of March to every member of the House of Assembly.
Well, it goes to show exactly what I said, because the declaration of the global pandemic, and when we ourselves had to, for the sake of life, had to close the country, that there was between that particular period on which the pandemic was declared, when we had to close the borders, close the country, and go into 24 hours lockdown, that it was due on the 12th. This was sent, well, it was dated at least for the 10th of March. When it was sent will be a different story, but it was dated for the 10th of March. And just like how you have guided me to when it was dated versus when it was stamped, it could be a different issue. Yes. I'm not sure. So I'm not going to argue the point, but we cannot take lightly the fact that the entire country had to be closed as a result of saving lives and livelihoods.
Can I come back to you on that? If you just turn over, before we finish, if you turn over to page 49 in that bundle, a letter from the 3rd of June 2020 addressed to another honourable member. Please don't say the name, but reminding that member that they have declarations of interest that are overdue. And if you go to page 77, another reminder, as the one we just showed you, again dated the 3rd of June 2020, and again reminding a different honourable member of that they were overdue with their declarations. And if you leaf through, we don't need to read it out, but 78, 79, the registrar is sending letters reminding honourable members of their obligations. You said the 11th of March 2020 was the date on which there was a lockdown.
Yeah, I'm trying to remember. It's 11th or 15th, but
Well,
it was mid-March. Yes.
Well, can I just press you a little bit about that, because other honourable members have mentioned lockdowns but could not assist with the precise date as to when the BVI was first locked down.
Well, a Google search will actually help that, but I think it was, whether it was the 11th or 15th, before the evening is out, we'll get the exact date.
Thank you.
That would be helpful, because in fact a Google search didn't reveal it. So,
okay, fine. I have it, but I did not remember.
If you could,
it's a date I'll rather forget, but
well, if you could, perhaps in a letter to the Commissioner, just set out the date on which the first lockdown was imposed and when it was relaxed or removed.
May I ask a question?
Yes.
Yes. The two sets of dates that you referred me to, this is in the bundle coming from the disclosure from the governor. Did members agree that they had received these?
I think generally the picture is that members fully accepted and often proffered the fact that Mrs. Romney-Varlak sent reminders throughout the year,
So too do I.
as usual.
Yes, but as relates to these two, did they specifically indicate that they had received these two?
Well, I don't want to. I think it's best not to comment on what their evidence is recorded on the transcript. I think the Commissioner's point is that the reason I wanted to take you to those was not in relation to the particular conduct of those members, but rather about the approach that they're illustrative of the approach that the registrar took even during the pandemic. Can I move on to, before we finish, your latest declaration, please, which you was kindly provided by your legal representatives this morning, and that's your 2021 declaration, which is not going to be in the bundle, it's going to be loose leaf.
Sure.
It's there on the right. So let's just get the dates of that into the record. Again, front page is your name and your constituency in your hand, isn't it?
Yes, that's correct.
The registrar has stamped it, and the date is her handwritten date of receipt is a little difficult the month is difficult to decipher, but it might be 19th of April 2021. But certainly what you've written at the top and initialed is the date 2021, haven't you?
That's correct.
Now, if you go to the last page, the last page of the document, not your attachment, the date that carries your signature.
Yes.
Do you have that?
Yes.
Confirm your signature, please. That's your signature.
Yes, that is my signature, and the date on it is March 8th.
So you filed your 2021 declaration at the same time as you filed your 2020?
That's correct.
Now, taking your 2020 declaration as the example, I think your threshold of acceptance is that that's in breach of Section 7, isn't it?
So 2020, you mean?
Yes.
Yes.
That's the one thing we can agree on.
That's correct.
That it's in breach of Section 7.
Well, for the 5th time, yes.
Yes. Well, for the first time then, has a report been written about you to the Standing Select Committee?
Well, I'm not a member of that committee, so I can't say or actually affirm or deny.
Would you expect the registrar to write a report about you to the Standing
Based on
Select
the
Committee?
act and so forth,
And there's no reason that you can dispute. I mean, she would be perfectly justified to write a report about you to the Standing Select Committee, wouldn't she?
Well, we kept her safe enough to be able to.
I'm sorry?
We kept her safe enough to be able to write the report.
Sure, she's very grateful of that.
That's right. Yeah.
Do you know who chairs that committee?
Yeah. Well, members had indicated the chairman of that particular committee, and I think the Honourable Premier Andre Foy.
When did you find out that the Honourable Premier chairs that committee?
Well, sometime in 2019, there were a series of select committees of the House, and membership were appointed for the select committees.
Was that when you found out that the Honourable Andrew Foy chaired that committee, or have you found that out more recently?
Well, they were all named, they were all given to us, and at the end of the day, I was more concerned with the ones I chaired and were a member of.
Appreciate the point. My question is not a trick one. When did you find out that the Honourable Andrew Foy chaired the select
2020
committee?
was extraordinary, 2019 was extraordinary, but it need not come into this record and so forth. He is the chair of it.
Well, did you find out that he was the chair of it in 2019?
Well, when it was actually established.
That's when you found out that he was the chair of the committee.
Whether it's September, October, I can't say which month, but when they were named, the Service Committee, the Register of Interest Committee, the Youth Parliament Committee, the Standing Orders Committee, all these committees.
You will have known when it was established. But when the Select Committee was established in 2019, you would have known its constitution.
Well, yeah, because we were all actually made members, some chairpersons, some members of different committees.
Go to page 8 in the bundle, the Carvin Malone bundle, please.
Carvin Malone, page 8.
This is a letter, 19th of February 2021. Do you have that?
Yes.
And it's addressed to you at the House of Assembly. And it concerns the Register of Interests Act 2006 and declarations under that Act. If you go, please, to page 9.
Page 9.
You're asked there a number of questions. The first is the date and content of each declarations of interest you've made at any time during your tenure as a member. The second is, irrespective of any such declarations you may have made, the information and documents that
Which paragraph are you reading from, sir?
If you see, you should have at page 9 a series of numbered items on the page. Do you have those? That's what I'm reading out to you. So there were 3 requests made in that letter, and I'm just going to summarize them. So the first request is to give to the Commissioner the date and content of each declaration of interest you have made at any time during your tenure as a member pursuant to your obligations to make such declarations under the 2006 Act. Do you have that?
Yes.
The second request was, irrespective of any such declarations you may have made, the information and documents that you would provide in such a declaration of interest. And the third request was, if during your period of appointment as a member, you failed at any time to comply with your obligation to make such a declaration pursuant to section 3.1, in respect of each such failure, a full explanation as to why you did not make such declaration and what, if any, sanction, admonition, direction, or other adverse consequence resulted. Now, your responses to that is found at page 11. And you wrote, the Commissioner had asked for a reply by the 26th of February 2021. You wrote on the 11th of March 2021, acknowledging receipt of the letter. And you then continue, my office seeks to support the Commission of Inquiry by providing the necessary information / documents that will allow a thorough and fair inquiry. Please accept my apologies for the delay in acknowledging receipt of the above mentioned correspondence. What didn't accompany the letter was the necessary information and documents to allow a thorough and fair inquiry. Was there a reason you didn't feel able to give any information to the Commissioner at that point in time?
Not that I would like to offer any excuse on that and so forth. It clearly was one in which whatever details were given, I was of the opinion that the response unit may have may have actually dealt with it, maybe, I'm not sure.
Sorry,
as to the exact.
I'm sorry to cut across you. Finish your answer and then I'll ask one question.
Yes, so, no, there is none that I can remember now as to exactly when this, in terms of the reasons for not giving the particular declaration. However, the response unit was charged to it, looking at the, taking the information and then doing this, because I remember one of the amendments to the act was to allow you to get all of the details that we have.
That's quite right, but it didn't require amendment of the act for you to explain to the commissioner that you missed your 2020 deadline by almost a year, did it?
No.
And it didn't require an amendment of the Act by the House of Assembly for you to say, well, actually, in answer to the request number 2, here is what I would provide to the the registrar.
No.
Right. Well, can we move on and just?
I'm sorry, Mr. Howard. When you said that the IOU was charged to respond, did you think that they would respond or might respond to this?
Well, yeah, that was probably my particular impression. I have no specific response now as to exactly why that section of it and so forth. I know that we were quite keen on making sure that whatever documents you had unrestricted would be, could be actually furnished and so forth. I could have gone to length in terms of the very same item in terms of the pandemic and how we had done it, because it was a critical time frame for 2020 that we were made upon. So the full explanation could have been exhaustive.
I just wanted to know what part you thought that the IOU might play, and you've explained.
No, what I'm saying is that as it relates to that and so forth, it is one in which we could have explained, because there's no make-up issues in there. It was one in which, not as an excuse, but the fact is that we were in the trials of a pandemic, of which 2020 was doing it. You see, I was always going to be keen in terms of following the particular guidelines, because this moment had to come. So we had to make sure that we followed whatever it is that needed to be done.
Okay, if you turn to page 12, please. On the 10th of March 2021, you were written to again by the Commission. And if you look at the second paragraph, please, Mr. Malone, what it reads is that the Commission has instructed me to write to you as a member of the House of Assembly of the British Virgin Islands with an open invitation to provide him with any information and or documentation that you have in your control or possession, which you consider might be relevant to COI's terms of reference. Alternatively, if you consider you do not hold any such information and or documentation, the Commissioner would invite you to indicate the same. And now, if you turn to page 14, please. Your response to that letter is dated the 11th of March 2021. Excuse me. And so it's written on the same day as you answered the 19th February letter. But what you write here is, I hereby acknowledge receipt of your letter dated 10th of March 2021 in regards to the above subject. My office seeks to support the Commission of Inquiry by providing the necessary information and documents that will allow a thorough and fair inquiry. Now, it was not accompanied by any information or documentation. What necessary information and documents did you have in mind at that point in time that your office would be providing?
Well, as it relates to, was this in terms of the register of interest that,
yes,
that you're writing?
Can I think I want to be fair to you. What I should draw your attention to is also a letter you wrote on the 15th, at page 15. So you then wrote in subsequent answer to on the 12th of May 2021, referring back to that letter I just showed you of the 10th of March, and said that you do not hold any information and or documentation that is in my control or possession, which might be relevant to the Commission of Inquiry's terms of reference.
Yeah.
Now, so I think I should be more specific in my question. You've referred now to correspondence that you hold with the Registrar of Interests and from the Registrar of Interests. Why didn't you think that that might be relevant to the Commissioner?
You mean in terms of her notices?
Yes.
Well, in terms of the notices and so forth, I said one of the, as to the exact timing, the notices sent out were sent out to every member, so I'm not sure. I was not exempt from it, so if I erred in terms of not sending or referring the notices sent to the Commissioner, well, I accept that as one in which I erred.
So there wasn't any particular reason you decided not to provide it at that time?
At all.
Well, could I take you to, it's moving on to a slightly different topic. I'll take you to one of the forms and what you completed in the form. Can I also give you some context? This is an area
Which page will be?
We're going to page 71 in the same bundle. But just to assist you, what my questions are primarily directed towards is your understanding as a member of the House of Assembly of what you were exactly expected to provide in terms of information and interests. So we can stick to, I hope, one form for much of the time. And what we have is your 2020 form, which is in the bundle at page 71. Now, I've asked this question of more than one witness, but can you see that there's a preamble to the form which says, the main purpose of the Register of Interest is to provide information of any pecuniary interest or other material benefit which a member receives, which might reasonably be thought by others to influence his or her actions, speeches, or votes in the House of Assembly, or actions taken in his or her capacity as a member.
Yes.
Do you have it? You're there, are you? And then you're referred to explanatory notes in each section of the form. Now, you filled in the form 3 times.
Yes.
What did you understand to be the purpose of the form? What were you being actually asked to do as a member of the House of Assembly?
Well, for myself and any member of my close family, my wife, my children, my child.
I think you're going back to the letters. You can put that bundle to one side.
No, well, I want to come back to it because I said.
Well, that's a letter addressed not to you. Well, if
I know, but I'm saying is one of this was actually addressed to me also, and it'll be part of my bundle.
Yes, it's part of information you have yet to provide to the Commissioner, and that's why we can't ask you about it. So let's go to page 71 and ask about your form and what you understood it to be. Now, you said your wife and child, but can you clarify what were you being asked to provide in terms of information?
Well, information, it was actually in the guideline sent to us by the registrar. So she had asked for information concerning your immediate family, and in the guidelines, she had asked over and over for information as relates to myself and my spouse or my children.
Now, you referred to the guideline. Go to page 83, please. And this is part of the form. It's the section on overseas visits. We don't need to focus on that. What I want to draw your attention to is the explanatory note at the bottom, because you see it refers to a guidance pamphlet on registration and declarations of members' interests. Do you have that?
Yes.
Is that what you're referring to when you speak of guidelines?
No, I'm referring to the letter that she had sent to us.
Okay, so before we leave that topic, in your time as a member of the House of Assembly, have you ever been given a guidance pamphlet?
Not that I remember.
In completing your form, have you ever felt that you needed to go and get advice from anyone about what was required to be put on the form?
Not particularly, no.
Now, you say that there were guidelines in letters from the registrar.
That's correct.
Is that in letters that you still hold in your office?
Yeah, those are some that will be
Right.
guidelines in terms of the, she was specific, as was in the letters that you showed me,
Right.
as to exactly what she expected.
So from your recollection, I appreciate you do not have the correspondence in front of you at the moment,
Yes.
so we need to be careful. But from your recollection, doing the best that you can, were her letters of a similar sort to the ones that I showed you?
Yes.
The ones addressed to you?
Yes.
And that's what you took to be guidelines?
Yes.
Now, you say wife and child. Were you under the impression that you had to declare interests that belong to yourself, your wife, and adult children, or dependent
adult child,
children? Adult child, I see. Now, if you go, please, let's go back to page 71, please, Mr. Malone, and just go to number 2. Now, in each of your forms, what you've done is annexed an attachment that gives the details that answers the question.
Sure.
And so you've cross-referred to the annex. And so when one tracks across your forms, you've adopted a standard approach. But again, keeping it general, and this is perhaps a slightly cheeky question, but I'm going to draw on your expertise given what you have declared. Can you help the Commissioner with this? What do you understand to be the difference between a company and a DBA?
Well, the incorporated company, the limited liability companies that we had here, would be those in terms of a company. If you're doing DBA, you can trade with a license, and it might well be one time when it was active, we had a group of companies called Malone Group Property Investment Limited, but we had a DBA in terms of Virgin Holidays that took the bookings and actually administered and so forth. So the substantive company, quote unquote, was Malone Group Property Investments Limited. The DBA was another.
And in terms of how you would describe yourself if you are operating a DBA as opposed to a company, is there any requirement you distinguish yourself? Could I set up a DBA tomorrow, or get myself a trade license and start calling myself a director?
Well, there are persons who they may not have incorporated the company. They have a trade license in their name, and doing this, Carvin Malone, the best in the game. DBA, Carvin Malone, the best in the game.
Was that one of your DBAs?
No.
Right.
Well, I could give you one of my companies, but it's
Mr. Malone that it wasn't. But again, just grappling with this. Incorporated company, we understand that, and incorporated companies have directors. DBA is linked trade licenses, and are these? And I assume that more than one person can hold the license. But when they hold the license, do you have directors of a DBA?
Not necessarily, no, because they're not required, as far as I understand.
So when you say not necessarily, again, this is, as Mr. Rawat said, really just to help us with other evidence we've heard from other people.
Fine, yeah, because
does that mean they could have directors, or could have people who call themselves directors?
Not that I am informed.
Right. Yeah. Okay. So companies, directors, individuals, DBAs trading under a trade name.
Yeah, because you see, you have partnerships. You can have a partnership.
Yes.
You can have a registered limited liability company.
Yes.
And have a cap. I think it's cap what? 34. Cap. What is it? 35.
Anyway, all sorts of different.
Yes.
Entities which can trade.
Yes.
But you have directors for incorporated companies, and for the rest, do you have directors? Might you have directors?
Well, not in the legal sense of the word, would you? Because at the end of the day, the directors is governed by the Companies Act.
Correct. Okay, I understand that. And again, using your sort of expertise, do people in fact call themselves directors sometimes when it's a DBA?
Well, yes.
They might.
Yes,
yeah.
and this is why I said earlier that all depends on which word you use legally.
Yes.
It could mean something else.
No, that's very helpful. Thank you. Yes.
Thank you. Now, if I, again, the focus of my questions tonight is just on what when you read the form and you're thinking, right, what information do I have to give? It's targeted to that, right? So
Yes.
what was expected? Did you believe was expected of you?
Yes.
Now, to give context, you set paragraph 1, which Commissioner, for your note, will be at 73.
Of the same page, 71.
Yeah,
Fine,
go to 73 now.
73.
So 73 is the first paragraph that you're expected to complete, which is directorships, and then the second one is remuneration, in effect, at 75. And we'll go to the attachment in a moment, and you've set that all out in detail. But if you look at 3, what 3 says is, does any of the paid employment registered in categories 1, which is directorship, and 2.
No, sorry. Which page are you looking at?
77.
Okay, fine.
Does any of the paid employment registered in categories 1 and 2, that's directorships and remuneration, entail the provision to clients of services which depend essentially upon or arise out of your position of member of the House of Assembly? And you're directed to the notes. Now, what did you think you were expected? What information did you think you were expected to give under this heading?
Okay, does any of the paid employment registered in categories 1 and 2 entail the provisions to clients of services which depend essentially upon or arise out of your position as a member of the House of Assembly? That's no before, that's no during, and no after.
Yeah, that's your answer.
Yes.
I get that's your answer.
Yes.
The point is, what did you understand the question to be directed to?
Well, I read nothing more of it than what's here in terms of entail the provision to clients of services which depend essentially upon or rising out of your position as a member of the House of Assembly. Do I get any clients as a result of me being a member of the House of Assembly? The answer is no.
Right, but is that what you thought it was supposed to be? That you were supposed to, that if
well, I'm reading it now, but this is not a written script I'm giving you. I said no before, no during, and no after.
I'm not at all disputing your answer.
Yes.
I accept that you wrote no. I'm not going to go behind the fact that you wrote no.
Right.
What I'm directing my question to is, what did you understand you were supposed to give? I mean, you might help by just reading note 1. Services covered by this category include action connected with any parliamentary proceedings, sponsoring meetings or functions in the House of Assembly, building or offices, making representations to ministers, fellow members or public servants, accompanying delegations to ministers, and the provision of advice on parliamentary and public affairs.
Okay, so you're saying whether or not I was seeking to get clients as a result of me being a member. The answer is no. I was not seeking any particular thing. So the answer is no.
Okay, all right. Well, let me.
In my go ahead.
Honourable Malone, I just want to make absolutely clear, this is not about whether you gave the right or the wrong answer.
No, I know, yeah.
It's what did you understand?
I know, but you asked me 3 times, so I'm saying is that...
No, and it's only because members have given different interpretations of what is intended by this, but you've given yours, and you've given your answer, and that's the sum of what you considered was covered by the scope of this paragraph. Thank you.
Let's go to paragraph 4 then, at the top. You see it, page 79, please.
79, okay, fine.
Again, you've answered no to this question, which is about sponsorship. And to try and shorten it, I'm not in any way disputing the accuracy of your answer. But what the 4A asks you is, did you benefit from any sponsorship before election where, to your knowledge, the financial support in any case exceeded in aggregate 2,500? And if you go to 2 at the bottom, note 2, You should register money given to you by your election campaign committee and money spent by your election campaign committee in connection with your election with your permission. Now, this is a question that I have put to more than one member, and it is a question that has elicited different responses. And so I want to ask you what your interpretation of this paragraph was. What did you take to be meant by sponsorship before election?
Well, if any group or persons or individuals were to give more than the $2,500, then you have to list it, basically, is what I take from it.
So, and you say give you more than 2,500. Are you including within sponsorship financial donations?
Yeah, there's a thin line between donation and sponsorship. I'm not sure. And I guess this is where the form may have to be more explanatory as opposed to sponsorship and donation.
You said there's a thin line between the two. Can you elaborate on that? What do you see as the difference, if any, between sponsorship and donation?
Well, I don't know if I see any, because sponsorship was interpreted here as actually donations. I'm not sure. I'm not sure if in my experience, the donation, because the British and American wording between sponsorship and donations could well change. But as far as I'm concerned, donation, sponsorship is basically the same thing.
So you approached it on that basis, did
Yes.
you? So the way it would work is if 10 people gave you $2,000, you wouldn't have to declare that. But if one person gave you $20,000, you would have to declare it. Now, you've answered, as we say, no to that. You've also answered to B, no. And B is, do you benefit from any form of sponsorship or financial or material support as a member of the House of Assembly? Now, what did you understand that you were being asked to furnish in terms of information in answer to question 4B?
Do I benefit from any form of, call it gifts if you want, donations if you want, or financial or monetary support as a member of the House of Assembly? Yes or no? Whether it's gift, sponsorship, donations, or whatever it is.
But did you appreciate that if, for example, somebody says, I'm going to give you free use of an office so that you can fulfill your duties as an elected representative, that's something that you would have to declare?
Yeah, the value of it.
Yes. And if you yourself, let's say that you are a successful businessman who operates an office, use that office for House of Assembly business, is that something you feel that you would have to declare?
Well, is there a line between my duty as a at-large representative and as a minister? The answer is yes. And if I have to use the office, somebody give me as a gift, I'll have to declare it. But it seems to work only one way. Because,
Why is that?
well, if somebody give me a gift to conduct government business, what if I give the government a gift to conduct their business?
That might put you in an advantageous position in relation to other businesses that you may own. And so wouldn't that be something that you might have to declare? Well,
I may then be in breach of that, because at the end of the day, say for instance, down at the R&R Malone complex, I've given them free service to run the vaccines. So I'll have to make sure I declare that and have.
I mean, it's not, again, not a criticism of you. It's actually about the form and whether the forms.
No, I'm just actually being forthright in terms of.
But the questions are directed to this, and you're not the other honourable members have made this point to the Commissioner, that for them, some of the wording of the form has created doubt and uncertainty as to what is actually required to be given.
Well, in that one there, and so forth, because I don't consider myself sponsoring the government.
Yes.
But,
so from you would not yourself reading this think to yourself that if, to borrow your words, I am giving a gift to the government, that you would need to declare it on this form?
Not on this one, no.
That's helpful, thank you. Now, can I jump to your paragraph 8? For the record, Commissioner, the Honourable Malone answered no to paragraphs 5, 6 and 7.
Yes.
But at 8, you have declared, that's when you're asked, it's page 87, please.
Yes.
You're asked to declare your land.
Yes.
Though I think on this form, you may not have ticked yes or no, but you've given the details that follow. And so, for example, you're asked at the top, do you have any land other than any home used solely for the personal residential purpose of you or your family? Now, one of the pieces of land you declare is in McNamara, and you declare it as a residence. Is that your actual residence?
That's correct.
So you actually went further than required in that you gave more information than
Just
you're
in
required.
case they weren't clear what they wanted.
And you say just in case they weren't clear.
The form wasn't clear as to what it really wanted.
And what about the opening line of paragraph 8 creates that doubt in your mind?
Please indicate whether the nature of the land, estate, residential, rented, and give it.
No, I think above that, Mr. Malone.
Yeah, they have any land other than any home used solely for the personal residence purpose of the family. At times, I did in fact lease out my home, and I wanted to make sure that we were clear about that and so forth. So there were times when I was moving back and forth. So the house was used in earlier years. So I wanted to make sure that it was down there.
I see, but in the time that you have been a member of the House of Assembly, your house hasn't been leased.
No.
Right. But what you don't, so you understand from the first line that you don't have to declare your home.
Yes.
But what you wanted to do, to be sure, was to declare your home because in the past, before you became a member of the House of Assembly, you had leased it on occasion.
Sure.
Fine. Now, there are 2 other properties that you mentioned, a residential condo, Admiralty Estate Complex, and a residential condo in the US. Yep.
Yes.
Now, are those rental properties?
Yes.
And did you read this paragraph and this question as not being limited to land in the BVI?
Well, for me, yes, and so forth. I wanted to make sure because, as I say, there was nothing here to not disclose. So I wanted to make sure it is in my wife and I name, and I wanted to make sure it was in.
Now, and that's the full extent of your land holdings, is it? A home and then those 2 residential condos.
I might say, in terms of my parents are both now deceased, and their will is still being finished. So I, as an executor, one of the dual executors, may have it registered in my name for the estate of. So those were not listed here. So if
I see. So right, yeah, because, and but that's a property which you're dealing with as an executor of a will.
Yeah.
And in terms of shareholding, we'll come back to that in a moment, if I may. Can I take you to paragraph 10 at page 91? It's headed miscellaneous, and it reads, if bearing in mind the definition of purpose set out in the introduction to this form, that's a reference to the preamble I showed you a while ago. And then it continues, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. Now you've said they're not applicable. So again, taking you away from your answer, and not interrogating you about your answer, but I just want to know, ask you to help the Commissioner with this. When you look at this form, what do you understand by this paragraph?
Do I have any additional shares? Do I have any additional land? Do I have any additional assets of which could be placed here? What what I must have failed to do is to put the extent of the loans I have. Maybe that would have been something in there, but it doesn't. The answer to that still remains not applicable, as far as my understanding.
Can I break down your answer a little bit? The first is, when I asked for your answer, you said, do I have any additional land? Do I have any additional shares? Do you think that this question is directed against you, or is it directed against you and your family?
Me and my immediate family, yes.
And do you define immediate family as your spouse and child?
Yes, that's 8 times.
Now, you then said, do I have to declare loans? I'm not asking you to tell us about your loans now, if you don't mind, but now that you've raised that, as you've been looking at this form with us today, is that something that in your mind now creates some ambiguity? Are you just now thinking, well, actually, you know, I'm not clear whether they would require me to declare loans?
Well, the fact is that like any other form that you have is, you know, the balance sheet, because I speak of it from accountant, I guess, their assets and they're actually either you did them cash, you did them by loans, you did them by gifts, you did them by other stuff and so forth. So some of this, in terms of enhancing the form, maybe there may be a section for whether or not to carry loans on this.
So that's something that thinking about it, you think that the form could better
enhanced,
better tease out from members whether they have, let's call it loans, that may be something that they may need to declare.
Well, yeah, because at the end of the day, some folks are land rich but poor of how much loans they have on the books.
I see.
So you see a house here, a house there, and so forth. And what you don't see is what funded it.
Mm. Thank you. Can I just take a look at the attachments, because that's where you actually set out, and it is for the transcript a typed document that you produce, and you have annexed to each of your declarations, the 3 that you've provided, and you then cross-refer to the sections to which it applies, which is section 1, directorships, 2, remuneration, and 9, shareholding. That's right, isn't it? And it starts at our page 93 and goes through. Now, can you help me with this, please? You've explained that you are a director of Caribbean Basing Enterprise BVI Limited, of which you, and with each of these, again for the transcript, what you do is you name the company, you name your role within the company,
yes,
and you also name the extent of your share ownership.
That's correct.
So in this case, Caribbean Basing Enterprises, you've declared that you have 100% share ownership.
Yes.
Now, you refer to 3 contracts, and so this was the position as of, you've put as of March 8th, 2021. Contracts with the Ministry of Education, Health and Social Development, contract with Ministry of Transportation and Works. So there's 2 contracts with Ministry of Education, 2 contracts, and 1 with Ministry of Transportation and Works. And it's to do, if I summarize it, to do with waste management.
Yes.
Effect. And you've explained the start date of the contract and the status of the contract. So again, for the record, 2 of them are on hold. Yes. So that, and only one of them is active.
That's right.
And is that still the position today, Mr.
That's correct.
Right. Now, these were obviously contracts that were in place before you entered elected office.
Long before, yes.
And one of them one of them that's active is, if I've understood it right, is at least in part with your own ministry. Well,
yes, and the reason why I placed on that Ministry of Education / Health and Social Development, because it was first under the Ministry of Education.
And then has been transferred to your ministry.
Yes.
Now, how does that work from a conflict point of view for you as the minister leading that ministry?
Well, there were many attempts to have it, quote unquote, taken altogether from me in earlier years. But being number one in the number two business, others saw it fit to let who's best at it remains.
Well, that may be something we need to come back to, if I may. But your March 8th, 2021, you are the Minister for Health and Social Development.
Yes.
Your ministry, which you lead and which you have a constitutional duty to administer.
And 10 years before I held this contract.
Yes.
Yes.
Yes. I'm not saying that, but as of 2021, the ministry still has the contract in place.
Correct.
It is an active contract with your company.
Yes.
You are the minister.
Yes.
How, in terms of the management of that contract, do you deal with the potential conflict of interest?
Well, what we have done is this. There were 2 or 3 submittals, and I guess you'll get to these a little bit earlier, but the Constitution allows for a member because...
is this, I'm sorry to cut you, but is this the Section 67 exemption?
Yeah.
So you're not required to vacate your seat?
Yes.
Yes. That is something I will come back to, if I may.
Okay, fine. So,
but it's actually the mechanics of it. You're sitting in the Ministry of Health and Social Development. It's 2021.
And I was not there sitting in 2009. So I'm saying is that at the end of the day,
yeah.
When this was, we are the ones who installed the equipment. It's a proprietary equipment, 2009. And at the end of the day, the ones best suited for administering and servicing this is the very company with which I actually sit. One could have argued that I may have been best suited in the Ministry of Transportation and Utilities, but because we, quote unquote, held these particular subjects, then it was I thought best, and other members thought best, not to put that possibility of conflict of interest, because the company's engineering, mainly in infrastructure, Caribbean Basin, number one and a number two business, then let's keep you away from this. In fact, when you Google the portfolios, you would find that it was original that telecommunications may have been placed under this ministry, but because I have family in that field, I thought it best to not put it there. And to my surprise, the prison came. And at the end of the day, I either had to simply not take any ministry or have it declared in cabinet, in the House of Assembly, as directed by the Constitution.
If I put my question, perhaps I hope try and put it more simply. If a problem arises with that contract between...
No, I have proper staffing and so forth.
That's
they administer fully what it is.
But how do you keep yourself away from that? Because imagine this hypothetical scenario. If a problem arises between the ministry that you lead and the company with which it has a contract, of which you are 100% shareholder, how do you, as the minister, manage that conflict? Well,
the thing is that I exempt myself totally from any dealings with any officers dealing with any contract related to this and so forth. In fact, I'm disadvantaged in that monies are owing that has not been paid, and I dare not go and ask them, where's my money?
Yes,
and so forth. So at the end of the day, I have to exempt myself totally from this and not use my office to find out, well, can I get on the top of the scale and so forth. So I'm more at a disadvantage than I am at an advantage, because I deliberately have done that. So by keeping away from anything concerning this is what I do.
So and is that arrangement written down? Is it documented?
Well, if you want to stay out of trouble, I don't know if it's documented really, but if you want to stay out of trouble, you actually do this. That's right.
Right. But then what you've explained is that if the ministry is in arrears with your company, you can't effectively go and ask yourself to pay the bills.
Right.
But
yes.
who does who runs it then? You can't. You're saying that you're
I have
well
staff.
aware.
I have staff.
No, that's on the company side. But within the ministry, who administers it? Who makes the decisions?
No, well, it have the my ministry is fortunate to have permanent secretaries, deputy permanent secretaries, financial officers, and unit heads and so forth. So there's a whole string of processes in order for it to come. Any arrangements, any particular subjects.
So I mean, you don't have a junior minister.
No.
So you are the minister.
No, the permanent secretaries, because if you were from the UK, you'll know that as far as we're concerned, the civil service is who, quote unquote, run things.
So the permanent secretary in your ministry will oversee this contract in relation to
we have
Caribbean
absolutely
basin.
zero, nothing to do. And it is a difficult thing to explain to the population at times, because they feel as if, well, they can call the minister and the minister can effect it immediately. It can't happen. And in most cases, it does not happen.
And you have just kept yourself away from this contract since 2019.
Well, this and almost any other, because at the end of the day, I told the financial officer, the finance thing, I was clear cut about exactly how the administration of the office goes and so forth. Because and this is why certain questions you may ask me, I'll have to bring in the officers related to it in order to give you the details.
You're not the only minister that has made that point to the commissioner, but the point here is this arrangement, effectively, if you like, a wall between yourself as minister and your company, is that actually written down?
Well, not that I've seen. I cannot say it is or it is not. I haven't been guided to it, but I know in terms of etiquette protocols and other things. I've been from the disclosure I give you in terms of my experience. I'm experienced enough to know that you don't do it. Period.
Okay, let's try and go through the form a little bit more quickly. If we go to page 93, we're on page 93. The next thing that you declare is CBE Engineering Associates Limited. 100% share ownership in that. You identify yourself as a director, and that provides engineering and architectural services and project management. That has no contracts with government.
Well, yes, but let me say again, here again is where I was disadvantaged to some degree, because my history will show that it was a very active company before I got into politics. And once I got in there, then I just, to avoid any of this, just did not seek to be further engaged in these works.
I see. So you put it has no contracts with none. Can your companies, without any difficulty, enter into contracts with statutory boards?
I seek not to.
Well, that may be Carvin Malone being a cautious accountant, but can you?
Yes.
Your companies could. It would present.
My company can get into contracts with government and the statutory bodies. There's a requirement for you to seek exemption from being placed. So it could seek it with statutory bodies, it could seek it with government, but there's a procedure in which it's done.
If I explain, I mean, the Honourable Neville Smith has explained that to the Commissioner. So I think we have some evidence about the operation of Section 67. But your understanding is that if one of your companies wants a contract with the statutory board or the government, you would have to go down the Section 67 route for yourself.
That's correct.
Okay, let's go over to the next page then, please. It's your page 95. This is a company in which you have 50% share ownership, a status of a director. It's called Island Block Corporation Limited. It's rental of office and commercial spaces, I think, in Mount Sage, yes? Now, you have said there that the company has between April 2010 and January 2020 entered into contracts which are all active with various ministers. It's with the Ministry of Transportation, Works and Industry, 2 contracts, and 3 contracts with the Deputy Governor's Office. And in one instance, it's leasing office space, but the rest of it is leasing file storage space. Is that right?
Yes.
Now, again, from obviously different ministries, not your own, but did you, on coming into office in 2019, take any steps to create any kind of distance between those contracts and yourself as a minister?
Well, when you say distance, what are you saying?
Well, you know, you've explained how in relation to the prison contract.
Yeah, the officers. So I don't.
You simply,
I don't inquire.
You don't have anything to do with that. But,
yes.
but what steps in relation to these contracts, if any, have you taken about?
Well, these are even easier because at the end of the day, they have been set from the dates indicated here, and it is only on renewal of any of these that we would then. If they come up for renewal, then it'll be important for me to go back to the House of Assembly and let them know, well, these are coming up for renewals and I will seek your exemption under 66 or 67 of the Constitution.
I see. And if, this is a hypothetical if, for example, you were to have conversations with the Minister of Transportation, Works and Industry. No.
The office takes care of all of that. I separate myself totally.
Right. And by the office, do you mean the company office?
Yes.
And so you haven't, effectively, since, are you saying that since coming into elected office, you don't run your own companies?
Well, no, right, exactly. Do not. I have an office that does that. In fact, again, to my disadvantage.
So you make no decisions in relation to the companies?
No, they would call me from time to time when they have areas of which they need recommendations on and so forth. So, and I'll actually give that. But in terms of the day-to-day running of the company, no.
See, but again, to go back to my hypothetical, if the Minister of Transportation works, and I think you've put it to transportation, works in industry, it might be works in utilities, but if the minister sought to discuss one of these contracts with you,
I send them to the office and I tell them, well, look, see if it's available, see what the price it is, see what terms you can get.
Is that something that a conversation like that, an approach like that, is that something that you would feel necessary to put on the form?
Sorry, in what way?
Well, if a minister in another department with which one of your companies had a contract wanted to discuss with you the operation of that contract, would you declare that on your form?
I see what you're saying. Yeah. Well, it could be declared. I'm not sure exactly. Are you in charge of the day-to-day affairs of your company? Yes or no? The answer will be no. So in that format.
Yes, but if I, as the minister, come up to you and say, Mr. Malone, I need to discuss how this contract's working out for my ministry, and you then do have a conversation, would you declare that fact?
Did you have a conversation?
Yes.
With that?
Yes.
Well, I don't know what I'll have to declare, because if I tell them to go see the office, well, do I have to declare that? You
tell me.
Well, I don't know. I don't see the reason to, because at the end of the day, it's small place, small world. We did not get into the commercial rental space after February of 2019. We have these spaces. I was the particular family leadership in this. If the particular government, if I see that government want, and a minister come and say, Minister Malone, do you have any space? Yes. Can you see the office for actual details? Why would I have to declare that?
So the answer is, in those circumstances, it's not something.
Well, you can draw the inference from it, but I'm saying is that I don't.
Unfortunately, I don't get to draw inferences. And that's why I'm trying to pin you down on your answer. But I think your answer is
you wouldn't declare that.
Well, I don't see what is there to declare.
No.
That a minister asked me whether or not I had space.
No, I'm sorry. I understand your reasoning, yeah. but you wouldn't declare it.
I know, but what is there to declare?
I'm sorry.
We also can't give you your answers.
Okay, fine, good.
Okay.
That's why it's important to
yes,
ask you.
your answer is no, but we understand. I understand the reasons for it.
Whereas, and as you've said, you
I know what I'm saying is that at the end of the day, you have to be reasonable in your questions. If someone comes to me and say, well, look, you have been renting for 20 years. Do you have any space available? You asking me whether or not I will declare that this minister had the nerve to come ask me if I had space. I don't see where that becomes irrelevant.
Sorry, I understand the reasoning.
Okay, fine, good.
Thank you.
but if you flip it, and I appreciate that your point is that you have divorced yourself from the day-to-day operation of your businesses. But if you were to approach a minister saying, I hear you're looking for office space, I have some, that is something you would have to put under a paragraph 3, isn't it?
Yes, that's different.
Let's go through the rest of the form as quickly as we can. 95 again. You've referred to the Malone Group Property Investment Limited, of which you have a 25% ownership, and you've identified your title as director, and you say no active government contract. So,
yes.
So in terms of when you're declaring information on the form, did you have in mind the need to declare contracts with government?
Well, yes,
that was the focus.
Yeah.
And when you define government, did you also include in that statutory boards?
I did, yes.
And then you've got Progressive Management and Communications, which is a management and communications company, 100% share ownership. You're the director. That also has no active government contracts. Is that right? Soapers Whole Corporation Limited, 10% share ownership. Is that just as a shareholding rather than playing a role in it?
Yeah, just a shareholding.
Right. Provides commercial real estate holdings, and again, it has no current government contracts, does it?
Yes.
Have I understood that right? I mean, you've said a seabed lease application submitted, mooring rights application, but that's an application you've made rather than a contract that you're engaged in.
Yes.
Then you've declared again, Sage Investment Holding Limited, CCT. What does CCC stand for?
This is the cell phone company.
Right. 2% share ownership in that. No active role in it.
No, at all.
It's, as you said, a telecommunications service provider. Now, various government, what you've said under that it's active, it has contracts with various government departments and statutory bodies, yes. But you're just simply an investor in this company.
That's right. I have absolutely nothing, officer or director or anything.
Right, and you're not provided with any of the details of the contract that it enters into.
At all.
Mount Sage Holdings 1996 Limited, ocean conversion. Again, it provides water desalination services. You have a 2% ownership. It's active. It has an active contract with the Ministry of Transportation Works and Utilities. Now, again, are you in the same situation as you are with Sage Investment, in that you're just a minor shareholder? Is that right?
Yes.
You don't get details of what contract it enters into. Perhaps the better example is, say, the telecommunications provider. If that were to enter into contract with your own ministry, would you be made aware of that?
Yes.
And what's the mechanism by which you might be made aware of that?
Well, sorry, if it's a cabinet item or a House of Assembly item, we'll do it, but they'll have no commitment to make me aware that someone wanted to purchase a phone from CCT or something like that.
Again, I mean, if a different ministry enters into a contract, then you're saying that there's no obligation on them to alert you to it.
Yes. But if it has to come before cabinet or the House of Assembly, then
that's when you'd be aware of it.
Sure.
So effectively, you'd learn it at the same time as other cabinet ministers.
That's correct. Yeah.
But if it's with your own ministry, if your own ministry,
that's correct. The day-to-day offering, if it's not on policy and it's not on law, folks do come up to me from time to time. What's the status of this contract? I have no idea. Can you call the member for housing, the member for prison, the member for safe haven?
when you say member for,
well, in terms of the public officer.
I see. So in your view, the civil service really do run everything.
Well, in terms of this, because that is how it's set up.
But is there a mechanism within your ministry for them to say, well, actually, we're thinking of entering into a contract with a company in which you have an interest?
Right. In terms of if I have an interest with it, then they would flag that immediately. In terms of
well, is that mechanism written down?
I can't say that it is. It wasn't specifically brought before me, and I'll have to. If any of those details come to me between now and what it is, I'll be pleased to do it, because they most certainly must be listening, and then they will show me. They'll educate me further.
Right. And who are the both that?
No, because I have the permanent secretary and I have some deputy permanent secretaries, finance officers, and they will be. So
they're the ones that may be able to tell you whether any of your companies have entered into contracts with your own department.
I'm still young in this official capacity. Yes.
Yes. So all right. Okay. Well, we won't take that any further. Let's go through the rest of the form. 99, you've referred to Sage Marina Holdings, Village K Marina. Again, a minor 2% share ownership in that, so no active role even before you came into government, is that right? Mm-hmm. But that has contracts with various government departments and statutory bodies, as does Sage Yacht Harbour Enterprises Limited, Virgin Gorda Yacht Harbour, which again provides marina and boatyard services, commercial, retail and wholesale spaces. Again, various government departments and statutory bodies, but again, no direct involvement on your part. Is that right?
Yes.
You then refer to Mount Sage Holdings 1996 Limited, which in brackets you've put Colonial Insurance, and it's a property and health insurance provider, 2% share ownership in that, various government departments and statutory bodies. Contract, and that's the full extent of your. You've declared all your directorships, all your sources of remuneration, and all your shareholdings.
Sure.
And to be fair to you, I mean, you've gone down to 2%. So have you given a complete picture of the extent of your shareholdings in this form?
I would hope so.
And was that in your approach? Was that what you decided to do? That
yes.
I'm just going to give everything?
I was going to give everything.
Follow. Thank you. Can I just turn to another topic, please? And that is, I hope we can take it briefly, but just, and the reason we can take it briefly is because the Commissioner has already received quite a lot of evidence about this. But it's the system by which you and you would be this as a territorial representative, have a fund from which to distribute assistance grants.
Yes.
Now, please correct me if I'm wrong in this. It's trying to summarize other people's evidence, but as a territorial representative, the fund, leave aside COVID, is $150,000 a year.
That's correct.
And the process is that someone can make an application to you as a territorial representative.
Yes.
You will assess the merits of that application.
Yes.
You'll reach a view on it.
Yes.
And you will make a decision. And,
yes.
and that decision extends, does it not, to deciding how much they will receive?
Sure.
But it then goes to the clerk to the House of Assembly.
Yes.
In some instances, the clerk can send it back to you.
That's correct.
Has that ever happened to you?
On one or two occasions where you may have a member who was was previously granted assistance from other members, and it was felt that they should not be getting it from 2 or 3 members, number one. Number two, in an instance where it was sent back for actual correction, they needed to get the invoices substantiated. Number three, if it was a educational grant that was best suited in the Ministry of Education, then it was asked to be forwarded to that.
I see.
the different housing folks and so, so yes, there were times they were sent back.
So are there instances where you have authorized or positively agreed to an application where what can come back to you is, actually the person needs to go to another ministry? So it doesn't come out of your fund, it might come out of ministry funds. For example, the education scholarship might come from somewhere else entirely.
Yeah, it was thought best suited to come out of the although in number 3, for instance, it give in terms of financial assistance for scholarships is allowed in actual verification. So the fact is that there was a broad scope in terms of what it could be done, but it was still specific under the provisions of the guidelines that was set.
If you go now from the clerk to House of Assembly, it also goes to then goes to the Treasury Department.
Yes.
And these are not my words; these are the words of the Honourable Vincent Wheatley. The job of the Treasury Department.
But you've asked me not to refer to members. You're questioning me, so you can't violate your own rules.
Fair point.
Yes.
But the job of the Treasury Department to issue the funds.
Yes.
Do they ever send applications back with a query?
Well, you see, yes, they've had situations where they may feel as if, well, although the clerk may have processed it, it is still lacking some other information that they need in order to fulfill their duty.
What can you give the Commissioner some examples of what sort of information they have asked for at that stage?
I really don't remember. My private secretary deals with most of this, but at the end of the day, any of the information that they come, they would be keen enough to send it back and say, well, look, this should not be, and so forth. So there is a trifecta in terms of surveillance of this.
You being one of the parts of the
clerk
trifecta.
being another, the actual treasury being another.
Now, the other evidence is, for example, that the application may be sent back because a particular part of it hasn't been signed or a document hasn't been submitted. Is that the sort of is that the sort of typical is that typical of what's been sent back to you, the kind of queries you have to deal with?
Yeah, those are typical because you have situations too that you may not be monitoring fully, and the head for which this is placed may have been busted. It doesn't have any more funds available in it. And if that is the case, well, this is where the trifecta situation will come in. If it isn't caught in the first, second, then the third will hit, because they cannot overspend the particular heads on which it is done.
Now, I think you draw attention to the guidelines for processing assistant grants, which are in front of you. When did you first receive those guidelines?
While it was spoken of early, in all honesty, it was very late. I can't say exactly when, but I know 19 and 20. So it was in 21 in terms of the written guidelines. We were always told what not to be in here, and it was part of that package. Just like when I told you, I don't know specifically when the registrar gave us those forms, but I know we have had to have it because Honorable Smith was one that did it on the specific day. But and there were guidelines that were spoken of. Maybe if I search my file, I'll find it and so forth. But we were always keen, and even if we weren't told, then my secretary or other persons would know, well, certain things simply don't fit the bill in terms of what could be examined.
So I mean, the guidelines themselves, your recollection is that these were sent to you in 2021?
No, we may have had them, but myself, you asked me about.
Yes, well, I mean, these are guidelines that govern your operation as a member of the House of Assembly.
Yes, and so forth. My
And
secretary
decisions
deals with all of them and so forth, and she must have had them and the other, members. What I'm saying, you asked when did I see
Yes.
that? So I paid much closer attention
Well,
to
just
it
to try and
forth.
clarify, Mr. Malone, is what you're saying that you may have seen these guidelines relatively recently, but your secretary will have been aware of them at an earlier stage?
Yeah, they actually kept me on the straight and narrow. So at the end of the day, it will actually do. When we
Which secretaries are you referring to?
no, that's a private secretary.
You maybe as a minister you end up with quite a lot of secretaries, but you have a permanent secretary
Yes.
as a minister, and then a private secretary.
That's correct.
Permanent secretary, I understand. The permanent secretary is running your ministry. What does the private secretary do?
Well, none of the other ministers explained this?
No?
Oh, really? Okay. Well, each minister has a private secretary and so forth. So all of the stuff that is because handle the appointments. If you wanted to see me tomorrow, it will go through the private secretary. This particular
and it's your private secretary since you came into office. Your private secretary has been handling correspondence around the applications.
Yeah.
She deals with the applications
and with the clerk and with the treasury.
I see. Right. So what do you do in the process?
Sorry, what do I do when?
Yeah. Well, what do you do in the process?
You'll have to ask me in relation to.
In relation to an application, what do you do?
No, well, once it comes in and is examined and it fits the particular scope, the guidelines and so forth, it comes to me for determination.
So you put in a fourth stage in that your private secretary makes an assessment of the application and then puts it in front of you.
Yes, in most cases, yes. There are people who would see me personally and say, well, look, I need to conduct an operation. But the national health insurance doesn't cover all of it and so forth. Can you please assist? And so forth. So I would send them to fill a form to see exactly what it is, get the medical bills, get the whatever the circumstances may exist, so that then it could be examined, it could be looked at and so forth. Because some folks may well not have been current on the NHI, they may not have been current on other stuff. They'd be down on their luck because between 2017 and 2021, remember, there's nothing that has been normal in most of these islands.
In terms of
destroyed, medical bills, and then the actual pandemic.
In terms of your the amount that you get, your $150,000. Taking 2019 to 2020 as an example, did you have to distribute the entirety of that amount?
Sure.
Now, the guidelines, I should ask you this. I mean, I'm just trying to understand the process that you put in place. How are you able to fairly determine an application if you're not aware of the guidelines?
Well, what I'm saying is that at the end of the day, the secretary will be looking at these, number one. Number two, in terms of the areas, because I've centered most of my contributions to assistance with medical stuff. I know that was there and so forth. When I saw this sheet of paper, might be in question, but in terms of whether or not I know of some of the limitations, the answer is yes, because they were vocalized. But if you ask me when did I get this sheet of paper, is what I speak of.
Just be clear to me. Just when did you get that piece of paper?
I don't remember the exact date, but it was either late 20, early 21 in terms of getting this exact piece of paper. But as I said before,
it's your secretary
well, that number one, and number two, just like the register of interest, because when you come into office, there's a whole series of packages that is actually given to you, number one. Number two, your research of me would have told you that I was one of the members who were charged with going to the UK to look at the to look at the loan guarantee and all of that, concerning the RDA and the loan guarantee and whether or not we should be entering into that. So a lot of the time was spent on research and getting information.
Commissioner, I noticed, I mean, we've been going for some time, and I'm conscious that I suppose I've got about 15 minutes more, but whether we ought to just give the stenographer a short break.
I think that's probably right. Mr. Malone, we have a stenographer, and after about 2 hours, it becomes even more difficult for him to carry on without a break.
Sure.
So we'll just have a short break now, and then we'll come back and finish off your evidence.
Am I not done?
And then Mr. Rowett says about 10 or 15 minutes more, but we'll have a 10-minute break, yes, and then come back if you will. Thank you very much.
Thank you.
Yes, Mr. Rawat. Thank you, Mr. Malone.
Thank you.
Honourable Malone, if I could take you to page 123 in the bundle. So to speak.
Which one?
In the Carvin Malone bundle.
1, 2, 3. 2, 3.
Just to finish, pick up on and finish on a point that you made during your evidence, which was about section 67. And so you should have at 123 the start of a number of resolutions of the House. Resolution number 10 of 2019, number 11 of 2019, which is at your 125, and number 6 of 2020, which is at your 127. Do you have those?
Yes.
And put simply, you came before the House and sought an exemption from having to vacate your seat because of contracts with government. Is that right? And so in relation to the first one, which was dated the 2nd of September 2019, but gazetted on 12th of September, this was in relation to contracts between Island Block Corporation Limited, of which you were a director, and it relates to the provision of properties to the Ministry of Transportation and Works, Department of Motor Vehicles, and then Deputy Governor's Office, 3 separate contracts with Deputy Governor's Office. That's right, isn't it?
Yes.
Now, these resolutions are debated in an open hearing of the House of Assembly, aren't they?
Yes.
And are the resolutions published so the public can read them? Do you know?
Well, once they actually gazetted, it's actually public.
I see.
Yeah.
And then if we go to 125, this was on the same day, and that was in relation to the contracts we'd already looked at, which is arise from your directorship of Caribbean Basin Enterprise BVI Limited.
Yes.
And it's one the present contract with your ministry in relation to the sewage treatment plant and various other sewage things. And there's also a H. Laverty Stout Community College contract over Leaf. Is that right?
Yes.
And then the last one, 8th of June 2020, you were again the recipient of a successful motion not to exempt your seat, and that was in relation to, again, Island Block Corporation Limited and leasing of space as a temporary record centre. Is that right?
That's correct.
Are those the entirety of the occasions on which you sought exemptions under section 67?
Yeah, that I sought, yes.
Can I move on just to a little different, slightly different subject, but your role in cabinet. What's the process if you want to declare a conflict when you are sitting in a cabinet meeting?
I would have it informed to the Premier, and who would inform the chairman. And even if I forgot, then I'll be reminded by the Attorney General or members.
How soon before the item comes up on the cabinet agenda do you inform the Premier?
Well, even when it's being considered to be placed on there's a cabinet steering group that directs what items are placed on the agenda, and it will be actually declared at the time.
I see. Do you feed into the cabinet steering group?
No, not at all.
Right.
Sorry. Explain that. Feed into. Am I a part of that?
No. The cabinet steering group, as I understand it, has the job of agreeing the agenda for the cabinet meeting. But can you make submissions, if you like, to the cabinet steering group for items to be on the agenda?
Well, the process is that they would have to be formulated, put in the circulated to the different factual comments, AG, Financial Secretary, from the secretaries if required. Then there will be circulated, and so it's an entire process. So it's fed in by the process. So if I personally can't do it, but it goes in terms of each of the ministries submitting a paper have to go through a process, and it is circulated, is agreed by the cabinet secretary, and then when all that is required has been completed, then it goes to the cabinet steering group.
I see. And at what point do you know what's on the agenda so that you can declare an interest if it arises?
Well, after the cabinet steering group decides that it will be agendaed or it will be placed on the agenda, then.
And how soon before the cabinet meeting does the agenda come to you as a minister?
It comes in terms of definition. It is cabinet steering group. My understanding is they meet on a Monday, and cabinet is on a Wednesday.
And so you have between Monday and Wednesday to alert the Premier to any.
And the secretary, yes, yeah, Premier, and he will do whatever is required.
Premier and secretary, is that the cabinet secretary?
Yeah, but it is a Premier that will have to give alert.
I see.
To her.
All right. Well, could you turn to page 16, please? And if you look at the large grey bundle that's on just furthest away from you, you should have two bundles that are grey. Take the larger one. One underneath that one. And turn to page 16, please.
16.
16. Cabinet minutes for the 3rd of April 2019. You are listed as one of those presents. Can you see your name there?
My name is the 1, 2, 3,
6 down.
4, 5, 6.
Yep, you got it. If you turn to 29, please. Page 29. One of the issues which we have been exploring with witnesses, and particularly those who sit in cabinet, is how the policy governing when you declare interests and how you declare them operates. So this is an example at page 29 on this meeting of the 3rd of April 2019, where, as you see at 12, the matter that came before cabinet was NBL-HL application number put forward by the Minister for Natural Resources, Labour and Immigration, and it's about Road Town Wholesale Trading Limited. You are recorded as declaring a private interest. And I just wanted to understand what was meant by private interest in this context.
Well, I'm a board of director member, shareholder, but a board of director member for Island Block Corporation.
I see. So you're both a director and a board member and a shareholder in Island Block Corporation. Sure. Is that right? And this related to the transaction that Island Board Corporation were involved in.
Yes.
I see. And is the term private interest a term of art? I mean, is it meant to capture commercial interests?
I guess, yeah, I'm not. I am interested in commercial interest, but I hold shares, so whatever it is.
I see. But you know, is the advice that is given to you when if you like, a commercial interest arises, it should be labelled a private interest? Or is that somebody else's words? Yeah,
that's a legal particular differential. I have shares. I'm a board of director member.
I see. All right. Go to 58 then, please. if you look at 17th of April 2019, that's a cabinet meeting. You have that?
Yes.
You're listed as appearing just before the then Attorney General. Do you have your name?
Yes.
If you go, please, to 72 in this bundle. It's you see it just above 29. There's a round robin from the Minister of Finance concerning the rehabilitation of Elmore Stout High School cell-shaped building. Can you just help me with this? What's a round robin in this context? What does it refer to?
Well, round robin is when you have a cabinet paper, and cabinet is normally held on the Wednesdays in person, or during the pandemic, it was mainly through WebEx and so forth. But in these circumstances of round robin is that if you need a paper to be determined before the next cabinet meeting, then you draw the actual CXC agreed to have it made available to members for their determination before the next cabinet meeting.
Because it's only at the next cabinet meeting that you can agree the minutes. Is that why?
Yeah, it'll be entered in as if it was at the particular meeting, but it was to be determined by members. Wrong robin. It's actually passed around, and and they actually determine it, and then.
Right. Now you are at 73. Recuse yourself. You're recorded as recusing yourself because of a familial interest, and yes. The familial interest that appears to be, and correct me if this is wrong, is that your brother,
yes,
was recommended by the Ministry of Finance for a petty contract, yes, in relation to this round robin.
That's right.
Now, what guidance are you given as to the extent of family relationships that you need to declare?
Well, in terms of if you have relatives, and again, like everyone else would have informed, it's small island, small place, you have family members, you have relatives all over and so forth. But if my brother comes up for a particular contract, I recuse myself from those particular deliberations and determinations.
Now, some of the evidence has been that this is directed to your spouse and your children.
No, that is as it relates to the registrar, yeah, of interest.
Well, I'm referring specifically to the evidence in relation to cabinet conflicts.
Okay, fine, good.
Now you've gone further, and obviously you've declared an interest because your brother was involved.
Sure.
But what's the outer limits for you? If it were instead of your brother, it was a cousin, would you declare the interest?
Well, let me ask you. Folks have a range of cousins: first cousin, second cousin, third cousin.
Yeah. So where's your line? Do you stop before you get to first cousin, or do you stop at second cousin?
Well, I look in terms of my aunts, uncles, and my brother and sister and so forth. I don't know if I had any determination as it relates to first or second cousins, but and so forth. But
so for my
brother, my aunt, my uncle.
Right. So your approach has been, if there's a potential conflict that involves my wife, my child, my adult siblings, aunts and uncles, I will declare it.
That's correct.
What about on your spouse's side? If it's your wife's siblings, would you declare it?
Well, that's easy here because my wife is from Sunset, Louisiana.
Well, let's imagine your wife is not from Sunset, Louisiana. If she were here and she had family on this island, would you declare it in that instance?
Me, Carvin, Malone, yes.
Thank you. 170, please.
And that's if I knew about it. That's not everything that your siblings.
Yes. Well, I think it's a precondition of being able to declare a potential interest that you know, sure, about it. So let's go to 170 and the 26th of July 2019 Cabinet meeting. You're again present, and if you go to 191, you again recuse yourself, Honourable Malone, and it's recorded that what, and if I explain that this was a memorandum introduced by the Premier, and it was about appointment of members to the Planning Authority. And you, on the first item that's recorded, is before the paper is presented, is that you recuse yourself due to so I'm start that again. You recuse yourself because of your, quote, close relationship, end quote, to one of the nominees recommended for membership. Now, those approved for membership are listed down at the bottom of the page, and it was just, could you clarify what is meant by close relationship?
Well, my brother was there again.
Right. So instead of, but prior to being recorded as a familial relationship, now it's recorded as a close relationship. Again, is that a term? Is that a term that's intended to refer to a family connection rather?
But I'm not sure what anyone else mean. As I told you, my brother, my sister, my aunt, uncle.
So, are you given any advice about declaring interest where it's not a family connection, but a different sort of connections?
Yeah, just in terms of relatives of that nature, brother, sister, spouse.
So the focus in terms of what you're looking out for is family connection.
Sure.
Go to 396, please. Again, Cabinet meeting, 7th of November 2019. We can see that you're there, just listed above the then Attorney General. Do you have that?
Yes.
420 then. This is a memorandum that's from the Minister of Finance relating to office accommodation for various government ministries and departments being relocated from the Central Administration Building. And you are recorded as recusing yourself to avoid a conflict of interest in this matter. The conflict isn't specified, and I wondered if you could just help the Minister, well, the Commissioner rather, with just like, what was the nature of the conflict in this instance?
Being a member of the board of director and a shareholder of Island Block Corporation.
So it was because there was a possibility of entering a contract with a company in which you have a direct interest.
That's correct.
I see. Right. Let's take a look at the last one, 517, please. You should have a minute of the meeting of 5th of February 2020. I think you've been promoted a little bit up the name list because you're now not second from last, but third from top. Do you have yourself there? Yep. You've got yourself?
Yes.
All right, let's go then to 554, please.
554?
Yes, please. It's a memorandum from the Minister of Natural Resources, Labour and Immigration. It's about a grant of Crown land and to a Chantal Malone, and you then recused yourself again, or you declared an interest, which I take is the same as that you recused yourself from discussion of the item. And it's because of a close family relationship with Miss Chantal Malone. And again, it's going back to, you know, I suppose the question of when is a cousin, but what was the nature of that relationship?
My niece.
I see. So on your side then, so for you, your ambit extends not just to siblings, but also to potentially to their children as well.
Yes.
I see. Right. And
well, let me just put in the record that first BVI lender, well, not first.
I've read that. She was the first.
Yeah, first, and only BVI lender to win a medal in the Pan Am game, and she might well be the first to win a gold medal. Sorry, a medal in the Olympics.
Well, thank you for that. But the point is, from your approach as a cabinet minister to the need to declare interests, your circle is quite wide, isn't it? I mean, I appreciate that your wife is not from the BVI, but from your side, it covers your wife, your child, your aunts and uncles, your siblings, and their children.
Yes, correct.
And is that how you've approached cabinet?
Well, yes, I approached cabinet and the House of Assembly in the same manner because I knew that this day will have to come. So at the end of the day, I wanted to make sure that we did this, and you'll see from my opening remarks, you know, if we're going to go to the other step, we have to gain the confidence by making sure that we forthright in it. If we go down to every cousin, then I would not be able to sit in cabinet.
Yes. No, I think that's a point that other witnesses have also made
Sure.
to the commissioner. But it is helpful to have evidence from those who sit in cabinet as to where they see the line being drawn. Sure. On the advice that they're given. Commissioner, I've reached the end of my questions. Can I conclude firstly by thanking the Honourable Malone for the time that he's given to the Commission today and the patience that he's shown in having to wait around a little bit. But also finally to thank him for the way in which he has given his evidence.
Yes, can I echo that? Can I thank you, Ms. Malone, for your time and your patience and the clear way in which you've given your evidence.
Thank you.
All very much appreciated.
Thank you.
Thank you very much.
If you could rise briefly, Commissioner, whilst we reset the room for the next witness.
Certainly. First, may I apologise for the delay in taking your evidence, Miss Moses-Scatliffe. I apologise for the delay. We're ready to start that evidence now. Thank you very much.
Thank you, Commissioner. Mrs. Moses-Scatliffe, thank you for coming to give evidence today. Can I begin by just dealing with asking first for you to be sworn?
Sure. Good afternoon. Would you like to swear an oath or make an affirmation?
Make an affirmation.
If you could turn the piece of paper around.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much.
Thank you. For the record, can you give the Commissioner your full name, please?
My full name is Ingrid Anne-Marie Moses-Scatliffe.
I try as we go through to keep my questions short and simple, but if at any time you would like me to rephrase a question or repeat it, please do ask me. There are a number of bundles that you'll see there in front of you. We will go to some of the documents in those bundles in due course. Can I ask one final thing? The microphone in front of you doesn't amplify, it merely records.
It doesn't have.
Amplify.
Oh, okay.
It just records your voice. So what you will need to do is to keep your voice up and to speak slowly, please.
Can I ask one question? You said there are a number of bundles before me. There was a bundle that was delivered to me.
Yes.
Is the bundle here with my name a duplicate of the one that was given to me and that I brought?
Yes.
Okay.
But you can use the bundle that was sent to you. If that's,
okay,
if that's
what I
easier
wanted to
for you.
confirm.
Yes.
Thank you.
Could you begin by just giving the Commissioner a brief outline of your professional background before you became Speaker of the House?
Prior to being appointed to the Speaker of the Second House of Assembly, I was a partner for a few years in a local law firm. Prior to that, and before changing careers, I was the Chief Registrar of Lands with the Lands and Survey Department. And prior to that, for over 12 years, I was a senior manager at an international bank in the territory.
Thank you very much.
Now you just explained that you were first appointed Speaker of the Second House of Assembly.
Correct.
And it's right, isn't it? You were also the Speaker of the Third House of Assembly.
Correct.
Prior to that first appointment in 2011, had you been a candidate in the general election at all?
No, I was not.
And at any time thereafter, did you put yourself forward to be a candidate?
No, I did not.
Were you, though, a member of a political party?
No, I am not.
And you were not at the time?
No, I was not.
So how did you come to be appointed as Speaker of the Second House?
Well, I got a telephone call shortly after election from the Honorable Premier at the time, Dr. D. Orlando Smith, and he invited me to stand for the Speaker of the House of Assembly.
And how does the process work? Were you the only person invited to stand, or were others?
Well, there is a process. On the day of the actual swearing-in ceremony, the clerk who presides over the session and the sitting asks for nomination to be appointed to the Speaker. And this is all documented in the House of Assembly standing orders. The clerk would ask for nomination for Speaker. The Premier would put forward his candidate, which was myself, and ask the opposition and any other member if there were any other candidates they wanted to propose. For the Second House of Assembly, there were none. And that's when I was sworn in.
And was it a similar process when you became Speaker of the Third House?
It was a similar process for the Third House. The question was asked. The opposition members said no, they didn't have any nominations.
And when did you finally step down from the position? Was that when the House adjourned for the 2019 election?
At the end of January, when the House was dissolved that day.
During your time as Speaker, what did you see the role as encompassing?
Again, the role of the Speaker is documented in the Virgin Islands Constitution Order 2007, as well as the House of Assembly Standing Order. The role is to preside over House of Assembly sittings and all committee of the whole House.
And did you have, as Speaker, any executive function in terms of running the House?
I presided over the House as it relates to House of Assembly sittings, committee meetings of the whole, any informal meetings that members had, or anything to do with the members.
Right. But I mean, if members had an issue with the clerk to the House, did you have any involvement in that? When
you say members had an issue?
Well, if they wanted the House of Assembly to operate in a certain way, was that something that you would be involved in?
Well, when you say in a certain way, it all depends. If members had concerns collectively as a body, then those issues will be discussed at House of Assembly informal meetings, and the clerk is the secretary to the House of Assembly sittings, as well as the sittings of the committee as a whole, as well as most of the committee meetings of members.
But in terms of line manager responsibility, you have a clerk to the House of Assembly. Does the clerk to the House of Assembly have a line manager, if you like?
It's just a very thin line. You have an input to say, but the clerk is the accounting officer of the House of Assembly. The clerk actually reports to the Deputy Governor's office.
Right. The issue that the Commissioner has been investigating is the question of interests declared by members of the House of Assembly, which includes former members of the House, and Commissioner has taken evidence about the Register of Interests Act 2006, and which prescribes for a register, but that it has to be one that is not available for inspection to the public. During your time in the House of Assembly, did you form any view about whether it was a good idea or a bad idea for the register to be published?
No, I did not form any view whatsoever when I was sworn as Speaker. I got a package just like I presume every other member did.
And what was in the package?
The Register of Interest Declaration form along with a cover letter.
Along with a?
Cover letter.
And when did you get that package?
I met that package the very first day that I showed up at my office.
I can take you to the law if it will help, but were you aware from that very first day that you had an obligation to make a declaration of your interests on the day that you were sworn?
When I got the package, I read the letter. I referred to the Elections Act, which governs the declaration, and I was aware.
And were you aware that you had an obligation to submit a declaration on every subsequent anniversary?
Yes, I did.
Were you also aware that separate to that, if you had not within 3 months of that date submitted your declaration, then that constituted, using the words of the Register of Interest Act 2006, a breach of the Act, and one which the registrar had to report to a standing select committee?
Yes, I did.
Could I take a look at some of your declarations, please, Mrs. Moses-Scatliffe? If you go, please, to page 69 in your bundle. Now, you were Speaker from 2011 to 2015, and then 2015, 2019, that's right,
correct.
Isn't it? And so the date in which I think you were sworn in and that the House was sworn in and had its first sitting for the 2011-2015 House was the 8th of December 2014. If you look at this form, it's stamped by the registrar January 21st, 2015. If you go to page 74, that's the last page we have on it, but is that your signature?
Yes, it is.
And it's dated, isn't it, 14th of January 2015?
Correct.
So it would follow that you had missed the due date of 8th December 2014, wouldn't it?
Correct.
So you hadn't, in that sense, complied with the requirement under the Act, had you?
No, I was short by a few days. Section 3 of the Act, that is.
Yes.
Correct.
We can, I'll be specific if you want. Some witnesses have not enjoyed me being specific, but I will be. So let's go to 62, please. That's, we've just looked at your 2014 declaration. We're now in the third house, and at 62 is a declaration stamped July the 7th, 2015.
Correct.
The last page of that is at page 68.
Correct.
Again, that is your signature, isn't it?
Yes, it is.
Dated the 30th of June 2015.
Correct.
Now, the due date was the 23rd of June 2015, which was the date you were sworn. So again, you would accept that you had breached Section 3 of the Register of Interest Act. Is that right?
Correct.
If you go to page 56, this is your 2016 form. Page 56 is the first page of the declaration, stamped July 6, 2016 by the registrar. That's right, isn't it?
Correct.
If you go to page 61, is that your signature?
Yes, it is.
30th of June 2016 is the date, isn't it?
Correct.
And again, you'd missed the due date of the 23rd of June 2016. And so you were in breach of Section 3 of the Act, weren't you?
Yes, I was.
If you go, please, to 50. Stamped by the registrar June 27, 2017. So this would be your 2017 declaration. The last page we find at page 55. Can you confirm that that's your signature, please?
Yes, it is.
It's dated the 27th of June, 2017, isn't it?
Correct.
So again, you had missed the due date of the 23rd of June, 2017.
Yes, I did.
And so you were in breach of Section 3 of the Act. You're nodding, Mrs. Bates.
Yes, I did. Sorry.
Thank you. And then finally, let's look at your last declaration, which we will find at page 44. Which is the first page, stamped by the registrar, and she's entered a date on there in manuscript of 15th of August 2018. The last page is at page 49. Again, is that your signature?
Yes, it is.
And it's dated the 27th of June 2018, isn't it?
Yes, it is.
So again, by missing the due date, you were in breach of Section 3 of the Act.
Yes, I was.
Did you, during your time as Speaker, have correspondence with the registrar?
Yes, I have.
Did you, I think you've indicated that when you first arrived, she sent you a pack, which was the declaration form and a cover letter. Did she send you letters like that every year?
As far as I can remember, yes.
Were you aware or not whether she was sending similar correspondence to other members of the House of Assembly?
I presume that she was sending to other members of the House of Assembly. But I can only confirm that I know I got mine this year.
If you could turn, please, there's another bundle on there, which I hope is headed Governor's Disclosure. It's one of the black lever arch files. You got it. If you could turn, please, to page 98, please.
Page 90.
98, 98. It's a memorandum dated the 9th of July 2014 from Boyd McCleary, then governor, to you as Speaker of the House of Assembly.
Correct.
And it's headed Declaration of Interests and reads as follows. The Registrar of Interests has drawn my attention to the delinquency of some members of the House of Assembly in failing to file their declarations of interest as required under Section 3 of the Register of Interests Act 2006. Some members have never filed a declaration since taking office on 8th December 2011. The Registrar of Interests advises me that she has issued numerous requests and reminders. She's also brought this matter to the attention of the Standing Finance Committee, yet some members remain delinquent. The Registrar of Interest is an important element in the checks and balances required to ensure good governance. I would be grateful if you could bring this matter to the attention of members and encourage all to file their declaration as soon as possible. Do you remember the Governor alerting you to this issue in a memorandum in 2014?
I do recall.
And that put you on notice, didn't it, that some members of the House of Assembly, at least, were not complying with the Register of Interests Act? What steps, if any, did you take in response to this memorandum?
I don't have the documentation at hand, but I will tell you what I recall from memory. I remember writing to the Premier, as well as to all members of the House of Assembly. And I do recall having a conversation, if not correspondence, with the registrar, which she would have been aware, as well as bringing it to the attention of the Premier that the Standing Finance Committee that the Governor is referring to in the memorandum, the standing orders of the House of Assembly, which had been in place from 1976, did not include provisions for a standing select committee for the Registrar of Interest.
If we take that in steps, you wrote to members and drew the issue to their attention. Subsequent to that, did you take any further steps in relation to those members to ascertain whether or not they were complying?
I remember it being raised in meetings. I cannot tell you definitively which members were not complying because it's a personal matter, but based on the memorandum that was brought to my attention, I was aware that some members were not. What I did also imply to the Premier is that as well as the chairman of the Standing Orders Committee, was to get the standing orders revised to include a standing select committee for the Registrar of Interest.
Now, you said that you had correspondence, which you don't have to hand, but where would that correspondence, which is correspondence from you as Speaker, who would hold that correspondence now?
That would be in the House of Assembly. It's government correspondence. It would be between my email and it would be on the files.
So you would not have retained copies when you left office?
No,
Right.
I would not.
Now, you raised then in 2014 the problem with the standing orders, that they did not cater for a standing select committee. Now, from other evidence that the Commissioner has received, this was something that had also been raised by the registrar. Were you aware of that?
Raised by the registrar?
Yes.
To whom?
To the Standing Finance Committee, to, I can show you if you want. Would you like me to show you?
No, that's fine.
But also to the Chairman of the Standing Orders Committee as well, drawing to his attention the absence of this committee. Now, you're the Speaker. What powers, if any, do you have to press for the creation of such a committee?
Well, the Standing Orders Committee had been created that there are 5 standing committees in accordance with the standing orders that are created very shortly after the House of Assembly is established. So the Standing Orders Committee had the responsibility for having meetings to have the standing orders revised to include a standing select committee for the Registrar of Interest. So I had extensive communication with the Premier as well as the chairman of the Standing Orders Committee at the time, and who then set out to have meetings to get that done. And I must add that there were a number of amendments that were also required to be made to the House of Assembly standing orders, bearing in mind, as I said, that the standing orders had been in effect from 1976. The Constitution came into effect in 2007.
You should see some loose leaf pages on your desk. There should include something headed House of Assembly of the Virgin Islands, Resolution number 3 of 2016. Do you have that?
Yes, I do.
That's the resolution of the House, which actually established the Standing Select Committee known as the Register of Interests.
Cool.
Now, certainly from your perspective, as from 2014, you had been raising, as Speaker, the need to amend the standing orders so the committee could be established. Would that be a fair assessment of what you did?
Yes, it would be.
Now, you were raising that when you were Speaker of the Second House. The resolution establishing the committee, the Standing Select Committee, was not passed by the House of Assembly until you were Speaker of the Third House.
Correct.
Can you explain to the Commissioner why it took so long to get this done?
It's not a matter of just getting the resolution itself done. The resolution was that emanated from the revision to the House of Assembly standing orders. The Standing Orders Committee did meet and have several meetings, as far as I'm aware, from in 2015, if not perhaps from around the latter part of 2014. And I remember in 2015, the standing orders have to be laid in the House of Assembly first. And I do recall one revision was laid, I think it was in December 2015. Of course, the standing orders in their full amendment phase has to be laid. And then a point of, an issue was raised in relation to the standing orders with no force presented on the table of the House of Assembly by members at the time. And they were taken off, and there were additions and amendments to other areas within the standing orders themselves, which resulted in the actual standing orders themselves not being revised until, I think it was early, in the first quarter perhaps of 2016. And coming out of that, the resolution.
The Act came into force on the 18th of February 2008. Obviously, you were not Speaker of the House then. You became Speaker of the House in 2011. In order for one step in the Act being fully operational is the creation of a Standing Select Committee, which is created some 8 years after the Act comes into force. From the time that you took your oath of office as Speaker in 2011, was this an issue, the need to revise the standing orders? Or did it only emerge in 2014?
I wouldn't say that it emerged only in 2014. Because as I said before, there were a number of issues that needed to be addressed within the existing standing orders of 1976, one of which was adding the Registrar of Interest Standing Select Committee.
Is there anything to stop the House amending the standing orders more than once?
Because the standing orders are actually the legislation that governs the House of Assembly, the committee would meet, but they also have to meet in conjunction with counsel from the Attorney General Chambers, as well as the the deputy clerk of the House at the time was the secretary to that committee while this was all being done. And I know that they met extensively to revise the standing orders, considering that they hadn't been revised for, well, over 30 years.
And so from your recollection, it's a process that began in sometime in 2014 and continued through.
It was a process that began, and it just emanated with the resolution actually being gazetted on the 19th of May 2016, but it did start prior to that.
Did you at the time appreciate that, as well as the obligation under the Act, there was also a constitutional obligation of being placed on members?
Let me put it this way, the Constitution, the Virgin Islands Constitution Act of 2007 came into effect in 2007. And that made various provisions within the Constitution, one of which was to provide for a registrar of interest.
What it also provides for, and I can take you to it if it will help you, but it provides that it shall be the duty of any person to whom the section applies to make a declaration to the register. And what that person has to do is make a declaration upon assuming the functions of his or her office, and at such intervals thereafter being no longer than 12 months as may be prescribed by law. And so the obligation, the Section 3 obligation that we've been asking you about, doesn't just arise under the Act, it arises under the Constitution, the obligation to make your declaration on the date you make your office. So during your time as Speaker, did you appreciate, and I'll just keep it to you, but did you appreciate that there was a constitutional obligation being placed on you to make your declaration on time?
I'm just rereading section 1112.3. No, section 1112.4, which is the section you were reading from, correct?
I paraphrased for you 1112.2 and 3.
Okay. And could you repeat the question again, please, now?
I won't read out the text now, you've had an opportunity to read it. But did you appreciate from the time that you became Speaker in 2011 that the Constitution placed an obligation on you to make a declaration on the day that you assumed your office?
I think by extension, the Registrar of Interest Act, which is derived from the Constitution, placed the requirement on the members of the House of Assembly to make the declarations.
You're a lawyer by training and profession, Mrs. Moses-Scatliffe, and the wording of Section 112 of the Constitution is not ambiguous at all, is it? It makes clear that there's an obligation placed on you.
Mm-hmm.
Would you accept that?
In accordance with 1112.3, correct?
Thank you.
I'm sorry, just while we're on section 112, while you've got it open, 112 subsection 1, there shall be for the Virgin Islands a register of interests. So again, that's mandatory. There has to be a register of interest. And then 5, without, you needn't read all of 5, but a law made under this Constitution shall make provision for giving effect to this section. That's the 2006 Act.
Correct.
The 2006 Act requires the registrar to maintain and keep the register in accordance with the Act. And the register, section 4.2 says, shall be in such format as the select committee shall approve. That means, on the face of it, that without the select committee approving the format of the register, there can't be a register, because there's no way in which a register can be formulated. That seems to be the understanding that the registrar had, because she said on more than one occasion that the register is a blank book because there was no format in which to put the information, which was. I'm sorry. Are you looking for?
I'm looking for the section that you were reading from.
It's page 62 in that on Mrs. Moses-Scatliffe. Page 62 is in that's it.
Page 62, what section were you reading from?
Section
Mr.
4.
Commissioner? Okay.
Just 4.1. The registrar shall maintain and keep the register in accordance with this Act. And 4.2, the register shall be in such format as the Select Committee shall approve. So the registrar took the view, on the face of it correctly, that without a format being approved by the committee, you couldn't have a register. The declarations would come in, they'd be on bits of paper, and she's kept them, but there couldn't be a register because there was no format in which to put the declarations.
And you're asking me a question, sorry.
The question is that there appears never to have been a register in your time or even now. Doesn't seem ever to have been a register because the Select Committee has never approved a format. There's no evidence that it's approved the format. Nobody suggested that it's ever approved the format, and therefore there is no register. The registrar has various bits of paper which have been sent to her by members from time to time, but there is no register.
Can I ask you, just for clarity, Mr. Commissioner, you were reading from section 4.1 and 2?
Yes. So 4.1 is the registrar shall maintain and keep the register.
Mm-hmm.
And 4.2, missing out A and B, because that's what the register must contain.
Right.
The register, going down to the bottom of 2, shall be in such format as the committee shall approve.
Okay.
The committee, there's no evidence that the committee have ever approved a format. The registrar, the previous registrar, Mrs. Romney Varner, took the view that that meant there was no register because there was no format in which she had to put the declared interests. So she said on more than one occasion, the register is simply blank. It's a blank book. Was that something which you thought about as the speaker? It may not have been. It may not have crossed your mind.
I'm inclined to say and shall be in such format as the committee shall approve. In my thinking, a register would be presented.
By whom, to whom?
By the registrar. Meaning, simply because the register shall contain the names, offices, addresses, basic information that members would have filled in on their declaration forms. But the formal format to be approved would be by the committee. So I'm just trying to be clear if you're asking, and I guess you've said it, that there was nothing that contained any information other than loose pages.
There are two separate things. One is the duty to declare, and we've been through that, section 112.
And the register.
And section 3 and so on. But there's this separate matter which is at the moment concerns me, that there still appears to be no register. Today there is no register. If somebody wanted to look at the register, there's nothing to look at. There is simply the loose pages which individual members have sent to the registrar from time to time. And I understand if you say, well, that was never something which I thought about, or it was never brought to my attention. It's just a concern. I just wondered if you had any view on it.
I don't recall the matter of there not actually being a physical register in place. Not that
being an issue.
No, that's I wasn't going to say not being an issue. That's not what I was going to say. Okay.
You may not have any comments on it.
Yeah, I
on
don't.
it. No,
I
okay.
don't.
No, okay. Thank you very much. Yes.
Do the standing orders prescribe, right, at least as they were during your time as Speaker, did they prescribe how often a select committee should meet, a standing select committee?
I'm just referring to it. I do not think so, but I'm just going to refer quickly to the section in the standing orders. So it prescribed the days and hours of the sitting, but not necessarily the frequency.
In the case of the committee that was set up under that 2016 resolution, they appear to have met once, which was in 2017. So is it entirely open to a committee to decide how often it will meet? What its agenda will be? That's for the committee membership, is it?
Correct.
So if the committee decides that it'll meet once a year, nobody's going to raise a concern over that.
If it's brought to the attention, whatever has been brought to my attention, then I will bring it to the attention of the members collectively in an informal meeting, as well as to the Premier.
But does it fall within your remit anyway? I mean, other than it being brought to your attention, do you as Speaker, would you have had any kind of control over decisions that committees made as to how often they would meet?
No, because I'm not a member of the committee.
No, I think the evidence is really it's up to the chairman.
It's up to
to call meetings and produce an agenda. Yes.
If we look at let's go to page 44 in the bundle. I just want to ask you quickly just about the form itself. This is your 2018 declaration. It contains, I think, generally across your forms, you've made the same declarations. But some other members might say that you had an advantage over them because of your legal training, and because this is a form that is scheduled to the Act. When you came to fill it in, did you consider that any of the wording or explanatory notes that were set out in the form could give rise to doubts or ambiguity about what information was required?
I cannot recall, but I do remember specifically when I got the form the first time and I completed it and submitted it. The registrar at the time contacted me and told me there was one area on the form I had incorrectly completed and told me what the correct thing ought to be. And I made the correction and sent it back to her, and going forward, that's what I bore in mind. And that was from the very first declaration that I made.
And in relation to which paragraph of the form was that?
It had to do with the constituency.
I see.
Page 1.
So you don't have a constituency as Speaker? Correct.
I wasn't sure what was meant for me to put there.
Yes.
And she told me that.
But other than that, what you've declared is, and this is the second thing in your approach, I mean, there are 3 areas where you've put substantive responses.
Correct.
The first is in relation to directorships. So you, for example, declared directorships in a law firm, trust company, accounting firm, holding company, an electronic bill payment solution, and a brokerage firm.
Correct.
Now, you also declared remunerated employment. For example, in the same law firm, Travers Thorpe Alberga, you've declared remuneration from there.
Well, correction, the heading of question 2 says remunerated employment officer profession, but the actual question asks, do you have any employment, office, trade, profession, or vocation apart from membership in the House of Assembly or ministerial office for which you are remunerated or in which you have any pecuniary interest?
Yes. So what did you take the question to be seeking from you?
Pecuniary interest. It wasn't that I was being remunerated.
It's just that you had an interest, for example,
Correct.
because you're a partner.
Correct.
I see. So, but the point is that and if we pick it up as well, you've also, for example, in the same companies, you've specified shareholdings.
Correct.
Now, did you appreciate, therefore, that the same, if you like, the same source of information might need to be repeated at different parts of the form to give full disclosure? So you could be a director of a firm in which you had a pecuniary interest and also held shares.
Correct.
And for completeness, you would have to put that information in different parts of the form.
Correct.
Did any other member ever come to you and ask for guidance in terms of completing the form?
I do not recall. All I can say is the declaration of interest is a very personal and private document. And other than speaking about it generally, in general terms, it was a personal matter.
If you go to page 48, please. This isn't about the particular paragraph, but can you see at the top in the explanatory note, there's reference to a guidance pamphlet on registration and declaration of members' interests?
It's at the top of page.
Page 48.
I don't
48 at the bottom middle, numbering at the bottom of the middle.
in the middle.
It's the top paragraph in italics.
Yeah.
Towards the end of that paragraph, there's reference to a guidance pamphlet on registration
I
and
see it.
declaration of interest.
Did you ever receive a guidance pamphlet?
I don't recall receiving one.
Now, obviously, you filled in a number of this form a number of times. Did you ever ask for it?
I can't recall asking for it because, as I said, the only question that I had a concern with on the form was the one that was incorrectly completed, and the registrar contacted me and told me what it should be.
And other than that, you had, you didn't think the form it didn't give you any difficulty in understanding what was required of you?
No.
If you go to page 49, please. Paragraph 10 asks you, bearing in mind the definition of purpose set out in the instructions form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. And the reference to the introduction is to the preamble, which you can see at your page 44 if you need to look at it, but which sets out the purpose of the register of interests. In terms of paragraph 10 that we're looking at page 49, what did you understand its purpose to be?
As it said, if you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories.
But any relevant interest, was that any relevant interest held by you or held by, for example, your spouse?
The latter.
So in your view, what was required of members here was to declare not just relevant interests they held, but possibly held by a spouse or other members of their immediate family?
Because the Register of Interest Act defines spouse and children, minor children, by virtue of the act itself. And this question, in my view, should be anything outside that.
So anything outside?
That is my interpretation.
Yes,
that's not necessarily.
Well, that's what's important, because what's important, I mean, you have the advantage over us in that you had to fill in the form. So how you approach the form and what you understanding the wording to be requiring is important to know. So when you approached para 10, you read it as looking for seeking information that fell outside what was specified in the act. So outside your spouse, outside your minor children.
And which I may have a relevant interest in.
So, for example, a business operated by an adult child in which you might have an interest or get some indirect benefit is something which you might declare under paragraph 10?
I would.
Thank you. You should, I hope, also see on the table in front of you some guidelines for processing assistance grants. A number of honourable members have explained the process by which the provision of assistance grants operates, and so the Commissioner has the evidence on that. They've explained that the clerk to the House of Assembly is also involved in the process. Does the Speaker to the House of Assembly have any involvement in this process at all?
No, I don't.
So that it's not the job of the Speaker to get involved in this.
The clerk has the day-to-day responsibility for the running of the office of the House of Assembly.
Next matter is there is a process by which honourable members can be exempted from a requirement to vacate their seat, which is under section 67 of the Constitution of 2007. So in circumstances when they might enter into a contract with government, they would be obliged to vacate the seat unless the House votes otherwise. Were you ever exempted under section 67 during your time in the House of Assembly?
I'm just going to section 67. No, I was not.
Did you ever seek exemption?
No, I did not.
In terms of the process of bringing such a motion before the House, is it always down to the Premier to put the motion before the House when an exemption of this sort is being sought?
Correct.
Mr. Commissioner, that's the end of my questions. Can I conclude by thanking Mrs. Moses-Scatliffe for her patience and for coming to give evidence today, and also for the way in which she has given that evidence?
Yes, and can I echo that? Thank you very much for your time and your patience in waiting, and for the clear way in which you've helped me. Thank you very much. Yes.
Can I ask you to rise briefly? Well, I'll be able to ascertain the position with the next witness, and then we can begin.
Yes, I'll do that. Thank you. Yes, Mr. Walwyn. I'm sorry if we've kept you waiting, but we are now ready to take your evidence. Thank you very much. Yes.
Thank you, Commissioner. Our next witness is Myron Walwyn, and can I ask that the witness be sworn, please?
Good afternoon. Would you like to swear an oath or make an affirmation?
Affirm.
If you could turn that paper around.
Really?
Great, thank you.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you, Mr. Walwyn.
Thank you, and thank you for coming to give evidence to the Commission today. Could I begin with some formalities? Could you give the Commissioner your full name, please?
My name is Myron Vernell Walwyn.
What I try to do, Mr. Walwyn, is to keep my questions short and straight, but sometimes that doesn't work out. And if you have any difficulty understanding a question I've put, please don't hesitate to ask me to repeat or rephrase it. There are a number of bundles on the table in front of you. We won't necessarily need to look at all of them. What I'll do is I'll take you to specific documents as we go through your evidence.
That works.
Final thing is just to ask you to, and this may be no difficulty, but just keep your voice up, please, and speak slowly. The microphone in front of you doesn't amplify, but it's important that we accurately record your evidence today. Could I begin with a question I put to every witness we've had in the last few days, and that is by asking you to just give an outline of your professional background before you entered politics, please.
Yes, I started out as a teacher. Then I got involved in the hospitality industry, did some formal studies there as well, and proceeded to open some businesses that are still operating here now in the Virgin Islands. I studied law. Upon my return, I was a Crown Counsel at the Director of Public Prosecution's Office. Proceeded to open a law firm with a few partners, and that's where I am now.
I see.
Yes.
Now, in terms of politics, is it right that the first time that you were elected to the House of Assembly was in 2011?
That's correct.
And that was as a territorial candidate.
That's correct.
For the NDP.
That's correct.
And that House sat, that was the second House, it sat from 2011 to 2015, didn't it?
That's correct.
And during that time, did you take on any ministerial role?
Yes, I was assigned the role of Minister for Education and Culture by the Premier.
And then you were re-elected, is that right, in 2015?
I was.
And again, did you return to a cabinet position?
Yes.
And what was that?
Minister for Education and Culture.
And I believe, correct me if I'm wrong, but you stood again as a territorial candidate in 2019.
I did.
You were unsuccessful.
I was unsuccessful.
And as we understand it, I mean, in effect, every voter has four, they have a district vote, but then they have 4 votes to choose the territorial candidates.
That's correct.
And it essentially it's the top 4 get it, and
that's correct.
Everybody else doesn't. Now, one of the issues that the Commissioner has been concerned with is the question of the Register of Interest Act 2006.
Yes.
And I hope you've picked up on that from the information that the Commission has provided to you.
Yes.
At present, under the Act, there is no provision for it to be inspected by an ordinary member of the public. What during your time in office, so 2011 to 2019, what was your view about making the register open to the public?
My view now, as it was then, is that I have no issues at all with the register being public. Absolutely none.
Can you see potential benefits to doing that? Absolutely,
particularly in a very small society.
And in what way could you see those benefits coalescing?
I think it goes hand in hand with good governance and transparency that we're trying to see, and that persons, particularly the voting public, ought to know what interests members have, so that when certain decisions are made, they can have confidence in those decisions.
But would you picking up on what you've just said, would you agree that a register of interests would only be truly effective if it were an accurate record of people's interests?
I would agree with that.
Now, obviously, it's a couple of years since you've left politics behind you, but you are a lawyer by training. And so if you need me to take you to the Register of Interest Acts, do tell me. But can I just outline for you the obligations that it places on members of the House of Assembly and see if you agree with me?
Yes.
The first is that there is an obligation under Section 3 of the Act to make a declaration of your interest on the date that you are sworn into office.
That's correct.
Secondly, you have an obligation under Section 3 again to make a declaration on every subsequent anniversary of that date.
Yes.
There is also under Section 7 a consequence of not filing within 3 months of your due date. And Section 7 describes when that situation arises, it describes it as a breach of the Act, and it mandates that the registrar send a report to a standing select committee. Was that something that you were aware of when you were in the House of Assembly?
I was not. I was not entirely aware of it. I was not.
And can you explain to the Commissioner why, particularly given your legal background, that was not something that you were aware of?
Well, I am not one of those lawyers who know everything. I must say to you, of course, I'm making no excuses, because I know from the Register of Interest Act, Commissioner, there's no defense in there. You either did or you didn't in terms of your filing dates. I was not aware of the first breach, which is in Section 3, and the second breach that was in Section 7.
You weren't aware?
I was not aware.
Thank you.
I was not aware of the material time.
Can I take you just to the declarations that you do file and the ones that have been provided to us? Can I explain, Mr. Walwyn, what I'd like to do is to take this in 2 stages, as I have done with other witnesses.
Yes.
The first is to confirm dates, but the second, which we will come to, is to ask for you to explain to the Commissioner how you approach the form.
Yes.
Because on different parts of the form, so far different witnesses have given different answers as to what they understood. So let's deal with dates first. If you go to page 61 in the bundle.
Can I confirm one thing though, Commissioner?
Yes.
The bundle that you sent to me, is that the exact duplicate here?
Yes,
What
it
you're
is.
reading from?
Yes.
There's nothing different?
Yes.
Yes or no?
Yes, there's nothing.
Sorry, yes, there is nothing different.
Yes, there is nothing different.
They're the same, Mr. Walwyn.
So if we go, please, just to, I think it's page. Oops. Sorry, give me one moment. If I take you, please, to page 61.
61.
Now, you can see that obviously your name and your constituency being at large is typed on this declaration form. It is stamped by the registrar October 5th, 2016. But can you see just above the received, there is written in manuscript for 2015 and then a scroll. Is that your handwriting, Mr. Walwyn? Or
At the top?
yes.
No, that's not mine.
Right. I'm going to suggest that it's probably the registrar.
It could very well be.
If we go through then to page 71, can you confirm that that is your signature?
It is.
And it's dated underneath, typed 9th September 2016.
That's correct.
Now, this appears to be your 2015 declaration,
Yes.
which was due on the 23rd of June 2015, the day that you were sworn in.
That's correct.
So would you agree that by dating it the 9th of September 2016, you failed to comply with Section 3?
That's correct.
And you were also in breach of Section 7, weren't you?
That's correct.
Now, if I now take you to page 72, we now should see a declaration which is stamped by the registrar December 14, 2016.
Yes.
And if we go through to the last page of that, which is at page 82, that's again signed by you, isn't it?
It is.
And that's 14th of December 2016.
For 2016, yes.
And so that's your, I'm going to suggest your 2016 declaration, which was due on the 23rd of June 2016.
Yes, sir.
So again, would you accept, Mr. Walwyn, that you were, by filing that in December 2016, you breached Section 3?
That's correct.
And you also breached Section 7?
I did.
Can I take you now to page 50?
50.
50, please. It's now a third declaration. You can see that it's stamped by the registrar. And within the stamp, she's written the date 18th September 18. Do you have that?
Yes, I do.
Go to 60 now.
Yes.
Again, the last page of the declaration, is that your signature?
It is.
Dated the 29th of December 2017, isn't it?
That's correct.
Now, again, 23rd of June 2017 would have been the due date.
Yes.
Under the Act. So you are again in breach of Section 3, aren't you?
I accept that.
And also in breach of Section 7.
Yes, sir.
And then if we do the last declaration we have, you will find at page 39. Stamped by the registrar, and she's dated 28th August 2018 in that.
Yes.
And you've signed that at page 49. And you've dated it 15th of August 2018, haven't you?
Yes, sir.
And that now taking your due date as being June, 23rd of June 2018.
Yes.
Submitting it on the 15th of August 2018 is a breach of Section 3, isn't it? Now, you said that to the Commissioner that you didn't really have an appreciation of the operations of Section 3 and Section 7.
Yes, that's what it is for timelines, yes.
Did you have, were you aware that, leaving aside the Register of Interest Act, the Constitution itself placed an obligation on you?
The Constitution created a Register of Interest. It's a creature of that, yes.
If you look, there should be on the table in front of you a bundle, not your own bundle, but another one, which...
What did you write me to the Constitution?
I'm taking you to the Constitution.
I bought it.
You bought your own.
Yes, sir.
Go then to section 112 of the Constitution, please.
Yes.
Do you have it?
I have it.
Thank you. As you've said, it creates the post of Registrar of Interest, doesn't it?
It does.
And at 1121, it mandates that there will be a Register of Interest.
Yes.
At subsection 2, it makes it the duty of any person to whom the section applies to make a declaration to the registrar. Do you
Yes.
accept that?
Yes.
And at subsection 3, it says that a person shall make a declaration under subsection 2 upon assuming the functions of his or her office, and at such intervals thereafter, being no longer than 12 months, as may be prescribed by law.
Yes.
And subsection 4 makes it applicable to members of the House of Assembly, including ministers.
Yes,
So if we go back to subsection 3,
yes,
that's the Constitution mandating that a member of the House of Assembly has to make a declaration upon assuming the functions of his or her office.
yes.
Would you agree?
I agree with that.
Which is, we see then mirrored in the section 3 duty, don't we?
Yes,
And then the second element of the subsection 3 is that at such intervals, being no longer than 12 months, as may be prescribed by law. And so that's again the second obligation that we see in section 3 of the Act.
yes,
Is found in the Constitution, isn't it?
yes,
So would you accept that where you are breaching section 3 of the Act, you are also breaching section 1123 of the Constitution?
no, I don't entirely agree with you.
And could you explain to
I
the
think
Commissioner why?
I think what this section does, certainly portions of the section we find replicated in the Act itself. But if you go to section 5 of the very same section 1112, subsection 5, a law made under this Constitution shall make provision for giving effect to this section. When I interpret that, the relevant area that you really should look at is the Register of Interest Act.
I see.
That is my interpretation of that. So I can't agree with you.
I'm sorry, Kerry, do finish, Mr. Walwyn.
Yes, I'm finished, Commissioner.
We're going to hear some legal submissions on this later today.
Yes,
But you are a lawyer, so let me say this. In respect of paragraph section 1125 of the Constitution,
yes,
those words are classically the words relating to enforcement, which are normally left to other measures. So to give effect to the section normally refers to something which provides, for example, sanctions so, to enforce the duty. But section 1122 is in pretty clear terms, it seems to me, subject to anything you say or any further legal submissions. It shall be the duty of any person to whom this section applies to declare to the registrar the interests. So that's a clear duty, isn't it?
yes, but that's also replicated in the Act. But then, based on what you said earlier, Commissioner, if you were to complete it, it says a law made under this Constitution shall make provision for giving effect to this section, including.
Absolutely.
So it's not just for sanctions.
No, it's not.
Yes.
Because there are various ways in which effect can be given to a duty.
Yes.
But what this mandates is there must be sanctions.
Yes.
There has to be sanctions.
In the Act.
Yes.
Yes. I mean, I do appreciate where you're coming from, but I respectfully disagree on what has been put to me.
Yes.
Yes.
Thank you very much.
Yes.
Thank you. Can you confirm that your position was the same as appears to be the case with other members of the House Assembly? And this is both former members and current members have given this evidence, and that is that the registrar would send you, before the due date was up, a letter notifying you of your obligations and a copy of the form that had to be completed.
I believe she would have done that.
And that subsequent to that, if you didn't make the date, she would send you reminder letters.
I believe she would have done that.
And do you recall receiving such correspondence?
I cannot recall because those would have come through my secretary, but I really do believe that she would have sent those.
No, you're the second person today to refer to the use of a secretary. Is this your private secretary within your ministerial office?
Yes, Commissioner.
Were you aware that she was sending letters and correspondence to other members of the House? And the time, when I say were you aware, it's obviously during your time as a member of the House Assembly. But were you aware that reminders and notices were sent to other members of the House Assembly?
I can't speak for other members. I can only speak for myself. I believe she sent them to me, as I said.
Were you aware, and this isn't asking you to speak for other members, but did you become aware at any time that other members of the House were, and this is the registrar's word, delinquent in filing their declarations?
I heard her make references. I don't know who the individuals were because she never said who they were. But I do know that from what she said that there were persons who were delinquent.
And where did you hear the registrar make these the statement that others were that members were being delinquent?
I'm not sure, but it could have very well been at Standing Finance, possibly. Could have been there.
As a minister, the Standing Finance Committee is not something that you would sit on, would it? Is it?
No, it's where you sit. The whole house sits to look at the appropriation bill, and they bring various departments in to say what their needs are, and they take the opportunity to raise issues that they're having.
I see. So the Standing Finance Committee is a committee of the entire House.
It is.
Oh, it's helpful. Can I take you then to some articles? You should have a loose leaf sheaf on your thing, which has a sort of index. It's called, I think it's called Press Articles Re ROIA. You have that.
Yes.
I just want to take you through a number of these articles. Now, the first one that you should have at your page 1 is headed Registry of Interests, a blank book. And it's from the BVI Beacon, April the 18th, 2012. Mm-hmm. And it says that it's been 4 years since the Register of Interest Act was brought into force, but the register itself is still a blank book, said Registrar of Interest Victorine Romney-Varlack during the recent deliberations of the Standing Finance Committee. Before anything can be officially entered into the book, Ms. Romney-Varlack told legislators, a standing select committee must be appointed, and that can't happen until lawmakers update the standing orders to conform to the territory's constitution. Like the Public Accounts Committee, the Standing Select Committee is to be made up of sitting lawmakers. And then there's a quote, so it reads as follows, quote, members should be thankful that the register was not a public document, because if it were, there would be nothing to inspect, end quote. Mrs. Romney-Varlack is recorded as saying in the SFC report. She went on to say she'd raised the matter of needing a select committee at every SFC meeting since her appointment in February 2008. Now, Mr. Walwyn, can you, again, the reference there to the SFC report, what do you take that to mean?
I think she means the Standing Finance Committee.
And does the committee actually produce a report, or is there a minute of the meeting?
There are minutes, I imagine, yes.
And so what one would see is if a department has to come before the Standing Finance Committee, they're coming before the whole House.
Essentially, all members should be present, yes.
And they can not only, I suppose, raise and answer questions about their budget, but also raise other issues.
Yes, they do take the time to raise other issues.
So did you, I mean, you were probably relatively new to the House by April 18th, 2012, but did you appreciate what the registrar meant by the fact that the register itself is still a blank book?
Well, I cannot say that what I've read was said in my hearing at that time. I mean, I'm just seeing this for the very first time, this description. So I don't think I'm able to say clearly without more.
Let's try and give you a little bit more.
I'll be grateful.
Just go through the rest of the format to conclude this particular law report.
Yeah.
If I should, for the record, just say that on page 2 it continues. For now, Mrs. Romney-Varlack keeps the very elementary declarations filed by legislators in file folders, the report states. What I'll do, Mr. Commissioner, if that's all right, is that I'll put the detail of these other press reports into the transcript before asking my question of Mr. Walwyn.
Yes, thank you.
The second press report that we have in this short bundle in front of you, Mr. Walwyn, is from the Virgin Islands News Online, January 6, 2013, headed Politicians' Registry of Interest Should Be Public, Romney-Varlack. And it then continues. The 2007 Virgin Islands Constitution has a provision in section 112 for a registrar of interest whereby elected officials must declare their assets, incomes and liabilities. However, the record is not public. The office of the Registrar of Interest is headed by Mrs. Victorine Romney-Varlack. She appeared before the 2012 House of Assembly Standing Finance Committee to defend her 2013 budget request. During Mrs. Romney Varlak's testimony, the member for the 3rd District, Honourable Julian Fraser, RA, inquired if the office was broadening its scope by expanding its powers. The registrar informed that in terms of scope, the registrar would maintain the registry of interest in accordance with the Constitution. She noted that in order to do so, the Standing Select Committee needed to be appointed and the House of Assembly needed to pass the relevant act. Mrs. Romney Varlak also noted that the registry could be extended to senior government employees who would have to declare their interests, but the act needed to be amended to accommodate them. Additionally, Mrs. Romney Varlak told the SFC that she suggested that the registry become public record. However, the member for 3rd District, Honourable Julian Fraser, RA, expressed that he did not think that the registry should become public record immediately and suggested that it should only do so after 7 years. Honourable Fraser also noted that members of the House SSC could request the information confidentially. Mrs. Romney Varlak told the committee that there was a conflict of interest if a member was in default. She noted that was why she was proposing a stand down of a SSC of the House and in turn appoint a committee comprised of private citizens. Mrs. Romney Varlak also noted that the United Kingdom Registrar of Interest laws, which she looked at, are restricted to elected members of Parliament only and not senior public officers. The report concludes by setting out some parts of section 112 of the Constitution. If we go over to the next page, and that's page 4, we return to the BVI Beacon of March 12, 2014. A report headed 8 years later, Register of Interest still not fully operational. And it continues. When Victorine Romney Varlak was appointed Registrar of Interest in 2008, she worked full-time for a month setting up shop as keeper of the Register of Interest, a log meant to help hold legislators accountable by requiring them to state their financial interests, such as directorships, employment, clients, sponsorship, gifts received, and land and shareholdings. Once she had the register established, however, Mrs. Romney Varlak began working only 3 days a week. And last year, when her contract was renegotiated, she was given a reduced salary, reduced her working days to just 2 a week, she told legislators during the Standing Finance Committee deliberations earlier this month. It then continues over. Legislators questioning the reasoning behind her pay cut were told it was inaction by lawmakers that led to it. After legislators passed the Register of Interest Act in 2006, they next needed to create a Standing Select Committee to help bring the Act into force. But this hasn't been done because the House of Assembly's standing orders need to be updated. Mrs. Romney Varlak is recorded as saying in the report on the deliberations of the SFC, these factors have left her post with a smaller workload than had been anticipated under the Act, she explained. The final report is at page 6. And it's now from the Island Sun. It's dated April 27th, 2016, and it's headed Register of Interest to be fully implemented. After many promises, on Monday, 25th of April, 6 legislators were appointed as members of the Register of Interest Standing Select Committee. The new committee will be chaired by Minister for Communications and Works, Honourable Mark Vanterpool, and will include Leader of the Opposition, Honourable Julian Fraser, Junior Minister of Tourism, Honourable Archibald C, Junior Minister of Trade, Honourable Marlon Penn, 6th District Representative, Honourable Alvira Madura Keynes, and 1st District Representative, Honourable Andrew Foy. Premier and Mr. Finance, Dr. the Honourable D. Orlando Smith, moved the motion, explained that the Register of Interest Standing Select Committee will carry out and exercise all the functions stipulated under the Register of Interest Act 2006. The Register of Interest was created for legislators to state their personal interests, assets, etc. But in 2012, Registrar of Interest, Victorine Romney Varlak, during her appearance before a Standing Finance Committee, announced there is no Register of Interest, only a blank book. At that time, the Registrar told the Standing Finance Committee that members of the House of Assembly should be thankful that the register was not a public document, because if it were, there would be nothing to inspect because she has a blank register book. Romney Varlak said that it had been 4 years since the Register of Interest Act had been brought into force and since the Registrar had been appointed. However, a Standing Select Committee was not appointed to work with the register. She explained that there cannot be a Register of Interest without a Standing Select Committee. It was stated that the standing orders of the House of Assembly need to be amended and brought into line with the current Constitution. And until this is done, the Standing Select Committee cannot be appointed and therefore she has no register. Romney Varlock said that successive throwing speeches mentioned the amending of the Act to include senior public servants and making it necessary for such civil servants to make declarations. However, it was noted that such inclusion would require that the Act be replaced or repealed. It was even suggested that it would be great if a short-term select committee was brought in because the registrar stressed that something needed to be done soon. She explained that failure to act would result in all of the relevant persons being seriously criticised at the end of the day. And it then concludes with a date as to when the to the reference to the Register of Interest Act 2007, which was passed on the 27th of December 2007. Yes. That amended the 2006 Act to make references, prior references to the Legislative Council become House of Assembly. Yes. Slightly long introduction to what I hope may be short questions, but taking it together, you're sitting in the House between 2011 2019, and so let's say it is 2016. You were entitled to sit on the Standing Finance Committee.
Yes.
With those reminders from those press reports in mind, and I'll caveat it that sometimes press reports can be inaccurate. But were you aware from 2012 to 2016 of the importance of a standing select committee?
I was aware later on of the issues. I mean, what I've read here, I cannot say that I remember hearing it at the time it was being said, but I do understand what she's saying, and I was aware later on of the need for the committee.
When you say later on, when did you become so aware?
I don't want to hazard a guess, sir, because I may mislead you and mislead myself.
Were you aware of the registrar's concern that the Register of Interest itself was a blank book?
I never heard her use that term before.
You've explained that you only, I think, later on in time became aware of your own obligations under the Act.
Yes.
Do you think that you were the only member of the House of Assembly in that situation?
I don't think so. I think a number of other members were under that same thought. They weren't aware of the timelines.
Because then I can show you the resolution, but it's amongst the loose leaf papers in front of you. What we know and what the Commissioner knows is that the Act came into force on February the 18th, 2008. Yeah. Mrs. Romney Varlock was appointed as the first registrar on that date, and she has remained in that post, only retiring very recently. Yeah. I think it's the 1st of this month when she stepped down. As she explained, and under the Act, as well as declarations needing to be made, a standing select committee is an important part of the process. Yes. On the undisputed facts, it took over 8 years to establish a standing select committee. Were you, during your time, I mean, I'll put it this way, does that not indicate that at least the Houses of Assembly of which you were a member took a rather relaxed attitude to the importance of the Register of Interest?
I wouldn't say that entirely. I can see how you can arrive at that thought. What I did know, because a standing order committee was put in place, I think around 2015 or so. I was a member of it. And that is when we really started to look at the standing orders, because they weren't revised in a while. And one of the key things that we were very keen to get done when that was put in place was to have the select committee for the Register of Interest put in place. I know we did a significant amount of work, meeting very late in the evenings, trying to at least get some of not just the Register of Interest issues addressed, but other issues that we know needed to be addressed because the standing orders were so dated.
Prior to that committee beginning to do its work, when had the standing orders last been revised?
It could have been, I remember making a joke to myself when I read it. I think I was 4 years old at the time when it was last revised. I remember that specifically, I think.
Was there, I think your evidence is that there was a lot of work to be done on the standing orders.
Yes, there was quite a bit of work to be done.
And they, as the evidence of Mrs. Moses-Scatliffe was that they have to then be laid before Parliament.
Yes.
And presumably there is opportunity for members to object to some of the standing orders or require further amendments or revisions. Is that right?
Yes.
Was there not scope to, in order to progress the select committee,
Yes,
for the standing orders to be partially amended and then put before the House, so that the House could at least agree to that and the establishment of that?
in retrospect, yes, we could have taken that approach.
Was there any reason why you didn't take that approach?
I think, well, as I said, I was a member. I was not the chairman. But I think we were just trying to be ambitious in addressing some of the long-standing issues that we know needed to be addressed. And perhaps rather than taking it in bite-sized pieces, we just went fully into trying to address those things that we knew should have been addressed a long time ago.
When, over what period were you a member of the Standing Orders Committee?
I think I was in that committee from 2015, I think.
So
But up until the House dissolved, yes.
in the third House?
Yes.
Were you a member of it in the second House?
I don't recall. I don't recall.
Did you appreciate that the reason why the committee, the Select Committee for Register of Interest, is so important is because it has to actually, under the Act, it has to approve the format of the register?
Yes.
And when did you come to appreciate that?
At the time when we were doing it.
But there still doesn't seem to have been any real urgency within the House to progress this.
I wouldn't say that it's necessarily so. I said, as I said, when I became a member of the committee in 2015, I think it was, we started to move assiduously to try to address that issue. I know I did hear other members speak about it before, but as I said, I can't remember who the members were of the previous committee. But I do know that right after general elections and the new committees were formed, we really worked as quickly as we could to try to get it established.
Who was the chairman of your committee?
If my memory serves me right, I think it was Honorable Ronnie Skelton was the chairman of that committee.
Because the countervailing view, which I would ask you to respond to, is that you have an act which is passed which comes into force in the first House of Assembly, February 2008, which requires, as part of its mechanism, a standing select committee, which is not established until the third House of Assembly, 2016,
Yes.
which, on the evidence the Commissioner has received in that third House, met only once, and there's no evidence that it agreed the format of the register.
Okay.
And now in the fourth House of Assembly, which I appreciate you are not a member of, has yet to meet and therefore has yet to approve the format of the register. If one takes that timeline, Mr. Walwyn, it does suggest, doesn't it, that members of the House of Assembly, irrespective of party, irrespective of experience, irrespective of status or office, just really not appreciating the importance of a register of interest.
I would say that members could have acted with a bit more haste on it, but to say that they were not interested, I wouldn't think that that's entirely correct, because in many instances, even though members were delinquent, they did still file the requisite information. Some were more delinquent than others, I assume, but the overriding objective of the register to make sure that members' interests were properly documented, I think by and large that was complied with.
But there are two separate issues. Firstly, the declarations.
Yes.
And we've heard evidence from a lot of members and former members as to delays, but that's one issue.
Yes.
And they then put in their declarations.
Yes.
The second issue is the register.
Yes.
2006 Act came into force in 2008. There is still no register. So if anybody wants to look at the register, like a court, there is no register to look at. And I think Mr. Rawat's point is that doesn't suggest any urgency in complying with the Act or the underlying constitution.
I see how you could form that view.
Thank you.
And you've said that members could have acted with more haste.
Yes.
Well, what's your definition of sufficient haste?
It should have been done. There's no excuse for it.
Well, I mean, take the select committee. It took 8 years. In what timeline, in your view, now looking back, should it have been done?
Well, it should have been done at the time when it was required to be done by law.
Can I turn to the form itself?
Sure.
Now, we just need to take one of your forms as an example, which I think is the way we can do it, and that is to look at page 39, please.
Okay.
Now, this form, it is in the form that is prescribed by the Act.
Yes.
So it repeats the wording of Schedule 1 of the Act. Now, you are a lawyer by training and a lawyer by experience. When you, on the 4 occasions that we've seen you had to fill in the form, and there may have been earlier occasions and earlier forms, but did you, when you approached it, did you consider that there were any doubts or ambiguities in what the form was requesting of you?
Not entirely. Not entirely.
Not entirely as a qualification. So were there things where you think, and that you thought that could lead to either the wrong information being given, or too little information being given, or even too much information being given?
What I can do, I can answer you looking back now, properly directing my mind to the form over the last couple of weeks since you sent me the bundle. When you look, for instance, at the main purpose of the register, which is at page 39, I have gathered from what I've read in the news that there seems to be, for instance, an interpretation that this section or this provision includes spouses and children and so forth. And that interpretation is then expected to assist in filling out part 10 of the form under miscellaneous. If you notice, in all of my forms, I didn't fill out 10. And so the interpretation of including spouses, your spouse, and your children and so forth, to me, is not immediately evident upon reading this section. And there are other areas within the form that I see could have been improved. The reason why I say that is because the issue of properly capturing any interest that spouses and close family members should have is too important an issue for the letter of it not to be written down clearly and in an unambiguous way. And so it leaves people or members now to sort of interpret or think what the form might be trying to say.
And it creates the uncertainty of when do you stop with family?
It does that.
One of the points that has been made to me by more than one witness is that at which point do you stop sort of referring to a particular cousin?
Yes.
Now, did you take the form as being limited to yourself, a spouse, and dependent children, or did you construe it more widely than that?
I took it to mean myself because that's what it says.
Yes, but the form in general, in terms of the sources of information, was it interest held by you as a member of the House of Assembly,
not in relation to the entire form.
No.
I tried to be as helpful as I could, except for when I came to 10 and the interpretation of the main purpose. I look at the main purpose to be myself. If there were other interests that perhaps my spouse may have had, I think I would have found a way to include those.
And if we look at the at 39 and if you like, the question that is being asked of a member completing this form is this, isn't it? That when you are making a declaration, you have to keep in mind what might reasonably be thought by others could influence your conduct as a member of the House.
Yeah.
It's in effect that you've got to have a sort of someone sitting on your shoulder. You've got to imagine what would someone else think if I did put in this information, or if I didn't put this information in.
Yes.
That's the sort of guiding thought that the person completing the form should have, isn't it? Yes. Can I just ask you though? I mean, you've declared, if we look through it and deal with it briefly, of course, you've declared directorships, so International Co-Limited, hotels and restaurants, the pub restaurants, Travers Thorpe Alberger, a law firm, and Harcombe Corporate Services, a trust company. You also refer to the restaurant business under enumeration. Yes. And then you also refer to the same companies under shareholders. So when you were completing the form, did you appreciate that the same sources, the same interests might need to be mentioned more than once?
Yes.
And was that, in your mind, approaching it, was it clear to you that that's what the form required?
Yes.
If I take you, please, to 45. Not asking about overseas visits, which is what we see here, but rather about, if you see the explanatory note in italics at the bottom, can you see that the last thing that is referred to is a guidance pamphlet on registration and declaration of members' interests?
Yes.
Did you ever, on either occasion that you were sworn into the House, did you ever receive a guidance pamphlet?
No.
Did you at any time during your tenure of the House of Assembly receive a guidance pamphlet?
No.
Did you hear of anyone mentioning to you or around you a reference to a guidance pamphlet?
No.
Can I take you, just jump back to page 42, please. And this is part 3, clients. You've mentioned, it refers the person completing the form back to what is called categories 1 and 2, which is directorships, and then the remuneration category. And you're asked to declare any paid employment that entails a provision to clients of services which depend essentially upon or arise out of your position as a member of the House of Assembly. And I won't read it out, but you'll see the explanatory notes at the bottom. What did you understand this section to be targeted at?
Any paid employment that you get by virtue of being a member of the House of Assembly.
But can you give some examples? I mean,
for instance, if you are maybe doing lobbying and you're lobbying the same government that you're a part of, I think that'll fit properly here.
So if, to give an utterly hypothetical example, you were to intercede with the minister on behalf of a client of your law firm, that would have to be recorded here, wouldn't it?
I think it'd be proper to do that.
Well, there's a difference between being proper to do so and being required to do so. Well, I mean, proper. You know, you may make a declaration out of caution.
It depends, because if the intercession doesn't amount to anything, then you know, it's up to the individual in terms of their interpretation of the section whether or not they have to put it in. Certainly, if it amounts to something and you do receive the services and you're remunerated for it, you should put it here.
But it's if you look, you're being asked about clients to whom you personally provide such services. Isn't the point that if you can use your access as a member of the House of Assembly to allow a client access to a minister, for example, which access would not be available to an ordinary member of the public, that's something that should be declared here, isn't it?
Well, it depends, Commissioner. And you have to look at the nature of the relationships in the British Virgin Islands. Because many persons, for instance, who end up in political parties, in groups, in different things, are primarily friends most times before they even become colleagues of that type. So, it wouldn't necessarily follow that because somebody makes an intercession that it's being done simply because they're part of the same political party, some of the same government. They probably could have gotten the same thing done whether they were part of the government or not, depending on relationships that exist here.
It's not necessarily about the relationship between you and a member of your political party. It's about what you do on behalf of a client. What I'm suggesting to you, and I'll put it as a hypothetical, if we assume that a client of one of your businesses says to you, Mr. Walwyn, you're a member of the House of Assembly, can you arrange a meeting for me with the Minister of X government ministry?
Yes.
Because I've tried myself as an ordinary member of the public and I just can't get a meeting.
Yes.
And you are able to engineer that meeting for this client,
yes,
and it takes place. That's something that you can only do because you are a member of the House of Assembly.
Not necessarily.
Well, let's assume that if it were something that you could only do because you were a member of the House of Assembly, you'd have to declare it here, wouldn't you?
Yes.
Now, you said not necessarily. Please explain the not necessarily.
Because it doesn't necessarily follow that because you're a member and you can get a meeting with somebody who is your colleague means that it's because of the position. Because there are times, depending on the relationship that exists between even people who are part of the government or not, relationships here in the British Virgin Islands are very strong and very important. So it doesn't necessarily mean that the client will be able to get to see that minister necessarily because the person they're dealing with is a member. If that is the reason, then yes, they should declare it. But I'm submitting that that's not always the reason.
Well, in those situations where it's not always the reason, does this part of the form give sufficient guidance to the member completing?
It should give some guidance, but I think it needs to be a bit tighter. Because if you look what it says, does any of the paid employment registered in categories 1 and 2 entail the provision to clients of services which depend essentially upon or arise out of your position? So it presupposes that something should have happened. Whatever the contact or intervention would have been, should have been something material that you would have benefited from. Sometimes you may not have benefited from it. So I'm saying that perhaps the form needs to be a bit more clearer in terms of what it's trying to achieve here. That's one of those areas that caught my eye when I sat down and took a look at it.
And so stepping back from the form,
Yes.
and at the distance of some years from the House of Assembly, would you accept that that as it stands now, it does need reviewing and revising?
Absolutely it does.
In
In other areas too.
Well, can you just assist the Commissioner with the other areas which prompt concern in your mind?
If I can go, I can show you 4, for instance.
That's sponsorship, page 43.
And the interpretation of 4. And I did read the interpretation that you are giving, Councillor, to it. And I think that there's a misdirection somewhere. If you read what 4 says, 4A says, did you benefit from any sponsorship before election, where to your knowledge the financial support in any case exceeded in aggregate 2,500? Before election could be 4 years before, could be 3 years before, but it's being interpreted as during, when the form does not say during. It should either say before and during or during. So again, that's another weakness of the form, I think. So I guess some work needs to be done on it as we move along.
What do you, leaving aside the wording, what do you think 4A is targeted towards? What is it asking a member to declare?
It's asking a member to declare any sponsorship, whether in money or kind, that they would have received before election or before an election cycle.
Again, and what do you take to mean? What does sponsorship cover for you?
With the monetary, or as I said, in kind.
So it includes donations of some one
Donations,
sort.
yeah. Donations is one.
Could I quickly just move on to another topic, which is something on which the Commission now has a great deal of evidence, but I want to take you back to your experience as an elected representative, and that is the question of assistance grants.
Yes.
Now, hopefully amongst the loose leaf material, I think it's still there is a guidelines for processing assistance grants.
Yes.
The information that's been provided to the Commission is that these were issued between 2003 and 2007. During your time as a territorial representative, did you have access to these guidelines?
Yes, I did.
And how soon after taking office were they sent to you?
I can't recall, but as far as my memory goes back, I knew of them and I read them.
We've been told that as a territorial candidate, you would have $150,000 a year.
Yes.
Now, and that in terms of the process, and please correct me if this is not your recollection and doesn't match what you did, but applications will be made to you.
Yes.
You would have to carry out a due diligence exercise.
Yes.
And make an assessment of the merits of the application.
Yes.
If you approve the application, it would go to the clerk to the House of Assembly.
Yes.
If it passed beyond the clerk of the House, it would go to the Treasury Department to issue the funds.
That's correct.
But in your experience, did the clerk to the House ever send back an application to you with a query?
I think so, but a couple of times I think it may have happened.
And what sort of queries were raised?
Perhaps if she required more information from persons, because you don't just send the form and you have to put the documentary evidence with it to support what the need is. And then there have been times, I think I remember once or twice, where somebody may have submitted to other members, trying to perhaps get help more 2 or 3 times, and it was sent back.
And did the Treasury ever send anything back to you?
Not to my knowledge, no.
Now, is this right, that these guidelines are, in effect, the only guidance that is given to honourable members as to how to distribute this money?
It is.
And so would this be a fair assessment that it falls down to you, it falls on your shoulders as an elected representative to assess the merits of an application and decide one way or the other whether it will go forward?
Yes.
And so you are exercising a discretion as to whether someone will receive a sum of money or not, aren't you?
One that you should exercise properly.
And this is the guidance that you have to make sure you do exercise that properly.
In addition to your conscience, yes.
You'll see at 10 that there is reference there to district offices expenses relating to rent, staff and operating expenses are allowed up to a maximum of $24,000 per annum. So it would seem from within that amount of money, you could take some running costs as a as an elected representative. Is that right?
For your office, yes.
And did you ever do that?
No, I never did.
Sorry, your voice dropped again.
I never did.
Thank you. One final matter, please. The Commission has heard evidence about Section 67 of the Virgin Islands Constitution,
yes,
which put, I hope, fairly, but in summary, allows for the House to vote to exempt a member from the requirement to vacate his or her seat.
Yes.
And it's a decision for the House. They may say yes, they may say no. That's right, isn't it?
That's correct.
And it arises in connection with government contracts.
That's correct.
During your time as a member of the House of Assembly, were you ever the beneficiary of an exemption under Section 67?
No, I was not.
Did you ever seek such an exemption?
No, I was not. No, I never did. Sorry.
did you ever vote in favour of motions to grant others the exception?
I can only remember one. And to be quite honest, it was not necessary to bring it to the House of Assembly.
And why wasn't it necessary for it to be brought?
Because it was an arrangement with a statutory cooperation.
And that falls outside the
It
ambit.
falls outside. Section 67 is clear on that, I think.
And so you have a recollection of one during your entire tenure in the House of Assembly?
Just one I can recall, yes.
And in terms of what information was available to you as a member of the House to make that decision, what were you provided with?
I can't remember, but I know there was some documentation that we were given to understand what was being done. On the surface of it, from what I saw, the member was perhaps given more of community service than actually making any money from it itself. Yes.
And so was it something that you could only decide on a case-by-case basis?
I'm sorry?
Was it something you could only decide on a case-by-case
Yes,
basis?
with the requisite information to support it. Yes.
Commissioner, those are my questions. Can I conclude by thanking Mr. Walwyn for coming and giving his evidence, and also for the way in which he has done so?
Yes, and can I echo that? Thank you, Mr. Walwyn. Thank you for your time, and thank you for the way in which you've given your evidence, which has been very helpful.
Thank you.
Could you rise for 5 minutes so we can reset for the next witness?
Yes, thank you. Skelton. I'm sorry that we've kept you waiting, but we are now ready to take your evidence. Thank you very much. Yes, Mr. Rawat.
Commissioner, our next witness is Mr. Ronnie Skelton. Could I ask that he be asked to either take the oath or to affirm?
Yes, thank you.
Good afternoon. Would you like to swear an oath or make an affirmation?
Affirm.
If you could turn the piece of paper around. Thank you.
I duly, solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much.
Thank you, Commissioner. Mr. Skelton, thank you for coming to give evidence today. Can we start with some formalities? First of all, could you give the Commissioner your full name, please?
My name is Ronnie Skelton.
As I've told other witnesses, I do try and keep the questions short and simple. It doesn't always work, but so if at any time you would like me to repeat or rephrase a question, please don't hesitate to ask. You'll see that there are a number of bundles on the table in front of you. We don't need to look at all of them. We might not need to look at some of them. But what I'll do is I'll take you to the documents as we go through. One of those bundles carries your name, but it should match the bundle that you've already received. So please use whichever one you want to.
Okay.
The last thing to remind you of is to ask you to keep your voice up and to speak slowly. The microphone that's positioned in front of you does not amplify your voice, it just records. But it is important that the stenographer can hear you so that your answers are clearly and accurately recorded. Could I ask you, first of all, to begin by giving an outline, and this is a question I've put to others, an outline of your professional background before you came into politics?
It's a long time. Anyway. I graduated from Tuskegee University in Alabama with a degree in electrical engineering with high honors. So I am a chartered electrical engineer by profession. I worked for the Electricity Corporation in different capacities, culminating in the general manager of BVI Electricity Corporation. How did I get into politics? I got ill and I was planning to retire, and my friends think that I had a set of skills that I can use to help my country develop. So we formed a political party, and that's how I got here.
And was that political party the National Democratic
The National
Party?
Democratic Party.
And is it right that as a member of the National Democratic Party, you were elected in 1999 to the Legislative Council?
Yes, I was.
And you remained in legislative politics until 2019, is that right?
No.
Go on then, correct me.
I was elected in 1999 and again in 2003. In 2007, I was fired in 2007. I came back in 2011. I hope I got it right, 2011, 7. And then I remained at 1999 and was fired again.
By legislative politics, I meant as an elected representative rather than being in cabinet government. So I think from 1999 through to 2019, were you an at-large representative?
I think I'm misunderstanding your question.
Sorry, let me try and take you through your career, and you tell me if I've got it wrong. So in 1999, you're elected as a territorial member to the Legislative Council.
Yes.
And then in 2003, you were re-elected.
Yes.
And at that point, you became Deputy Chief Minister and Minister for Finance, Health and Social Development.
Yes.
You then were in opposition between 2003, 2007.
No.
You left politics.
I was
entirely.
a private citizen.
I see. Well, we found one fault with Google then.
Okay.
So 2003, 2007, you stepped out of politics.
2007 to 2011.
2007.
You were not elected.
I was not elected.
Yes, that's right. And then when you returned, were you re-elected in 2015?
2011, I was re-elected.
I see, right. And did you become a member of the cabinet then on re-election?
Yes, I was.
And did you remain in cabinet in the 2015 administration?
Yes, I was.
But is it right that in, I think, November 2018, you left cabinet and you left the National Democratic Party?
Yes, I did.
And you then formed the Progressive Virgin Islands movement?
Yes, I did.
And it was under that banner that you contested the 2019 election?
Yes, I did.
But you yourself were unsuccessful in that
Yes,
election?
I was unsuccessful.
The issue, one of the prime issues that the Commissioner has been taking evidence on is about the Register of Interest Act 2006. Now, although that was an act in 2006, it didn't come into force until February 18th, 2008. And under the provisions of the Act, an ordinary member of the public cannot come in off the street and inspect the Act.
Yes.
It's only in very limited circumstances that it can be inspected, the register can be inspected rather than the Act. Now, you were, for most of a significant period of time, a legislator,
Yes.
including from the time that the Act came into force. What was your view?
No, I was not when that came into force.
Yeah, fair enough. I'm trying to take it shortly.
Okay.
From 2011, certainly,
Yes.
when, after the Act had come into force, you were in legislative politics.
Yes, I was.
And from that time, did you have a view about the merits of making the register open to public inspection?
Yes, I had a view, but we never get to the point where what the register will be, what will be the content of it. There is some concern that I have making members' information public. It all depends on the content. What we provide now, I don't have a problem making it public.
On the form as you had to fill in at that time, that did not cause you problems making
That did
it
not cause me problem based on what I understand it to.
require.
Yeah.
But your concern is that a circumstance could arise where if more information
Yes.
were required,
Yes.
there would be risks associated with
Yes.
that. And what sort of risks do you anticipate, Mr. Skelton?
Again, it depends on the information that is required. If you require a lot of financial information, then it opens families to all sorts of, want a better word, kidnapping, so to speak. People holding your family ransom for all sorts of reasons. So I would be worried about that.
So taking that forward, and bearing in mind the form that you had to fill in, but do you think that there would be a benefit then in giving clear guidance as to what information is actually required and what shouldn't be declared?
I would say yes.
Now, taking it from 2011, when you returned to legislative politics through to the time that you left, were you aware during that time that the Act placed you under an obligation to make a declaration of your interests as of the date you were sworn into office?
No, I was not.
Did you at any time become aware that that was the obligation on you?
I was not either.
Were you aware that as well as doing it on the date that you took your oath, you also had to do it on every subsequent anniversary?
Every subsequent anniversary, I understand that.
That you understood?
Yes.
Were you also aware that under Section 7 of the Act, if you didn't file a declaration within 3 months of the date that it was due, then the registrar had to write a report to the Standing Select Committee?
Yes, I was aware.
When did you become aware of that provision?
I think I was aware of it from the inception.
From the time that you returned back to politics?
If you go back to 2006, not for you to ask me more questions, but to clarify what you're saying. I was in the legislature in 2006 when the bill was being discussed and the bill was being prepared to move forward. So during the committee stage, there was a lot of questions asked and a lot of concerns about the bill. But it's a long time ago. I can't recall specifics.
But from that process, was it clear in your head what obligations confronted members of the House of Assembly in terms of the act that came into force?
Based on my questions at that point in time and the explanation given based on my presentation, that's what I understand that you had to do.
Can I take you through some of your forms, please?
Yes.
I'm going to do this in two parts. The first is to look at the dates on which you filed your form. But then the second is to just ask you some questions about the questions themselves that you were confronted with. If you go please to page 179 in the bundle. It's a form stamped by the Registrar of Interest with the date October 7, 2015.
Received.
Do you see it? And is that your handwriting there that gives your name and records that you're an at-large representative?
Yes, it is.
If you go to page 189.
Yes.
Is that your signature?
Yes.
And it's dated by you, is it October 5th, 2015?
Yes, it is.
Now, the due date for that form, applying the Act, Section 3 of the Act, was the 23rd of June, 2015. So you were obliged to file it by the 23rd of June, 2015. Would you accept that you missed that date?
Yes, I will accept I missed the date.
And because you hadn't under Section 7 filed it within 3 months of June 2015, you also breached Section 7, didn't you?
What else? Section 7 says it again.
Let me take you to it. You should have on your table a bundle that's headed Constitution and Legislation. I'm sorry?
If you read it, I can understand it.
All right. Okay. I'll put it into, I'll take you to, I'll read you Section 3 first of all. So Section 3 says, a member shall make a declaration in the form set out in Schedule 1, which is the form that we've been looking at, on the date on which he assumes the function of his office, and on each subsequent anniversary of that date. So that's obligation 1, do it on the date you assumed office. And then there's obligation 2, do it on every subsequent anniversary. And that's Section 3. So if you don't comply with that, you breach the Act. Section 7, and it's Section 7A, says that where a member fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued, the member shall be in breach of the provisions of this Act, and the registrar shall, within 14 days of the knowledge of such breach, submit a report of such breach to the committee. And that's the Standing Select Committee that deals with the Register of Interest. So that's a second way in which you can breach the Act or not comply with it. So with that explanation, because I'm going to suggest because you dated yours on the 5th of October, you were 3 months after, over 3 months after June 2015, and therefore you were in breach of Section 7.
What time in October? What time in June it was?
23rd of June 2015 was the first meeting of the House. So that's when you were sworn in.
Yeah.
If it helps you, that's the date that applies to all of the declarations that we have for you. So or at least in 2015, you didn't comply with section 3 and you were in breach of section 7. Do you accept that?
Yes, I accept it.
If you go to your 2016 declaration, you'll see it at page 168. It starts there. That's stamped by the registrar July 26, 2016. Do you see that?
Yes.
But if we go to page 178, you've signed that, haven't you, that page, and you've dated it June 8th, 2016. Is that right?
Yes.
So it would follow that you filed ahead of the due date in that year, didn't you? Because the due date was the 23rd of June. So you filed on the 8th of June.
No. Yes, I did.
If we go to your 2017 declaration, that's at 157. Again, stamped by the registrar. She's put the date on there of 1st of August 18, and it carries your name on it. But if we go to 167, which is the last page of this particular declaration, you've signed it, haven't you, Mr. Skelton?
Yes.
And you've dated it in your own hand, June the 3rd, 2017. Now, can you explain the difference between dates? You're dating it 3rd of June 2017, and the registrar's dating hers the 1st of August 18.
Yes, I can give a simple explanation. The Register of Interest, she sent out these forms to help all the members, including myself. I will get the form and I will fill out the form because she probably sent it in advance of the due date, and I will fill out the form and I will sign it. And sometimes I forget to hand it into her. And this could be, I know a couple of times it happens. I was traveling, I was busy doing something, it ended up under the pile in the desk. And when I realized it was there, pick it up and give it to her. I guess she could only stamp it when I give it to her.
Yes.
Yeah.
So the explanation for the difference is just because although you filled it in before the due date, it just didn't get to her.
It didn't get to her.
Fine. Let's go to the last form of yours that we have at 145. This is appears to be your 2018 form. Registrar has stamped it, dated it the 18th of July 2018. And if we look at page 155, that's your signature, and you've dated it July 17th, 2018. So it got to her pretty quickly on this occasion, didn't it?
Yes.
But what's right is that because you had to file it by the 23rd of June 2018, you hadn't filed it in, you hadn't completed it in time, had you?
Yes.
Now, you mentioned that the registrar would send correspondence out. Do you have a clear memory of her sending the form out to members and asking them to complete it?
Not, I can't speak to other members, but I know, in my office, I get a package from the Register of Interest with all of this information. And whenever she sends it, I know it's something is close to being due to process. So I do what I have to do. I can't speak intelligently about other members.
Did you discuss the register of interest with other members at all in terms of completing the form and the need to do it by certain dates?
I know a couple of times I discussed it with the Premier. That if we make a law, if we make laws for other people to follow, we must also follow our laws that we make for ourselves.
Can I show you some correspondence to you? I think which you'll find that on the table there should be a folder headed. It might be labelled Governor's Disclosure. If you go to, please, go to page 99 in that bundle.
Yes.
You were there when the Act was first being discussed as a bill. The evidence before the Commissioner is that it comes into force on the 18th of February 2008. The evidence is also that from that date, the Registrar pressed for a standing select committee to be established because that's part of the necessary mechanism of under the Act. And what I'm showing you is a letter, and I showed this to the former Premier. It's a letter from the then Governor Boyd McCleary to the Premier dated the 9th of July 2014, referring to the importance of the Register of Interest legislation, the need for a Register of Interest committee. And the Governor attached a letter to you from the Registrar dated the 19th of February 2014. We'll look at that in a moment. And asked for assurances that the Register of Interest Committee will be established, and concludes, I trust that this will not be much further delayed. Now, the letter that is referred to, which is addressed to you, is found at page 97. It's dated 19th of February 2014, as I mentioned. It's addressed to you as Chairman of the Standing Orders Committee. Now, that was in the second House of Assembly, 2011 to 2015. Were you the Chairman of the Standing Orders Committee in that session of the House?
I think I was.
And to your recollection, were you the Chairman throughout the period?
I think I was also.
If we look at the letter from the Registrar to you, it says, Dear Sir, I write in connection with the Standing Orders Committee.
Which letter is that? No.
I'm sorry, Mr. Skelton.
Page 97.
It's 97, okay. Yeah.
Do you have it?
Oh, yes, I got it.
I'll read it into the record. I write in connection with the Standing Orders Committee, the draft Standing Orders of the House of Assembly. As you are aware, having been Chairman of the Standing Orders Committee for the period August 2003 up to March 2007, the report of the Standing Orders Committee was laid on the table of the Legislative Council of the Virgin Islands at the 48th sitting of the first session of the 15th Legislative Council on 20th of March 2007. Since then and up to present, there has been no forward motion on the report. You are also aware that the Register of Interest Act 2006 was brought into force on 18th February 2008. Simultaneously, the Registrar of Interest was appointed to, among other things, maintain and keep the register in accordance with the Act. Section 4 of the Act speaks to how the register shall be maintained and shall be in such format as the committee shall approve. Section 77A of the draft Standing Orders of the House of Assembly make provision for the Register of Interest Committee. I have no doubt that you can understand how the work of the Registrar of Interest is hampered by the non-existence of the Register of Interest Committee. Since the coming into force of the Act and appointment of the Registrar of Interest, 6+ years have elapsed. The Act is not fully operational. The Register of Interest Committee has not been appointed. The Register of Interest remain a blank book. The Virgin Islands Constitution Order 2007 and the Register of Interest Act 2006 continue to be contravened. All this is hinged on the amendment of the standing orders of the House and ultimately the appointment of the Register of Interest Committee. I now crave your indulgence and seek your advice regarding the appointment of the Register of Interest Committee. This was sent in 2014, early 2014. Is it right that a report in relation to the Standing Orders Committee had been laid before the House and was still there without forward motion as from March 2007?
I honestly can't recall, but I know the Committee for the Standing Orders made to the standing orders. I don't recall, I will have to go back and look and think about it, whether or not, you know, I can see the election process overpowering anything on the table of the House. And I don't think it was a deliberate act that at that point in time, the standing orders amendment that were being requested were not approved. But again, my recollection, I will need to go back and think about this. I know, I remember the letter, now that, and the Register of Interest know that I was one of those people who want to make this process happen. So, and I think the committee, the amendment was made, but I don't remember exactly when the amendment was made.
You will have, we can give you a range at least. You will have amongst the loose papers in front of you, probably just underneath your folder there. Amongst those is a resolution of the House, number 3 of 2016. The Standing Select Committee was first established on the 25th of April 2016. Mm-hmm. And so, and to give it further context, Mr. Skelton, the registrar on the totality of the evidence that the Commissioner has received was pressing for this committee from the beginning of her appointment. And she appeared, as we canvassed with the previous witness, before the Standing Finance Committee, and it was a point she raised, amongst other matters that she raised. Can you just, it might be said that to go from 2008, when the Act comes into force, to 2016, that length of time, which spans more than one House of Assembly, taking that amount of time to get the standing orders amended and establish this committee was a sort of inexcusable period of time and an inexplicable period of time. Can you give the Commissioner some insight into why it took so long?
All I can do at this point in time is, I was the chair. I apologize for the inaction, because I know when I got this letter, I think the election was shortly held, so it went to the next administration, which I was a part of, and then by the time the committees were formed and get moving again, we addressed this matter. There's no excuse for it really that I can come up with, you know.
Because I think Ingrid Moses-Scatliffe, who was the speaker
At this time, yes.
at that time, told the commissioner that the standing orders, as they were, had last been revised in 1976. Was that your recollection?
No, it was not.
Well, prior to you becoming chair of the standing orders committee, and then undertaking a revision, when was the last time, to your recollection, that the standing orders had been amended?
There were some minor amendments to the standing order. I can't recall exactly when, but before the major amendments, there were some minor amendments to the standing order. And I don't recall exactly the dates and the times.
Would one possibility have been for the Standing Orders Committee to have made an amendment and laid it before the House just in relation to this standing?
Yes, that's exactly what I'm thinking. A resolution that need to come to the House to amend the standing order just to reflect that one provision.
Was that ever considered as an option whilst you were the chair of the Standing Orders Committee?
I think it was, but the members wanted some amendments to the standing order, so we had to go through a long process. But this one provision could have been, like you said, would have taken a resolution to the House and get it approved. Now, Mike, I don't know why it wasn't done.
Can you confirm this, that once a select committee is established, in this case, we're looking at the Register of Interest Committee, is it simply down to the chairman to decide how often that committee meets and what work it does?
Not necessarily, no. It's down to the members.
Of the
The
committee
chairman
itself?
doesn't have any special powers except to convene meetings and make sure the meetings are run in an orderly way.
Now, when we've looked at the letter of February 2014 addressed to you, can you recall what discussions, if any, you had with the Registrar of Interests at around that time?
No, I don't recall.
If you go back to page 99, it's not a letter that copied to you, but it's the letter I started with, which is the memorandum from the Governor to the Premier in July 2014, so a few months later than the letter addressed to you. Do you recall if in July 2014 you had any discussions with the then Premier about establishing a Register of Interest Committee?
No, I don't.
In terms of you've explained that you chair the Standing Orders Committee, but whether or not you could take the quick route of making one amendment that comes before the House, or the longer route of sorting out all the necessary amendments, who decides that?
The House of Assembly is made up of 3 leaders: the Speaker, the Premier, and the Leader of Opposition. The Premier normally determines government business. And it's basically the Premier and the Speaker mix up the agenda of what will be on the next meeting.
But could you, as chair of the standing committee, have determined by yourself that the committee would approach the standing orders in a particular way? Could you have sort of rule in effect?
Not by myself, no.
And would it depend on a vote of the members of that committee?
Yes, it will.
Thank you. You said that the registrar knew you as one of those members who wanted this system in place.
Yes.
Were there alternative concerns or opposition voices at that time to putting this in place?
No, I don't think so. I don't think there were any opposition. I think the format, the final format of what is in the register of interest, I think most people had their own opinion. Not that they did not agree for the register of interest and its committee to be in place. No, I don't think that there was any dissenting voices.
So that it wasn't your impression that there was resistance to moving it forward. It was just that it took an awfully long time.
Yeah.
Could you turn to 145 in the bundle, please?
In which book?
In your bundle, the one of papers relating to you.
145.
I just want to ask for your assistance just now in terms of how easy you found the form in terms of what information it was asking you. You were by some stage, you would probably be described as a senior member of the House of Assembly. Did other members approach you for guidance in relation to how to fill in the form?
I think they would have asked questions.
And I appreciate it's a few years ago now, but what sort of questions were being raised about the form?
Probably what does this mean and how do you go about filling it out? The questions were mostly general questions. But one thing they know they had to submit this form within the, as provisions of the Act prescribes.
So from your time in the House of Assembly, whilst there may have been uncertainty about what information to provide, there was no uncertainty about when it had to be provided by.
I don't think it was uncertainty when it was supposed to be provided by. I know there is the provision you read where you had to submit it on the date of election. I think that no one realized that. It's basically a practical provision. You know, if it had said 21 days after you're sworn in or something like that, it makes more sense. But on the day, it doesn't. I think that's one of those mistakes that was made in drafting. I don't think it was a willful that members did not want to do it.
And what did you take to be the purpose of the form? What was the point of making a declaration?
The point of making a declaration is so that the public, if the need arises, will see what you had at day one, and 10 days after, whether or not you have been abusing your position of power to amass riches. I think that's what it's trying to do.
If you go to page 151, you'll see there, it's not the reference to overseas visit that I want to draw your attention to, Mrs. Skelton. Do you see that this wording in italics, which begins with the word note? Can you see at the tail end of that paragraph, there's reference to a guidance pamphlet on registration and declaration of members' interests?
Yes.
Did you, in your time, and this would probably be from 2007, did you ever receive a guidance pamphlet?
No.
Did you ever hear of one
No, never.
being in existence?
No.
Did any member ever ask you, have you seen a guidance pamphlet? If you could just go back to page 146, please. Now, if we look at 146, under directorships, you've listed, and you gave the same information throughout your declarations, but you've listed directorships as Skelton Quarry Limited, Skelton Concrete Products 2010 Limited, Skelton Development Limited, Skelton Properties Limited, Skelton, is it Baylot Limited, and then CRC, a retail company. Now you list them under directorships. You also list some of these companies under number 2, remunerated employment, which is whether you're remunerated or you have a pecuniary interest. And you also list them under shareholdings.
Yes.
Now, were you clear in your own mind when you were filling these forms that information about the same company or interest might have to be put in different parts of the form?
Repeat it again.
What you've done is, in relation to the interests you have, you've declared them as a director, as a source of remuneration, and as a shareholder.
Yes.
When you approached the form, were you clear in your mind that the same interests might need to be referred to more than once?
Based on the form, yes.
Yes, because you could be a shareholder in a company and also be a director.
Yes.
And for you, there was no ambiguity about that.
Not to me.
Now, if you look at page 156.
156.
Yes, because we're looking at your 2018 declaration. One of the things you provided, at least in 2018, to the registrar was the declaration that you have to give when you stand as an election candidate.
Yes.
Why did you decide to do that?
Well,
Yes.
to be abundantly clear that there was no, I just wanted to, beyond any reasonable doubt, that this is my life.
When you cross-refer, you refer to some of the interests that are on your election notice in your thing, but you don't refer to all of them. So, for example, Skelton Investments Limited or Skelton Enterprises Limited and P and 3R Company Limited don't appear in the form itself. Was there any reason you decided not to do that?
Skelton Investment and Skelton Enterprises Limited are kind of dormant companies, so I didn't. But yes, this should have been on the form.
But taking it more widely, if you have dormant companies, do you think that the form could benefit from making clear to the person filling it in whether dormant companies ought to be declared or ought not to be declared?
Yes, the form could be more explicit.
If we go, please, to 153. That's the section you have to fill in on land, and you're asked, do you have any land other than any home used solely for the personal residential purposes of you or your family?
Yes.
Firstly, did you take that to mean that there was no need to mention your own residential home?
Yes.
And did you take it to mean to be directed to land that you yourself owned rather than your spouse, for example? Or did you read it more widely than that?
I thought it was land that I have an interest in.
Any land that you might have an
Have
interest in.
in.
I see. And so what you've declared is a commercial property in the valley in Virgin Gorda, estate in Great Mountain, Tortola, and then a timeshare in Mexico.
Yeah.
Now, in relation to the last of that, was it your understanding that it wasn't limited to interests in land in the BVI? It was wider than that?
Again, no, I thought it was just land wherever you own it. Property wherever you own it.
Right. Could you just go to 155, please? It's miscellaneous, which says, bearing in mind the definition of purpose set out in the introduction to this form, you have any relevant interests which you consider should be disclosed, but which do not fall within the 9 categories set out above, please list them. What did you think the point of this paragraph was? What was it asking you to do?
That's a good question. Now that you ask it. I can't say I do.
Do you think then, looking at it, that it as a paragraph, it's unclear about what it's expecting a member to declare?
Exactly. I think that's correct.
Other parts of the form refer to your spouse, they refer to you, they refer to your minor children. If you read this, it refers to relevant interests. You have any relevant interests which you consider should be disclosed. Would you read that as being directed to interests that you yourself have, or interests held by your immediate family?
During the committee stage of the bill in 2006, a lot of questions were asked, and if the verbatim reports could be had. The whole discussion around the Register of Interests bill, which became an act, members were extremely concerned about exactly what needs to be on the forms. And one of the things I am noticing with the questions being asked is that some of the concerns that were raised back then and approved by the House at that point in time could have been lost in translation, because members never get the bill back to see what it was. What was the final document before us, the governor sent it. So I have some questions that were questions back then, but it seemed that the amendments were never made, so to speak. This clause could have been lost in translation based on the advice given to us by the drafters and the Attorney General of the day. There's some drafting concerns that needs to be addressed.
So distilling that down and stepping back, is it your evidence to the Commissioner that the form does need looking at again?
In order to be more specific, after 86 now is what, 13 years? It's overdue for amendments.
Can I turn to another matter? You sat in Cabinet.
Yes, I did.
during your time in Cabinet, what was the process for declaring an interest in any item on the agenda?
The process was for members to declare an interest. If something came to Cabinet concerning any close friends of mine or family members, I will declare the interest and walk out. Not that I have an interest, but I am closely associated with these people. It's a small country, and you know, I came from a family of 8 aunts and uncles, 11 brothers and sisters. I have hundreds of nieces and nephews. My family is huge, and so most people are related. So, and we do talk to each other. But if I ask my families for information to put on this form, I think I will not get the information. So we have to be measured in the information we're asking for.
But turning it to what you have to do if you're a cabinet minister and you've got to declare an interest in cabinet, accepting that the wider family exists. Where did you personally draw the line? You said if I had family members or close associates, but what criteria did you
Close friends.
So if you had a close friend who was a potential appointee to a board, in those circumstances, would you declare an interest?
If the friend has the skill set to be on that board, I will say, this is my friend, and I will stay. I'm talking about monetary remunerations and all that stuff like that. But to sit on the board, and he's properly qualified to be on that board, I don't think I'll declare it and stay.
What about family members? Given that you have, obviously, as you said, a large family, where did you draw the line in terms of declaring an interest?
Children, my wife, probably my brothers and sisters, depending on what is happening.
So after your wife and your children, at that point, would you just make an assessment based on the particular circumstances?
Yes.
Thank you. The next topic is that the Commissioner has been hearing evidence about the operation of Section 67 of the Constitution of 2007. And what that does is that it allows, in part, the House to vote to exempt a member of the House of Assembly from vacating their seat.
Yes.
So it could be in circumstances, for example, you have a contract with government. During your time in the House of Assembly, were you ever exempted from vacating your seat?
No.
Did you ever seek such an exemption?
No, I try not to do business with the government.
Commissioner, I've reached the end of my questions. Can I conclude by thanking Mr. Skelton for coming this afternoon to give evidence to Commission and for the way he has done so. Thank you, sir.
Thank you.
No, and can I echo that, Mrs. Skelton? Thank you very much for your time, and thank you for the manner in which you've given your clear answers.
Thank you.
Thank you very much.
I can go back with this. I'll leave it.
If you wish to leave it, you can do so.
Thank you, Mr. Skelton.
Thank you very much.
Now we're due to hear some legal submissions.
Yes. Could you rise for 5 minutes so we can reset the room?
Certainly. Thank you very much. Good. I think we're ready to proceed. Sir Geoffrey, as I said, welcome back. I know there are others representing other participants here too. Perhaps, Mr. Rowett, you can read those into the record.
Yes. As you know, Commissioner, you listed a session this afternoon to hear legal submissions in relation to the evidence that you've received over the last few days, on, in particular, the Register of Interests and the compliance with the 2006 Act by current members and former members. This afternoon we have representing the Attorney General and also elected ministers, Sir Geoffrey Cox QC, together with Lauren Peaty of Withers. Mr. Lewis Hunte QC appears on behalf of Dr. Kedrick Pickering, and we also have with us Mr. Archibald Christian, who appears on his own behalf.
Yes, welcome, Mr. Hunt. Welcome, Mr. Christian. Thank you. Now, perhaps, Sir Geoffrey, I can address you first.
Yes, of course.
We've heard evidence over the last week from various current and former members of the House of Assembly on a number of matters, including things like the form of the declaration and the assisted grants scheme. But really, the legal submissions that I would benefit from, I think, relate to criticisms, particularly criticisms of individuals as opposed to systemic problems. And I think this is right. I'm sure that you've been following the...
As much as I can.
Yes, exactly. But I'm sure you have been instructed as to what's been said in the evidence over the last week. And generally speaking, there are one or two exceptions, but literally one or two. Most of the members, firstly, appeared to be in breach of Section 3 by not filing on the due date. Just in brackets, that seems to me to reflect Section 112 of the Constitution, which imposes the same duty. And many of them also accepted that they were at times over 3 months in breach, which triggers the sanction in Section 7 of the 2006 Act. So those breaches were very frankly accepted by most of the members. And we have a schedule of them as we've taken them from the evidence, including the evidence of today. And really, it's the approach to those criticisms, those breaches, that I would like to hear legal submissions on. I mean, perhaps first from you.
Well, I'm very happy, Commissioner, if you want to. I'm equally happy to defer to Mr. Hunt, who's a very distinguished local practitioner. So I'm in your hands, really.
Well, we don't want to fight, Sir Geoffrey. So I'm happy.
We don't want to fight to let somebody else go first.
I'm very happy for you to go in whichever order that you feel most appropriate.
Commissioner, I prefer Sir Geoffrey.
And then I'll hear from you, Mr. Hunt, after Sir Geoffrey.
Let me accept the challenge. May I say straight away that I would like to develop the submissions as a whole. So I will, if I may, get to those parts, I think, in which you're most interested, but there are certain matters that I'm instructed.
Just one minute. I think it may be feedback?
Good to go. Right.
Thank you.
There is a context which I'd like to supply.
Yes.
And I think it fairly ought to be supplied. So let me begin by saying to you, if I may, that those I represent, I think, accept entirely that it is central to the democratic idea that the purpose of elected office is to serve the public. It is not to enrich the office holder, and it is not to enrich the office holder's personal connections. And members should not use their position plainly to influence the legislative process for their own advantage or for someone to whom they are connected. And for this purpose, as you know, sir, many parliaments, most frankly in democratic countries, have now provided for members to make periodic returns of pecuniary interests to be recorded in a register. And the purpose of that register is to strengthen public trust and confidence in parliamentary processes. And those I represent fully accept that principle. But let me commence, if I may, first by orientating ourselves as to the nature of the inquiry that you've been undertaking in the last few days. Let me state it in case I got it wrong, because I'd invite correction. We understand the relevance of the recent inquiry into members' interests and of the submissions I make to you today to be to the commissioners your duty to inquire into and make recommendations as to improvements in governance that would increase public confidence in the institutions, and in this case, the House of Assembly. The criticism seems to be, as you've been kind enough to delineate it just a moment ago, that members were late, sometimes very late, with the registration of their interests. But a clear distinction, I would respectfully submit, must be drawn between a failure to comply with the rules relating to timely registration of interests and conduct of the kind that you, sir, are charged with examining under paragraph 1 of the Instrument of Commission. And I see you nod, and I didn't expect, if I may say so, anything different. That conduct is, of course, confined to criminal wrongdoing. One can debate whether it fits perfectly within any criminal offense in this jurisdiction. One could argue that it would. But certainly it is conduct of a character of a wholly different nature and character to that with which we are dealing today. Now, the statutory sanction, sir, for the failure to make timely registration is, of course, that the registrar would submit a report to the Standing Select Committee of the House of Assembly, charged for the time being with the consideration of matters relating to the register. And the committee must then, by statute, meet within 21 days of the submission of the report, and then may, in their discretion, direct the member to remedy his defect within a maximum of 28 days. If the member fails to comply, the committee must report to the Assembly, which must debate the report within 14 days of the report. And the House of Assembly may fine or suspend the member for up to 2 consecutive sittings. Now, so addressing section 3, without taking you directly to the statute, but we can look at it in a moment if we need to, I would respectfully submit that there is a potential issue relating to section 3 because it seems to have been drafted from the point of view of a sitting member at the time of its enactment. Because if you recall, the section reads that within 30 days of the act coming into force, there must be a registration, and then thereafter at every election. Now, practices vary, but legislatures invariably, I've not been able to discover a single one that hasn't thus far, allow some time for submission to the registrar of interests of newly elected members. The House of Commons allows 1 month. I think the Parliament of Australia allows 28 days. One can look through the Commonwealth and find no jurisdiction easily, I haven't discovered, but your team may look, discover one that requires mandatorily registration on the first day of the election of the member. My submission is that it makes no sense to require the registration on the day of being sworn in. It will inevitably place an arguably unreasonable burden on the member. A newly elected member who may not at the time of election even know of the obligation will have many unfamiliar responsibilities and demands on their time. And as the Honourable Flax Charles observed, it is nowadays usual in many Commonwealth legislatures, if not all, and the BVI is, of course, a member of the Commonwealth Parliamentary Association, for induction and training sessions to take place, some of which specifically deal with the registration of interests. And in addition, the registrar will often hold individual meetings with newly elected representatives to assist and answer questions and give guidance about how they should meet their obligations in what is to many a complicated subject. The absence of such features, I would submit to you, is a flaw in the system under your inquiry.
Could you just give me one
Yes.
moment, because I'd like the statutes, please.
May we return to it in a moment? I'm going to address it
Yes,
step by step.
but I know that I'm going to need them.
Yes.
Just to confirm one point.
Yes.
But if you're going to deal with this later, tell me. You've referred to paragraph 3, but in the Constitution, paragraph
112.
section 112, that imposes, it's really an amalgamation of subsections 2, 3, and 4, but it imposes a duty. It shall be the duty of any person to whom this section applies to declare to the registrar, etc., etc. 3 is a person shall make that declaration upon assuming the functions of his or her office, and at such intervals thereafter being no longer than 12 months as may be prescribed by law. Now I mean, I understand what you say about the practicalities, but that's a duty to make a declaration on the day.
Well, it's a question of construction. Commissioner, of course, if you take that view, then it's a matter entirely for you.
But
my submission, well, my submission on this is that the better view, if not for pragmatic reasons, it seems to, with respect, I would submit, if you force a newly elected member to make registrations on the day, he or she may not know she's going to be elected. They may not even know of the obligation. You may say what that should require is a program of education to candidates. But it doesn't happen even in the United Kingdom.
But when you say on the day, this isn't on the day of the election.
It's on the day of being sworn in.
Yes.
Exactly. But forgive me, that not much happens to a newly elected member of parliament after he's just been elected between having the writ handed to him and turning up. You don't get much induction or training in that period.
I understand that,
Yeah.
but just looking at the Constitution as opposed to the practicalities, just looking at the Constitution, what can be clearer than a person shall make a declaration upon assuming the functions of his or her office? What can be clearer than that?
Well, I would argue that one has to read it together with sections 3 and 7. And section 7, and I'm not going to develop an analysis that you won't have already considered, but the express reference in section 7, which you will have, I hope, before you, but where a member, and for this purpose, let's just look at 7A, fails to make a declaration within a period of 3 months from the date on which the duty to make that declaration accrued.
Just pausing there.
Yes.
Section 7 doesn't impose any duty.
No, what it does is declare the consequence of not making a declaration.
It declares the consequence, or it
Yes.
outlines a sanction.
No, it doesn't just outline a sanction, it declares the consequence. It says the member shall be in breach of the provisions of this act. Then it describes a sanction.
But 7A, first make a declaration within a period of 3 months from the date on which the duty
arose. Yes.
Says the duty arose under section 3.
Yes, but there's no reason why a statute shouldn't consider you a breach only after a particular period. The duty arises and is a continuing duty, it goes on beyond 3 months.
Yes.
But the Act has adopted the policy of saying you will only be in breach if you are 3 months late. Now, it seems to me that that is a perfectly legitimate policy for the Act to adopt. And if it weren't that policy, why would it adopt the language of saying the member shall be in breach? You could say, well, he's already been in breach. It's saying it, and I submit this is the better view, it's saying it because what it is saying to the member is you have a duty the moment you assume your office. But after 3 months, you will be considered to be in breach.
I'm sorry, I mean, I'm sure it's me. I simply don't understand that. You have a duty to, under the Constitution, and the Act can't override the Constitution, you have a duty to make a declaration upon assuming the functions of office. That's on the date you're sworn in. That's when your duty arises. If you don't comply with the duty, you're in breach of that duty.
Well,
forget about Section 3 and Section 7.
Well, if you refer to the Constitution, then, and I'm not saying for a moment, Commissioner, if I may say straight away, that the matter is not interpretable in the manner in which you say. The question is, what is the better view? Having in mind the purpose that the Act is designed to achieve and the Constitution, yes, normally I grant you, if I may put it that impertinent way, I concede is the better way of putting it, that usually the expression upon doing something means at the time or immediately after doing it. But what the Act does, in my submission, is further define what is meant by Section 112 and what it means to say, and this was clearly the way that some of the witnesses had interpreted it before you, whether they were right or wrong, which is that they would only be considered to be in breach of the Act, for the purposes at least of any sanction, if they transgressed Section 7 and were 3 months.
Yes, and we can check the transcripts. There's certainly one witness today.
There was certainly one, I think,
one today,
who said it, and there may be, I think, one other, and forgive me for not having known that. And I don't propose, if I may, to individualize these sections.
But Sir Geoffrey,
I can only leave it there, Commissioner.
But let's say that let's say that these statutory provisions have more than one interpretation, that they're ambiguous. Does that hugely matter for my purpose?
No, and that's what I'm going to come on to say, if I may. The point is, what I would submit is that having regard to the reality of a new member's experience, having regard to the practice of other legislatures, which do allow time, the scheme and policy of the Act was probably intended. I grant that there are problems that exist on this interpretation, but I submit it's a tenable one, was to say, you have a duty the moment you enter into your office, but if you have not done it within 3 months, you will be considered to be in breach. That's the meaning. That's the meaning of saying shall be in breach. It's a tenable interpretation. I grant it may not be the one, sir, that you would have preferred either today or when you were sitting in the Court of Appeal, but it's certainly a respectable argument, because it doesn't make sense to place a member in the invidious position of facing such moral obloquy as attracts to being in breach at 1 minute past midnight on the day of their being sworn in, when the complexity of their registrations could be quite considerable, when it may depend on third-party inquiries, when it may require advice. The practicality is such that the scheme of the Act must, I submit, whether felicitously worded or not, have been intended to allow a period of time for the members to make those registrations, whether or not, as a matter of literal construction, you prefer my submission or you adopt the position that you have adumbrated so far. But I need to move on from there.
Yes.
Because perhaps it doesn't matter very much. I was made aware of the observations you made to the Honourable Carvin Malone earlier about constitutionality and the importance, perhaps the elevated importance, of observing a constitutional obligation. My submission is that there may very well be some such moral importance, but frankly, the ignoring of a statutory obligation is an important matter in itself, and particularly if you're a public officer, elected or otherwise. And I'm not here instructed on behalf of those I represent to say anything different. So may I move on to this? What I have submitted, and I leave it in your hands, if I may, to determine that the better view of the legislation may be, even if this requires a purposive approach to it, is to regard a member only being in breach once Section 7 is triggered. And for the reasons that I've given, that frankly, Practice all around the world is to allow that time. And it really does place a member in a very invidious position indeed. As I've said, the House of Commons allows 28 days. And there is a programme, as I shall describe in due course, of quite intensive these days, familiarisation and training.
But in the UK?
In the UK.
Yes.
Now, in the case of many past and current members of the House, as I've just said, the registrations were much later than 3 months. And while most members newly elected in 2019 appear to have made efforts to comply, I speak perhaps of the Honourable Flax Charles, the Honourable de Castro, who clearly made sincere efforts. The conclusion is certainly open to you that the system never functioned properly.
I'm sorry, which system?
The whole system of registration of interests, the Act, never functioned properly.
Well, that's not a difficult conclusion to draw.
As I said, it's clearly open to you.
Because there's no system.
No, and I'm going to come to that, if I may. We submit, I'm going to submit there are 3 possible reasons, each of which are relevant to the question of criticism for this. There can, of course, be no basis for a public servant, elected or otherwise, to ignore an unequivocal statutory obligation. Statutory obligations, however, are ignored every day in every society, from speed limits on the roads to the submission of tax returns to a whole variety of activities with which you, particularly with your experience, will be very familiar. It doesn't excuse it, but they are. And so the question to which I hope now to turn is why the statutory scheme was constituted and designed in a manner that it was, and whether it enhanced the prospects of compliance, and why it hasn't appeared to function at all or properly. Now, first, I submit, the ROIA adopted a fundamentally flawed design to achieve its purpose, rendering the register, even if it had been maintained perfectly and fully up to date, practically useless. A register that was not a useful tool for democratic purposes was likely not to be regarded as a high priority. This is simply a matter of human nature. I repeat, would you bear in mind that I have said straight from the beginning, as those instruct me accept, that there is never a basis for ignoring a statutory obligation. But what this seeks to do, what my submission seeks to do, is give you 3 reasons for your consideration as to why that system didn't operate. First, it adopted a fundamentally flawed design. Secondly, the registrar, though diligent in her attempts to chase repeatedly members through successive assemblies, appears not, at least from 2016, to have been given the appropriate advice as to what to do to enforce the Act and its provisions, at least once the committee envisaged by the Act had been constituted. And thirdly, there appears to have been no preparatory programme of education and training in the importance of a register of interests, and to achieve the culture change necessary for it to be successful. Either when the Act was passed, or subsequently for members after each election. Now the reason, and let me address those in turn if I may, a fundamentally flawed design. The register was only ever ordinarily accessible to a member on the payment of a fee. Other than a court or a criminal investigation, no one else could ever see it. No questions, I think, well, I may be wrong, whether my learned friend, Mr. Wright, has asked whether any member ever asked to see the register. I can't remember such a question, but I don't think that they ever did.
But there is no register.
Well, to see the record at least, because as I understood the evidence before you, there was a meeting in 2016 when the evidence of the witness was that the register format had been approved, but I may be wrong.
Well,
about
no,
that.
I'm sorry, you are.
Well, in that case, I'm
to assist
yeah.
Jeffrey,
Yes.
just with 2 points. The evidence is that as of 2016, that was the first point at which there was a resolution to establish the Standing Select Committee. It met in 2017. The evidence of the Honourable Mark van der Poel and the Honourable Marlon Penn was that it did not go so far. That meeting did not go so far as to establish the format of the register. And similarly, that's evidence from the Honourable Andrew Foy didn't say anything contrary. The other two members of that committee, that 2016 committee, were the Honourable Alvira Madura Keynes and the Honourable Julian Fraser, but neither of them remembered being on a committee.
Well,
can I before just, and I don't have the name, but it is one of Sir Geoffrey's clients, but there have been a number of honourable members, and certainly I could think of one of the elected ministers who have, as a result of perhaps being asked to come to give evidence, have approached the Registrar of Interest for their own documents, both for correspondence records and for their declarations, and been provided to them.
Since the inquiry? Since
the inquiry.
Yes, I have the point, but let's look at, if I may, I'm grateful for that. But
when you said there's yes, because you said there was a fundamentally flawed design, but what's the fundamental flaw?
The flaw is nobody ever got to see the register. The fact is that a register can only work if it's A, kept up to date and accurate, and secondly, somebody can see it. So that the second function, I mean, I'm saying what may be banal, but the fact is that this needs to be stated. The design of this scheme was stillborn, because only if it's a democratic tool, a register, can it ever justify its existence. Somebody needs to be able to look at it and say, but that person hasn't declared in oral debate. It needs to be able to be referred to by at least the members in debate if necessary. It needs to be able to be seen so that those can inform themselves as to whether the speeches or the votes are or are not consistent with the interests. Yes. And so I'm saying nothing that I suspect will be controversial, but I think it's important we state it. Now, what is the effect of this? My submission is that it was made extremely difficult even for a member to see it, at least on the Act, because first you had to pay a fee. Secondly, you didn't even have a right to see it. Under Section 9, the registrar had to be satisfied that the purpose of the request had been made out, that the request wasn't frivolous and vexatious, but against what standards and criteria, that it was made in good faith. How would you judge that? What is a good faith reason and what is not? That it was intended for a purpose that is consistent with the objectives of the Act. Well, those were never expressly set out. And then if she's not satisfied as to those matters, then she can decline to grant the inspection of the register at all. And she must also notify the member whose register is to be inspected. Now, all of those things presented very serious hurdles in the way of the only class of persons who could see the register, namely the members, in the way of looking at it at all. So that this register would have become some form of Dead Sea Scroll, kept in a hermetical cave, removed from anybody's sight or gaze, and certainly removed from being an effective tool for the increasing confidence in democracy.
But doesn't that mean that following Section 112, which requires a register, mandates that there must be a register, and then says that in subsection 5, there needs to be a law to implement that. So the law that implemented the requirement of the Constitution, implemented, of course, by the, well, it was really implemented by the Legislative Assembly, the House, the Legislative Council, but effectively the House of Assembly was simply ineffective.
Yes, and that's my submission, effectively.
That's yes, but it's not. I'm sure you will make it far more attractive than it currently sounds, but it's not an attractive submission because the Act, well, really the Constitution in a sense, but certainly the Act requires self-policing in terms of the register. And what you say in self-policing, the self-police men, the members of the House of Assembly, have created an Act which in terms of enforcement and implementation is fundamentally flawed
Yes.
and hopeless.
I do say that, and those I'm instructed by would entirely accept and endorse that position. The Act itself was not set up in a manner that created the incentives for it to be complied with, because frankly, it was practically useless. I mean, for practical purposes. The only class of persons who could look at it were the other members, and they even had to pay a fee. And even then, they didn't have a right, because, as I say, you had to get past the Cerberus watchdog in order to establish your right to see it. And when you saw it, of course, you couldn't copy it, you couldn't take an extract. Query whether you could take a note. I don't know if you've reached a conclusion as to that, but it's possible, I suppose. But certainly it was enforced one imagines it would be enforced pretty tightly on copying and extracts. Now, all of that tended to mean that a member who was elected, it just never was regarded as a serious system, I suspect.
No, but in terms of governance, that's an appalling thing.
Well, I'm not here, as I told you when I started, I'm not here to gloss matters that are matters of clear fact.
But it is, isn't it?
Well,
in terms of governance.
Save only, I'm coming come on to that, because you see, this is not an uncommon experience in legislatures. The United Kingdom can't boast about its performance in relation to
forget about the United Kingdom.
No, but it's important.
But what we have here, we have a constitutional obligation to have a register and to make declarations. So far, we've got to the point of, firstly, there never has been a register. Secondly, that the Act, which under section 1125 of the Constitution was intended to implement the constitutional requirements, is practically useless, which is your term.
Yes.
That's not, in terms of governance.
It was poorly designed.
It's not well.
Structurally flawed.
As I say, your term, which I think is right, practically useless.
I mean, let me carry on, if I may, because I do have some. I mean, my point is this to you, sir, is that I'm not coming here, nor am I instructed, to attempt to dress up what is clearly an unsatisfactory situation. What I'm here to do is to say to you that there are important contexts that need to be considered. The first is that the scheme that was adopted was structurally flawed. Now, if you were going to make it succeed, have any chance of making it succeed, you needed something else. Simply to introduce legislation and tick a box, so that's done, register of interest legislation, is not going to mean that that legislation embeds itself in the culture of a democratic system, unless with it you have rounded the policies to enable that statutory scheme to succeed. A full understanding of its objectives, the kinds of the induction and training of which I spoke, the attempt to make through all sorts of means the culture change necessary to embed that statutory scheme. That was never done. All that was done was that somebody had on their list for good governance legislation, register of interests. It was enacted, and it then was stillborn. Why? Because thought was not given to the informing policy context that would be needed to make it successful, and the kinds of ancillary support that would be needed to make it successful. Now, the reason I say that with respect is that it is not an uncommon experience for legislatures, even if this statute had been designed better, to take time to appreciate and internalize the importance of a register of interests. It is a cultural issue for legislators that is quite difficult for them to assimilate. In the United Kingdom, for example, while it's been the convention that a member should declare any relevant interest before speaking in a debate for many, many years, going back hundreds of years, certainly 100 or more, no resolution was passed in the House until 1974. And a register of members' interests was first introduced by resolution of the House in 1975. A permanent select committee was established in February 1976. But for 20 years, that register was treated with disrespect and disdain by successive parliaments. Famously so, you may recall, it was, I think, the Right Honourable Enoch Powell who refused point blank to register his interests on the grounds that he had not been, that it was not binding on him, the resolution of the House, that it was, he was an honourable man, that members should be presumed to conduct themselves honourably, and he declined to register his interests. And of course, many other members of Parliament did. And it wasn't until the Nolan Committee in 1995 that recommended a complete overhaul of the Register of Interests, including the Parliamentary Commissioner, the independent Parliamentary Commissioner, that a satisfactory system was installed with which all members complied. Now, if it took 20 years for the United Kingdom Parliament, the mother of parliaments, to recognize and internalize the need for transparent registration of interests, not because those inside it were dishonorable, but because they found it hard to acclimatize themselves to the new need for transparency and for reassuring the public as to the central principle I started my submissions with. It is, I submit, not wholly surprising that in this jurisdiction it has taken 13, and that without any form of training, induction, resources invested into creating the culture change necessary, members have found it difficult to comply. I don't excuse it, and none of those whom I represent seek to suggest other than that they were late with their registrations, and that those registrations, at least after 3 months, were in breach of the Act. But one does need to look at the problem here. It is perhaps not surprising when what you're asking a legislator to do is invasive of their privacy. I say not as an excuse, I hasten to add, it is simply a difficult thing for a legislator to grapple with. But once the training and induction and inculcation is performed, most members see the need for it. Now, there is one final point that I would wish to make, sir, if I may, and that is this. It seems, with respect, that the registrar decided to approach the current governor, or the previous governor, and possibly governors before him, to seek their advice as to what to do. In my submission, the best course of action at that point, in fact, the only proper course, would have been to say, take advice, probably from the Attorney General, as to what you should do. Because the Act did offer the registrar potential remedies. Once at least the committee was constituted, it would not, I submit that I take the point about the register, perhaps if the register wasn't existing, but would there have been anything to stop the registrar submitting a report? The chairman had been selected in 2017, the committee had been selected, the standing orders by then had been changed to constitute the committee. If the registrar had then submitted the report, it would have triggered the statutory duty to sit within 21 days. If the committee had not then sat, would there have been any impediment as a last resort to the registrar seeking a remedy from the court? I submit, though these are highly undesirable things for any registrar to have to do, had she been given that advice, had she submitted a report, it would have triggered the statutory duty and would have been judicially enforceable. It was, after all, created under statute, this system, not within the standing orders of the House, as some legislatures have done. Now, I don't seek in any way to criticise the registrar, and that is not the intention of this.
Because the registrar from
Has been trying to chase.
2008 did at least two things. Firstly, she chased members. She gave them notice when the declarations were due. She then chased them, one witness said, very assiduously. But she did, as it were, relentlessly. We've seen some of the correspondence.
I've seen some of the correspondence too.
And one of the honourable members said that he didn't open the envelopes that she sent him. So the first thing she did was to press for the declarations. And the second thing she did was to press for some action in relation to enforcement. That is the setting up of a standing committee.
Which was done in 2017.
Which was done in 2016. It took eight years. And it was populated, without mentioning names, both in the last House and this, with several members who
were in default.
But were in default and on the face of it treated the obligation with, as you put it, disdain. They were years in default, and not all of them, I don't think, appreciated the obvious conflict of interest. Some of them did.
Well, my point is that had the report been served on the chairman, the committee would have had to sit, and these issues like conflicts of interest.
Why did the committee have to sit?
Well, because the section requires it.
Well, the Act requires lots of things which have never happened.
No, but forgive me with respect, if the committee had not sat when it had a duty to sit within 21 days, it would have been judicially enforceable. There would have been nothing to stop a court issuing an order to compel the committee to sit in compliance with its statutory duty.
So that was a burden that you would have put on the registrar.
Well, what I have said is that when the governor was asked, or when the governor asked for information in November 2020, the better thing to do would have been to have said, take the advice of the Attorney General.
Who, of course, is a member of the House.
Well, but the attorney has to be independent across all kinds of difficult situations.
I understand that.
And I have no doubt this attorney would have been, she would have given her view candidly on what she thought the law was. And I have little doubt that she would have said, if you serve your report, there's a statutory duty on the committee to sit. And if it doesn't sit, it would be judicially enforceable on your action, on your suit. Now, what I submit was, that's what she should have been told to do. She's charged with a constitutional office. Instead of resorting to the governor and giving him information in breach of her obligation under Section 13, at his request, so it doesn't appear the governor understood the obligations of the Act, because there is little doubt that Section 13 and the oath of confidentiality that the registrar took was breached by the conveyance of information connected with the register to the governor. And the governor should not have made that request. What he should have done, I submit, is advise her to seek legal advice.
You say there's no doubt. We don't know, because that's not a matter which has been put to the governor yet.
Well, let's wait and see. It's my submission that Section 13 is uncompromising, unambiguous in its terms. And no governor should have requested information from the registrar, which was manifestly, or if we don't accept for the moment manifestly, which was at least arguably in breach of her statutory obligations. If the members have breached their statutory obligations, which they have, then the governor has breached his obligations, the obligations as well, or at least encouraged or requested the registrar to do so. And that is at the heart of the problem that exists in this territory. Well, upon which I will submit to you, I hope, later.
Yeah, but it is a matter for later. But there is a difference, and this is not a comment on the propriety of anybody's action. But in those circumstances, from what you've said, the governor was concerned about the system not working, and the members of the House of Assembly were those not operating the system, because they undoubtedly did not operate.
If you mean there may have been benign reason for breaking the law, I've never understood that to be a proper basis.
I'm sorry, I didn't say it was, because these are matters for another day.
Quite.
But what I'm saying is that here we had a system whereby the members of the House of Assembly were obliged to make declarations of interests under the Constitution and under Section 3. They failed to do so. Some failed to do so relentlessly and despite the registrar's best efforts over years. And
what I'm saying to you, Commissioner,
the House of Assembly members did not create a select committee, which was the first
until
2016, which was the first step of enforcement. When they had created it, it has met once. It has not approved any format for the register, so there's no register. We have no evidence from the registrar on this, but you can certainly understand her giving up.
Well, I don't think any constitutional officer has the right to give up.
No,
you can resign if you don't think you're having proper cooperation.
No, she didn't give up in the sense that she kept sending her reminders. But
a proper course after 16 was to have taken legal advice and to have triggered the statutory duty to sit.
I understand that submission.
And that is what any attorney would or should have advised, and not to go to the governor to seek some form of relief, which is not statutorily available from the governor.
No, as I said, but that is for another day.
It is for another day. But when one is looking at the nature of the default here, you cannot ignore the fact that legislatures around the world have had similar difficulties. And you have to ask yourself, why? Why have even countries of 67 million had difficulties wrestling with this problem? With all of the resources and training, it was only Nolan that introduced a sensible and a system to which the House of Commons was obedient in 1995. And the reason is that it requires a serious culture adjustment of thinking for any legislator. And this assembly was given no support, no training, no assistance with adapting and adjusting to that new need. So long as the act was passed, the box was ticked. No doubt a message flew back that this legislation had been passed, and therefore one tick was added on somebody's checklist. But what should have been done, and what we had a duty to do as the United Kingdom, was offer practical and real support. Not simply stand back and say the legislation is done. We should have had over here Commonwealth Parliamentary Association officials, deputations, assistants, practical program of support to bring about a mindset within this assembly of compliance and the understanding of the need for compliance. Good governance too often, sir, is simply a cliche that trips off the mouth. It requires tough, difficult mindset adjustments. And this assembly and this territory and this jurisdiction deserved better from the United Kingdom than simply to have the act enacted with nothing else around it. Because I've been able to find not a trace of support, practical experience given, wisdom communicated, despite the promises that are so often made. Now, I'm sorry to sound vehement, but I also feel, frankly, embarrassed. You, with Mr. Rawat, are doing your jobs. And you've had these members through this room, one by one, and each of them have had to accept, as is right they should, that they failed to comply, or most, I think, there may be one or two exceptions that I haven't followed. They failed to comply with their statutory obligations. And I reflect how many I certainly have occasionally fallen down on mine. And so have many of my colleagues in the House. And so when you, but this is relevant because the tone of the inquiry is important. Of course it's wrong. It's not it's a statutory obligation. But I don't think we, coming from the United Kingdom as we do, can necessarily afford a moralistic tone.
It's not a moralistic tone.
No.
It's looking at what the Register of Interests Act, which was passed by the Legislative Council here, said, and looking to see the extent to which any attempts have been made to enforce it. And the attempts have been
desultory, if best.
Yes, that's really to put it at its highest. You've explained in your submissions why you think that is the case.
In simple, the statutory scheme was badly designed, structurally flawed, because you need the incentive of at least of easy access to the members. So the members, I mean, it's normal in debate to refer to the Register of Interests, but you couldn't in this one unless you paid a fee. It needs to be a democratic tool. Secondly, I don't think the registrar was properly advised from 2016 onwards. Indeed, I think she was misguided. Not personally, I mean, not guided correctly. And finally, and most importantly of all, that culture change of which I've spoken, which is a difficult one, needed to have been supported by wraparound policies and serious investment and support.
Yes.
And it wasn't. But with respect, you can't just blame that on this territory and its jurisdiction. The United Kingdom has a duty. And when it comes to good governance and developing good governance, it must sit by the sides of these territories and lift it up. And I have looked, I've been carrying out as close an examination as I can to see what support has genuinely been given. And at the time I can find almost none. So I do submit that when you locate the seriousness of this, and nobody seeks to excuse the failure to abide by a statutory obligation, there are reasons for thinking that the scheme itself was simply not well designed and they needed better advice in doing it. It wasn't supported. Well, you shake your head. I find that hard to understand. But when a judge does it, it always troubles me because unless you actually speak your mind, which I know you will, I don't have a means of addressing it.
Well, no, but I just find that proposition difficult.
What? Which one?
That
the UK had a responsibility.
That they needed better advice.
Why not? Why not? Have you seen the Integrity in Public Life Act?
Here?
Yes.
I haven't studied it. We've got it. I
commend you see it. It's badly in need of advice. Of course they need advice and expertise. They have excellent advocates and lawyers. But these are matters which this jurisdiction is unfamiliar with. And we have a responsibility. That act was stillborn. I can't see any sign of anybody saying in 2006-07 that this act is unwise.
But are you saying that the BVI government is incapable of taking these steps on its own?
As any young, nascent country, they are entitled to expect from the administering power support, practical help, the supply of know-how and expertise in order to equip them with the capacity for good governance. Yes, I'm not saying they're incapable. They will make their way and make their mistakes like every nation does if it's free and independent. And it'll make many mistakes like the UK has made. But that doesn't mean they're incapable.
No, I didn't mean, no, that's probably not the right word. But what you say is that in respect of the measures now, you've referred to the Integrity in Public Life Bill, which has been referred to by a number of witnesses. But what you're saying is
there needs to be more support.
That, as it currently stands, would be inadequate.
I mean, as it currently stands, it clearly needs significant work. For example, it applies, as I understand it, to members of the House of Assembly. Those members are subjected to the code of conduct or the schedule of principles.
In the ministerial code.
Well, no, in the Act itself, there's a schedule of principles. One of them is to act politically impartially. It'll be the first time, in my understanding, that a member of the House of Assembly had to act politically impartially. So, yes, I'm saying that this territory ought to have the promise made in 2012 in the white paper of a long-term program of substantive support, which is what my colleague, Lord Hague, said at the time, to assist it to equip itself with capacity for these democratic institutions. Yes, just like nations, free and independent nations all around the world receive it. But this island has been left pretty much to itself, except when some trouble arises. And that's why you're here. Yes, I say that.
And that's helpful. A lot of those submissions are submissions that are going to have to be dealt with on another occasion. But
Yes.
I see that they bear.
They bear on this, they do.
Yes,
And
this is to do with governance.
And you can't, and not a single one of the ministers I represent would resile from the acceptance made to Mr. Rowett in his skillful examination, though the materials were there and spoke for themselves. You know, I know you will forgive me for saying that. I mean, the truth is that not a single one will resile from saying that they accept they were in breach of the Act. Now, whether it's two or one.
And they accept through you that the scheme that's been set up is practically useless.
Yes. Was in 2006. I think what this government says and what the Premier says is that they will fix it. And they came into power on a program of attempting to fix. Now, this one is one connected with the House, of course, and the legislative with the House of Assembly. But I see no reason why that shouldn't be fixed by this government either.
But that is an issue which I'll have to deal with.
Which is?
The confidence in which one can have in the promises given by this government to fix various matters of governance, which I suspect, although I don't want to put words into your mouth, particularly in respect of a hearing that's probably some weeks away, it's going to be accepted that the current state of governance is less than optimal.
Yes, I think it probably will be. I mean, indeed, that's what the government came into with its program saying. I have to say that the latter observation troubles me because, confidence or not, this island, through its self-governing institutions, they're its only hope. They need to be strengthened, and they need to be assisted.
No, I understand that, but some of these matters of governance, in respect of which there is legislation in the air, or some of it further more than in the air. Some of it's
coming before the House now.
Some of it I think has now been passed. But it is the confidence one can have in this legislation being effective.
Well, that will require public service reform. Because
no, I understand, and I understand your submissions on that, or the minister's position statement in relation to that.
But Commissioner, I've shot my. What I wanted to supply is some context. May I say straight away, none of this is designed to suggest that the individual and personal responsibility of each member of the House, as any member of any legislature, for their own registrations is in any way diluted by what I've said.
No. And the context you've made submissions on, it is useful because it's going to be useful in future hearings. But there are two things. That is one of the submissions that you made with regard to the individual responsibility of the members, and most, not all of them, but most of them, frankly accepted that they were in breach and so on. But the second one is the minister's acceptance that the current scheme is
Inadequate.
yes, I mean yes, worse than inadequate.
Yes, it doesn't fulfill a useful purpose.
Yes.
Because a register like that ought in some way to be accessible to the public. That's, and I think the Premier said that he would be minded to introduce public accessibility of the register.
He did, from recollection, and I think most of them, not all, not all embraced it with the same enthusiasm. Some wanted to see restrictions on the openness of the register, if I can put it like that. But most of them accepted the principle.
I mean,
of having an open
let me
register.
be quite candid. There are real drawbacks to open registers. It becomes a political tool for every many frivolous complaints are made.
I understand that.
It is a profound invasion into a legislator's private life, because what happens is, as you can imagine, stories get written, minor infractions are written up to be morally shameful or even impute dishonesty. I accept the need for a register. Of course I do. Every legislator must. But there are perfectly understandable reticence to invite that kind of onslaught that it can sometimes mean.
No, I understand that. I do understand that.
Well, sir, unless I can assist you further, I hope that what I've said, I mean to have left with you on the question of the construction of the statute, only at least the possible interpretation that I've adopted. Of course, if you prefer, and you may well, and I can understand why. I mean, the language, I agree, it suggests an obligation arising on the day.
But in the context of what the Commission of Inquiry is doing, it may not matter.
Well, that's my submission.
No,
what you're faced with is manifestly a pattern from the very inception through successive governments, cross-party. This is not confined to one political side or another.
It's not a.
This has no party political point. You're faced with a situation where, for some reason, there was a falling down on statutory obligations across the board. I have ventured some reasons why that might have been. Why do some statutory schemes attract high compliance? Why do others attract low compliance? Sometimes it's the design of the scheme, sometimes it's the education and training behind it, and sometimes it's because things weren't done at the time that could have increased the compliance.
And here we've probably got a full house of those matters.
Yes, those are my submissions.
Thank you very much. Mr. Hunt.
Yes, thank you,
Yes.
Commissioner. I would like to draw a distinction between the outright failure to comply and tardiness in complying. Now, here, my client, Dr. Pickering, declared his financial interest for every year since the Register of Interest Act came into operation. But he concedes that he did not do so in accordance with the provisions of the Act. The reason why he did not strictly comply with the provisions of the Act are now, for the greater part, academic, because he is no longer a member of the House. However, the fact that the requisite declarations have all been filed is a strong mitigating factor in his favor, and I raise it on his behalf. Now, as far as sections 66 and 67 of the Constitution are concerned, the evidence before this commission is that Dr. Pickering was above reproach, because he was very careful in observing those sections, and in such a way that he did not even have to seek exemption from the House of Assembly. And for this, he is to be highly commended. And it fortifies my submission that the untimely filing of the declarations under the Register of Provisions Act is an aberration, or should be treated as an aberration. Now, I'm going to mention something here which will take us back a little way back, maybe to 1979. And what is not generally known is that the legislature, the Legislative Council that was elected in 1979 was an illegal body. It was elected under an ordinance that was not brought into operation. And that was the duty of the governor of the day. He was in charge of elections, and it was his function to see that the elections ordinance was brought into force before the elections were held. The governor ended his tour of duty and left the territory with a new governor and a new attorney general to fix the problem. The new attorney general gave the governor certain legal advice, which the governor followed. The result was that the legislature was allowed to run its full course, and the new council, when it was validly elected, unanimously enacted a statute validating its predecessor. That was the advice given to the governor of the day. The statute is called the 9th Legislative Council Validation Act, 1984. And I mention it to show that as serious a constitutional problem as that, the territory was able to correct it without any problem, because the territory is a far more mature territory than people would like to think. And I think it is far more mature perhaps than some well-known countries on this side of the Atlantic, because you wouldn't see anyone with a battering ram or a machine gun invading the legislature here. And I mention it because all of these problems that we see pale into insignificance with what happened in 1979. And I'm sure that the territory is mature enough to fix its problems. And those are my submissions.
Thank you, Mr. Hunter. Mr. Christian, do you want to add anything to what's already been said?
Thank you very much, Commissioner, for seeing me this afternoon. I just want to add a small submission to the hearing based on my bundle on page 166.
We haven't got your bundles now because I'm afraid we've moved on from your bundle.
Right.
But you refer to anything that you want to refer to.
You can refer to it afterwards because
yes.
it was submitted on Thursday. Commissioner, with your kind indulgence, on the 9th of December 2014, the Registrar of Interest, Victorine Romney Valak, wrote to me, and her letter says, "Dear sir, this acknowledges receipt of your declaration of interest for the period 8th December 2014. I am to thank you and express my sincere appreciation for your timely filing of your declarations. Please accept my best wishes for the Christmas and New Year." I just thought I wanted to submit that into the record as it was part of my bundle. And then secondly, I know a number of former members and current members have made some submissions with respect to recommendations. And if I can offer one, I suspect that based on what members have been faced with once they were elected and the time in which they have to file their declarations, that perhaps on the day that members are sworn in, their declarations are presented to them so that at that same day and at that same time, they'll be in a position to submit their declarations. That's, I perhaps think, one suggestion that can work with respect to timely submissions.
Yes, a practical suggestion. Yes.
Thank you, sir. That's the end of my submission.
Thank you very much, Mr. Christian. Mr. Rawat, I'm sorry you've come last, but I thought it would be better to hear from Sir Geoffrey and those representing the participants first.
Commissioner, I note the time, so I will try and keep my submission short, but no promises can be made. The first observation I would make is that the act on which you are now receiving submissions is a piece of BVI legislation. Second is that perhaps one needs to be careful to separate perhaps rhetoric from logic. I was struck by Malone friend Mr. Hunt's observation that in his submission that this is a mature democracy. And one contrasts that with Sir Geoffrey's submissions, which referred, for example, to the existence of a cultural issue. And at times, Sir Geoffrey spoke of a they. Perhaps it's helpful to remind you, Commissioner, of who the they are that you have heard from over the last few days. You heard from Dr. Hubert O'Neill, first ophthalmologist on the island. You heard from Dr. Kedrick Pickering, who was also a surgeon. You heard from Dr. Orlando Smith. You've heard just now from Mr. Christian, who was able to tell you what role he played. You heard from Miss Flack Charles, who gave you her experience as a community worker and in tourism. Others who spoke to you were educators. Cherie B. De Castro began as an educator. Vincent Wheatley, you'll remember, when he first gave evidence, spoke about his start as an educator. Dr. Natalia Wheatley, as he explained, has a PhD. Julian Fraser, an architect by training. There is, if one looks, and I accept Sir Geoffrey's point that what we are looking at is a system that spans years. It's the operation of a system that has operated in a way that is flawed, irrespective of political party, irrespective of the experience of the legislators. But what I would say is we must be cautious about belittling the experience that all those who gave evidence to you brought into politics. They are educated men and women who were, in my submission, well capable of understanding the obligations they place upon them. The take-home observation I took from Sir Geoffrey's submission is that you will have to, at some stage in this process, separate the present from the future in relation to the Register of Interests. The last few days have been very much concerned with the present. And whilst you've indicated that the future is something that falls to be considered at a later date, there are some submissions I will make about it. But if I take the first submission that of Sir Geoffrey, that the Act itself was fundamentally flawed. It was doomed to failure from the very beginning. That is my submission. In my submission, it is a point that one needs to approach with some caution. I say that because you heard from Julian Fraser and this afternoon from Ronnie Skelton, who, along with others from whom you've heard, were part of the 2006 cohort in the House of Assembly that debated this, what was then a bill. And Ronnie Skelton himself gave evidence to you about the thought processes that it went through, the questions that were raised by honourable members at the time. You have the timeline of this. And in my submission, what has to be examined is how the Act was implemented as from 2008. It mandated, in my submission, a mechanism. It might not have been the best mechanism. It might be a mechanism that others looking back now, and many of the witnesses have been candid enough to say that as they looked at their forms in evidence, and I think Mr. Christian was one of them, that there were areas of improvement. And they gave that evidence openly to you. But what the system envisaged, flawed or not, It was the system that the House of Assembly chose to implement. It was a system that established a registrar who would have the task of checking the accuracy of entries, but it would also have, it was not left to the registrar alone. What was important as part of the process was a standing select committee. The standing select committee isn't just there to receive reports from the registrar as and when she sends them, and or to deal with other breaches under the Act, for example, the failure to comply with a notice from the registrar under Section 5.4. But it also, right from the beginning, has a standalone duty in my submission, and that arises under Section 4, because it is the job of the standing committee to establish and approve the format of the register. So there are a number in my submission of clear obligations that arise as one goes through the process, which are not in themselves incapable of cogent application. The first is the obligation to make your declaration on time, and then on every subsequent anniversary of the due date, and it's the date on which you're sworn into office. The second is of the registrar to check declarations. And you heard evidence, for example, this morning from Mrs. Moses-Scatliffe, that there were occasions when the registrar would return a declaration and ask the person making it to resubmit. The Honourable Andrew Foy was another example. When he submitted, I think, a total of 4 in 1 year altogether, they were all returned. But it also importantly provides for a standing committee to approve the register and then to deal with the reports that are submitted to it. And then ultimately, it provides for sanctions that the House of Assembly can impose on a defaulting member. It was there. It cannot be simply brushed away that what the evidence has shown is that there was not just a culture of compliance, but arguably a culture of indifference. Indifference to the importance of the obligation created by the Constitution, indifference to the obligation created by the Act itself, and indifference to the importance of the Standing Select Committee as part of the process. Now, I pause there because, in fairness, I would remind you of the evidence that you've received today of Myron Walwyn about, and indeed of Mrs. Moses-Scatliffe, about the difficulties in establishing changes to standing orders. It appears that on Mrs. Moses-Scatliffe's evidence that it literally took years for standing orders to be amended such that they could then be, the Standing Select Committee could be created. The second point that Sir Geoffrey makes is the role of the registrar. No one has made a criticism of the registrar, and I don't understand Sir Geoffrey's submission to imply any personal criticism or indeed professional criticism of the manner in which she went about her task. But the suggestion that the most recent and past governor persuaded her to a course that was contrary to the Act needs to be put into a wider context, because what is right is that the registrar went not only to the past governors, and not just the most recent governors, but their predecessors. And in fact, likely it seems to every single governor since 2008. The registrar also went to the chair of the Standing Orders Committee, Ronnie Skelton. You'll remember the letter of the 19th of February 2014 that he spoke to today. She went to the Premier. She went to the Speaker. And perhaps most importantly, she went to the entire House, because as Myron Walwyn explained, the Standing Finance Committee is a committee of the entire House. The evidence that you have, admittedly from press reports, is that whenever every year that the registrar would appear in front of the Standing Committee, Finance Committee, she would remind them as a group that people were not complying with the register. She would remind them that the Standing Select Committee had not been established. She would remind them that the register was, in her words, a blank book. So my submission, all of that meant that the members of the House of Assembly themselves were on notice of the obligation. The members of the House of Assembly themselves were on notice that the system was not complying. And the members of the House of Assembly, past and present, were on notice that the first step in beginning to make the system work was filing your declarations on time. The last point that Sir Geoffrey makes was the need for support. And he speaks to the absence of support as a flaw that meant that the Act would never work, but also has spoken about support in the future. If I turn to the first of those, what I would ask you, Commissioner, to bear in mind is this. Firstly, that a number of former members and honourable members have given evidence, and in fact given evidence in positive terms about the fact that the registrar would, in advance of the due date, send them a notice with the declaration form to be completed. And there is evidence that that was done even before the first day on which a member was sworn. And the best example of that is the Honourable Neville Smith. He came into office, elected for the first time in 2019, and he submitted his declaration on the 12th of March 2019. The second element of this is that you have, the registrar was available to give advice, more than one. And I hope I'm not misquoting his evidence, but Mr. Christian was one of those who said that he could go to the registrar for advice. And she was available. And in her correspondence, she explains that she is available to assist with any difficulties in completing the form. The third point, and I don't understand Sir Geoffrey's submission to detract from this, is that one cannot dilute the importance of a statutory obligation, and more importantly, the importance of an obligation created by the Constitution, not least because it is the trigger to making the Act operate properly. The fourth point, and I think, and again, this is a point that Sir Geoffrey has made, and that is, and it takes from the Attorney General's own evidence, and that is that the Act does not create a defence of reasonable excuse. What I would also draw your attention to, Commissioner, is this, that with a number of witnesses, I canvassed their obligations under the Constitution to make a declaration of their interests as an election candidate. That is a constitutional obligation, just as the Section 112 obligation is. And no witness gave you evidence that they misunderstood the nature of that obligation, that they had any difficulty complying with it. The final point I'd make in terms of the support that exists in the degree of knowledge, and it would be, I suppose, the degree of knowledge within the overall House of Assembly, is to return to the Standing Finance Committee, because that is the registrar speaking to the House of Assembly in total. If one looks then towards the other limb of Sir Geoffrey's support submission, that is, and he's right to say this, and you are right to say this, a matter for another day. but you will have noticed his impassioned cry that here support is needed, and support is needed going forward from the UK. And it may be something that needs to be considered, but you may wish to take note of the point that Sir Geoffrey made about the Nolan Committee of 1995 recommending an independent parliamentary commissioner. That I don't think is something I need to go into, but it is obviously something that we may need to revisit in due course. With no disrespect to Malone from Mr. Hunt, his points were specific to his client, and I don't think I need to address that. And similarly, with no disrespect to Mr. Christian, his point is one that relates to his own evidence, but he has quite properly read that piece of evidence into the record. And if I didn't do it at the time, can I apologise to him for not having done so?
Thank you, sir.
Other than that, I don't think there's anything more I can usefully add.
No, thank you, Mr. Rowett. Well, thank you all very much. Some of the issues which have been discussed today will clearly be raised later on in the inquiry hearings, but thank you for all of your submissions in relation to the breaches and criticisms that may be made as a result of the evidence I've heard over the last week in relation to the Register of Interests, and I'm very obliged for those. Is there anything else?
Nothing from me.
I think 10 o'clock tomorrow.
With the Attorney General, I think.
Yes.
Tomorrow, yes. Yes, thank you all very much.